Adjournments, page wise, page 1, serial number 1 and 2. Serial number 1 and
Serial number 1. Lordship, 3-time notice has been taken. I may permitted to file a application to take paper publication, my Lordship. Regarding respondent number 4.
correct. How much time you need?
Sorry, my Lordship.
How much time you need?
1 week, my Lordship.
Because 1 week time is 22 minutes.
Great.
Page 2, serial number 3 to 7. Page 3, serial number 8 to 10. Page 7, serial number 11 to 13. Page 8, serial number 14 to 17. Page 9, serial number 18 and 19. Page 13, serial number 20. Page 14, serial number 21.
Serial number 21, my lord, for appeal and pray for 1 week time. Senior is inconvenience. 21.
Any interim order is there? No protection
Connect
order.
matter ದಲ್ಲಿ application ಹಾಕಿದ್ದಾರೆ ನೋಡಿದ್ರೆ ಆಯ್ತು.
Memo for acceptance of paper publication. We'll decide that next application, then we'll adjourn it. You only have filed paper publication you have filed. We'll accept that and then adjourn.
Be here.
Page 15, serial number 23 to 26. Page 16,
Page
number 27 to 30.
Serial number 24, admissional.
Yes, which one?
Admission, serial number 24, madam.
24.
Appellant has died, sole appellant has died. I had to take steps against the, to bring the,
File a memo if he is dead.
yes, madam.
Then memo file ಮಾಡಿ ಬರೀ orally ಹೇಳಿದ್ರೆ.
I'll file a memo, my lord. I'll have to take steps against the. bring the-
Correct.
I'll file a
You
memo.
have to report the death. You have any death certificate or anything?
No, I have to collect the death certificate and to make the report.
24. Reference counsel submit that. As per his information, appellant is dead. 2 weeks time is granted to take necessary steps. Page 16, serial number 27 to 30.
Serial number 27, my lord. So I'm appearing for the respondent in this case. So just I need a 1 week time to make a presentation. Next week, kindly be any date. I appear for petition appellant. Next week, kindly be.
Yes, correct. Last time.
When
actually, my-
That's what that. I come today morning with out of station. Apart from that, I'm a little bit tired up with it 2 days. So I couldn't see that. So next week, kindly be given.
Yes, counsel. Respondents counsel.
Respondent for 1, 2, and 7.
There are 7.
I'm appearing for 1, 2, and 7. I'm Srikanth.
Venkat Subbrao, C7, CN Srivatsa.
Srivatsa, my colleagues, Srivatsa and Srikanth, my name should be there instead of the Srivatsa name is come. Srivatsa is not coming to the High Court. He'll be in the civil court. That's why my name should be there and mentioned.
What is your name?
Srikanth.
But ಅವ್ರದ್ದು ವಕಾಲತ್ ಇದೆಯಾ?
ಇಬ್ರು ಜಾಯಿನ್ seal on the office, seal joint seal. So he's not coming. That's my name is to be mentioned that sheet.
ಅರ್ಧ ಒಂದ್ ಹೆಸರು ತೋರಿಸ್ತಾರೆ ಈಗ.
I'm not getting cost list also. I have not received cost list also. I had come through somebody else there. That's all.
ಯಾರು?
Srikanth.
ಬರೀ ಶ್ರೀಕಾಂತ ಮತ್ತಿಂತ ಅಂತಂದ್ರೆ.
Yes, Srikanth.
PA Srikanth, the counsel submits that he is appearing for respondent number 1, 2,
Or 7.
and his name shall be shown in. the
Next week
notice.
can be any date. Wednesday, Thursday, any day.
Found correct? Do the needful. Okay. As requested. By
Carried, my lord.
Srikanth as a final chance, list round 27.
Much.
3-7.
Page 17,
3-7.
37. 37.
Much.
Page 17, serial number 31 to 33. Page 18, serial number 34 to 38.
Serial number 36, I'm for appellant.
Serial number 46.
36, sir.
36 ಹೋಗೈತಲ್ಲ. ಎಸ್ ನೀವು ಬರೋದೇ ಇಲ್ವಲ್ಲ ಇವ್ರೆ, ನಿನ್ನೆನೂ ಇರ್ಲಿಲ್ಲ, ನಿನ್ನೆ ಇರ್ಲಿಲ್ಲಲ್ಲ ಇವ್ರು ಕೇಸ್ ಕರೆದಾಗ.
ಕೇಸ್ ಕರೆದಾಗ ಇರ್ಲಿಲ್ಲ ಸರ್, ವೇಟ್ ಮಾಡ್ತಿದ್ದೆ, ಬೇರೆ ನಡೀತಾ ಇತ್ತು.
ಕೇಸ್ ರೀಚ್ ಆಗೋವರೆಗೂ ನಾವು ವೇಟ್ ಮಾಡ್ತಿದ್ದೆ ಅಂತ ಆಮೇಲೆ ಎದ್ದೋಗ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೇಗೆ? 2017 ಮ್ಯಾಟರ್ ದಟ್ ಇಸ್. ಇದು ನಿನ್ನೆದೇ ಇವತ್ತಿಗೆ ಲಿಸ್ಟ್ ಆಗಿದ್ದ. ಎಸ್ಟರ್ಡೇ ಹಿ ವಾಸ್ ರೆಡಿ, ಹಿ ವಾಸ್ ಇನ್ಸಿಸ್ಟಿಂಗ್ ಅಲ್ವಾ? ನಿನ್ನೆ ಅವ್ರಿಲ್ಲ, ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡೋದಿಲ್ಲ. ಎಸ್, ನಾಟ್ adjourn it in their absence. Page 19, serial number 39 to 41.
Page 20, cell number 42 and 43. Page 21, cell number 44 to 49.
2019 ಏನೋ ಕೊಡ್ಬೋದು.
Page 22, cell number 50 and 51.
I appear as serial number 50, my lord. I could not serve the copy and the amicus curiae. 2 weeks time I have granted, I will serve the copy, my lord, appeal number.
Family court ಆ? Okay.
2 weeks.
2 weeks ಆ? ಆಯ್ತು.
Yes, please,
2021 ಏನಾದ್ರು ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಇದೆಯಾ?
ಇಲ್ಲ, no interim order.
Okay.
Ex parte I was granted by the trial court.
At least
I
up to
dismiss-
2 weeks.
Please, oblige.
For order, cell number 1 adjourned, cell number 2, Sangamesh G. Patil, Prashant BR for R1 and R2.
I am for the appellant, my lord. I served the copy to the Prashant, my lord. Respondent 1 and 2 advocate.
I have received the copy, my lord.
I see.
I have received the copy. I want some time to file my objections, my lord.
For
Already.
So it's that he has received the
It's
copy.
covered by judgment, my lord.
Office objections stood complied. ಏನದು objections to what?
Objections to IN.
1926 days delay, sir.
Please, madam.
At request 2 weeks time is granted to file counter. ಇದು 2016 ಹಾಕ್ಬಿಡಿ.
ನಮ್ಗೆ ಕೊಟ್ಟಿದ್ದೆ ಮೊನ್ನೆ.
Correct.
Ah,
How much
please.
time you need?
I will,
10 days ಸಾಕಾ?
10 days, 2 weeks.
2 weeks
Okay.
time.
It's covered by judgment, my lord.
IA
Please
1
take it to court, sir.
Please.
Much.
Cell number 3, Shivarudrappa Shetkar, Gururaj Joshi for R1
Taken
and R2.
steps, not 4 occasions. Not, the parties also not have written letters, not, there is no response. Not, so I shall not, as a final chance, not, I shall file an application not seeking for substituted service.
2 and 4 ಇಬ್ಬರಿಗೆ ಮಾತ್ರ.
2 and 4, they are the directors, not, and the company.
So you are also, you are guarantor, huh?
I am one of the directors.
And as
Director's wife not, director has died, his wife not has filed the appeal.
R.C. Chandrasekhar ಅಂತ ಇದೆ.
Chandrasekhar not, Dr. R.C.
By his LR.
Deceased by his LR, not Smilathil Chandrasekhar.
She herself is 85 years, sir.
Yes, not.
Appeal memo
ಅದಕ್ಕೆ there is no response, literally, I have written letters also. I shall not send a registered post notes, I have sent till now by courier. ಅದು ಏನಾಗುತ್ತೆ ಅಂತ ರೆಸ್ಪಾನ್ಸ್, if they are not interested to contest notes, I shall not necessary application actually.
Request final notice ಕೊಡ್ತಾರೆ. ಸ್ಪೀಡ್ ಪೋಸ್ಟ್ ಸ್ಟಡಿ ಕಳಿಸಿ ಒಂದ್ ವಾರ ಬರುತ್ತೆ.
ಅದಕ್ಕೆ ಒಂದ್ ವಾರ ಬಿಟ್ಟು ಹಾಕೊಂಡ್ರೆ ಅಥವಾ 2 ವಾರ ಬಿಟ್ಟು ಹಾಕೊಂಡ್ರೆ they stay at not ತಮಿಳ್ನಾಡು.
Telling which appeal against R2 and 4 shall stand dismissed.
Ma-
10 days ಕೊಡ್ತಾ ಇದೀವಿ.
ಆಯ್ತು,
ಅಷ್ಟಕ್ಕೆ ಬಂದ್ರೆ ನೀವೇ ಮೂವ್ ಮಾಡಿ ಮೆಮೊ ಹಾಕಿ.
ಆಯ್ತು.
ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ.
Cell number 4, Chandrasekhar,
Memo of return filed by advocate for appellant.
Please, madam. I'm filed the memo for retirement.
Why? ಏನ್ acknowledgement ಹಾಕಿದಿರಾ? postal acknowledgement.
ಅವರೇ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ. ನಮ್ಮ
ನಾವ್ ತಗೊಳ್ಳೋದಿಲ್ಲ. We should know. ನಮ್
ಅದ್ರಲ್ಲಿ ಪಾರ್ಟಿಲಿ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ, ತಗೊಂಡು
ಪಾರ್ಟಿ. ನಾವ್ ಇದನ್ನ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋದಿಲ್ಲ. ನೋಟಿಸ್ ಕೊಟ್ಟು ರಿಟೈರ್ ಆಗಬೇಕು, ಇಲ್ಲಾಂದ್ರೆ the memo of retirement is not accompanied by notice or postal acknowledgement. As a having served the notice of retirement, it would unsafe to rely on the alleged signature of the appellant on the memo. Therefore, memo of retirement is rejected. ಏನ್ ಹಾಕ್ಬೇಕು ಇದ್ರಲ್ಲಿ ಮುಂದೆ? ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್. ರಿಟೈರ್ ಆಗೋಗಿದ್ರೆ
ಇಲ್ಲ, ಅವ್ರಿಗೆ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿತ್ತು, ಬರ್ತಾ ಇಲ್ಲ ಸೀನಿಯರ್, ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇನೆ ರಿಟೈರ್ಮೆಂಟ್.
ಸೀನಿಯರ್ ಒಂದು ನೋಟಿಸ್ ಸಿಗ್ನೇಚರ್ ಹಾಕ್ಸಿ ನೋಟಿಸ್ ಕೊಡೋದಕ್ಕೆ ಏನಾಗುತ್ತೆ? ರಿಟೈರ್ಮೆಂಟ್.
ಆಯ್ತಾಯ್ತು,
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬರೋಕು.
ಹೌದೌದು, ಫೈನಲ್.
ಪ್ಲೀಸ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಒಂದು ವಾರ ಬಿಟ್ಟ.
9/7.
9/7.
Cell number 5, Chandranath Arigake.
How can you rely on the signature? ಬರ್ತಾರೆ ಇಲ್ಲ ಅಂತ.
Petition came to be dismissed, an ex parte order. My lord, kindly see, there is a,
Non-filing of
yes,
application for substituted.
howdo, 8/2/2024 order may kindly be
8/2/2024.
24 order. This honorable court,
8/2/2024. Matter is passed over.
yes, it reads further, third paragraph, counsel for the appellant submits that he has filed a memo for having taken substituted service of notice, office to verify and put up. My lord, earlier on,
Verifying no fresh memo of
yes,
application is filed for substituted service. However, on further verifying pursuant to the order dated 11/2/2020, advocate for appellant had filed a memo on 3/3/2020 along with receipt for substituted service of notice to the respondent through email courier.
my lord, this person soon after the marriage has left the appellant and gone to Saudi Arabia. After that, he is not, his whereabouts are not known.
Correct?
Therefore, an application was filed before this honorable court to serve him through the
Which
email email.
date ಯಾವ್ದದು?
That was on 11/2/2020, madam.
2020.
That application was permitted.
Once, we'll see.
Yes, ma'am.
11/2/2020.
20, madam.
Mhm. 24 2 weeks ಅಲ್ಲ?
Electronic mail as well as by courier service.
Yes, that was
Just
complied with.
the amendment to order 525 CPC.
That,
Permitted to so and file an acknowledgement for the same.
yes,
ಈ ಎರಡು courier ತಗೊಂಡಿದ್ದೀರಾ?
ಹೌದು. ಇಮೇಲ್ ಮತ್ತು ಕೊರಿಯರ್ ಆಮೇಲೆ 11/2ಗೆ ಆದ್ಮೇಲೆ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ
The
3/3/2
appellant has filed a memo for having sent notice to the respondent by way of courier service, producing the copy of the receipt courier. The copy of notice of the email address of the respondent is so and so. To the above address, a copy of memo was sent as an attachment on 3/3/2020. A copy of the printout of the mail is filed here. Same may be taken on record. The acknowledgement has not been placed on the our thereafter 27/1/2023.
My lord, professional courier it was sent, my lord.
Not been placed on record. Lawyer counsel for the appellant says that praise for and is granted 1 week's time to enable him to move an application. Like we have to seek, if at all you want to insist on that service, there is an order on 27/1/2023 directing you to further take notice.
My lord, yes, my lord, there is some mistake.
ಯಾವ್ದು
Allah, this lady is totally unable to comply with this, my lord, because her husband left, she does not know, she does not even a penny to live on. And with the great difficulty, this was done. And my lord, on the professional courier, this
ಅವರು ಡೆಲಿವರ್ ಆಗಿದೆ ಅಂತ ಒಂದು ಏನಾದ್ರು ಪ್ರೂಫ್ ಹಾಕ್ಬೇಕಲ್ಲ ಇವರಲ್ಲಿ.
kindly see the memo dated 3/3/2020, my lord. 3/3/2020. On that, on 27/1/2023, that memo was not put up.
By left ಅಂತ ಇದೆಯಲ್ಲ. High Court Legal Services Committee.
20 memo was filed, my lord.
But the 2020 in the 4 years, why did you not mention that?
My lord, after that,
2023, that was not accepted. Again, notice was ordered.
my lord, may I submit, my lord?
Correct.
On-
Mr.
on
Harika,
3/3
either you have to seek recalling of that order or you have to take sub-service.
That is, my lord, 8/2/2024, this
ಆಯ್ತು ನೋಡಿದ್ವಿ ನಾವು, but there is an order of another bench. Now,
no, office to verify and put up.
ವೆರಿಫೈ ಪುಟಪ್ ಮಾಡಿದ್ಮೇಲೆ 27/1/2023 ನಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ. ಅದು ನಿಮ್ ಕೊಲಿಗ್ ನೋಡಿದಾರಾ?
Yes, ma'am.
Later, Nandish CPA Lawyer Counsel
Yes,
for the appellant in compliance of the order dated 11/2/2022. Even though the appellant has sent the notice through email as well as through courier service, however, the acknowledgement has not been placed on record. Lord counsel for the appellant prays for and is granted 1 week's time to enable him to move the application seeking substituted
Yes,
service.
my lord, on that,
Sufficient ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ.
on that day, this memo was not put up. Therefore, when the submission was made before the earlier bench, the earlier bench,
ಇದ್ರಲ್ಲಿ ಇಲ್ಲ. It is up to you. ಏನ್ ಮಾಡ್ತೀರಾ?
my lord, on 3-3, I shall make an application to recall that order and requesting the court to direct the office to put up the memo. 3-3-2020 memo has to be put up, my lord.
ಏನ್ whatever you want to do, you do it. We are granting you 10 days. Yes.
Still number 6, Venkatramana MK, PPF Associates.
I issued a notice of retirement, my lord, it has been duly served.
Sorry, fire will.
I filed the memo to that effect on 19/6.
One.
Originally is here, my lord.
Call it, postal acknowledgement ಹಾಕಿದ್ರೆ ನಾವು ತಗೊಳ್ತೀವಿ.
ಹಾಕೇನಿ,
Wait
ಹಾಕೇನಿ.
for the appellant. Okay, this will take 26 minutes. ಇದೇನು ಒರಿಜಿನಲ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇನ್ ಕಾಪಿ ಹಾಕ್ತಾ ಇದ್ದೀರಾ? ಒರಿಜಿನಲ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದಲ್ಲ, ಇದು ಕಾಪಿ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು ಇಟ್ಸ್ ಓನ್ಲಿ ಕಾಪಿ. ಒರಿಜಿನಲ್ ಅಲ್ಲ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕು ಕಾಪಿ. ಏನ್ ಹೆಸರು ಅವ್ರಿಗೆ? ರಂಗನಾಥ ಶೆಟ್ಟಿ.
Raghunath Shetty.
Here, Raghunath.
Now counsel for the appellant has filed a memo of retirement along with a copy of notice and postal acknowledgement. In proof of service of notice on the appellant. Now counsel for the appellant also submits original ಹಾಕ್ಬೇಕಲ್ವಾ ನೀವು ಕೋರ್ಟ್ ಮುಂದೆ ಕಾಪಿ ಹಾಕೋದಲ್ಲ.
I'll during the course, I will file it.
Now counsel for the
No,
appellant-
why I am not producing, my lord?
Huh.
This appellant is almost court burden. Tomorrow I may go before the bar council also for that. Because
ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದ್ರೆ ನಿಮ್ಗೆ ಅನುಕೂಲ ಅಲ್ಲ. ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದ್ರೆ ಇನ್ನೂ ಸೇಫ್ ಆಗಿರುತ್ತೆ.
I will, right now I will.
ನಾವು ಅದನ್ನೇ ರೆಕಾರ್ಡ್ ಮೇಲೆ ತಗೊಂಡು
ಆಗು ಸ್ವಾಮಿ. ಅಲ್ಲ ಅದ್ರ ಜೊತೆ ನಾನು ಸ್ಟಿಚ್ ಮಾಡಿ ಈಗಲೇ ಕೊಡ್ತೇನೆ.
See, if we record,
Yes.
we also produce the original
Yes,
notice.
yes, I will produce now itself, my lord. I will enclose it there itself.
It's the office copy of the notice and our original postal receipt for the perusal of this court.
I may permit you to retire.
Appellant, though served with retirement notice is absent. Therefore, the appellant's, she came in appellant's function is permitted to retire. Idralli, what is the matter here?
Matter for husband has filed a divorce petition against the wife. It has been rejected by the trial court.
Please ಆಗಿ.
ಅದಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗಿ ರೆಸ್ಟೋರ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಅಲ್ಲಲ್ಲ.
ಡೈವರ್ಸ್ ಡಿಸ್ಮಿಸ್
ಡೈವರ್ಸ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಅವಳಿಗೆ ಈಗ ಬಹಳ ಪ್ರಾಯತಿ, ಈಗಿನ ಡೈವರ್ಸ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇರ್ಲಿಕ್ಕೆಲ್ಲ ಒಟ್ಟಿಗಿದ್ದಾರೆ ಅವ್ರು ಟೀಚರ್ ಅಂಡ್
ಅದರಿಂದ ನನಗೆ ತೊಂದರೆ ಬಂತಿದ್ದು.
When the petition was filed, he was 64, 2015 ಅಲ್ಲಿ. ಈಗ 10 years, 74 ಆಗಿರ್ತಾರೆ.
Anyhow, my learned friend is now, he is not
Yes, the
instructed
appellant
probably.
is not interested in prosecuting the matter, therefore appeal is dismissed for non-prosecution.
Yes, great. I'll file now itself.
You file it, it's safe for you also, no?
Yes. Still number 7, Ramachandran K, AGF for R2.
ಈಗ ನಾವೇ ಒಂದು
Two minute.
ಅವ್ರಿಗೆ ನಾಳೆ ಅವ್ರ ಸೇವೆ
Beneficiary.
ಮಾಡ್ಕೊಂಡ್ರೆ ಕಾಪಿ ಸಿಗುತ್ತೆ.
This appeal filed by the beneficiary, my lord.
My lord,
Driver enigma.
Steps
For,
by substituted service
please, my lord,
for R1.
please, I am filing the application for substitution.
ತಗೊಳ್ಳೋದಿಲ್ಲ, ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಕೊಡಿ. Why you do like this?
ನನ್ಗೆ ಯಾವ ಮಾಡ್ತೀನಿ sir. ಅಲ್ಲೇ ಫೈಲ್ ಮಾಡ್ತೀನಿ sir. ಇವತ್ತೇ ಫೈಲ್
At request 1 week time is granted to the late.
ಟುಡೇ only.
Still number 8, Vinay Kumar GS, BM Siddhappa for R2 and R3.
In this matter, my lords.
Okay, for respondent, my lord.
ಅವ್ರಿಗೆ ನೋಡಿ.
R2 and R3.
Let's,
Yes.
as far as the death of
Yes,
respondent
IA
number
150 of- ಗೊತ್ತಿಲ್ಲ.
date of death is till now, we are not knowing, my lords. That's why I have requested this honorable court. My lords, it may be kept open. Even I have taken a contention in the affidavit also, stating that it may be kept open.
Respondent number 1.
Respondent number 1, my lords.
How many respondents are there? Whether
My lords, I have brought this LRs on record, A to E.
the other response are no related to this.
No, my lords, no.
Respondent number 1. But how do we come to know that he is dead? ಏನಾದ್ರು ನೋಟಿಸ್
ಅದರಲ್ಲಿ ಇಲ್ಲ ಕೋರ್ಟ್ ನಲ್ಲೇನೆ ನೋಟಿಸ್ ಬಂದಿದೆ
Dead ಅಂತ.
ನೋಟಿಸ್ ಇಟ್ ಹಸ್ ಕಮ್ ಬ್ಯಾಕ್ as respondent number 1 is deceased and and they have also confirmed, my lords, when we went to their house, they have also confirmed the death of their father.
Correct.
They have given the details of the LRs, but whereas they have not given the date of death of the deceased, and we have requested them time and again.
Correct. Now notice of these applications is not ordered, no?
No, my lords.
Then I consider that
I have,
submit
my lords, as per the directions of this honorable court, I have taken notice on the respondent number 2 and 3. Only respondents,
ಈ LRs ಗೆ ಹೋಗ್ಬೇಕು.
LRs I have to take. Yes, my lords.
No, we record your submission because there is office objection. It is not known to you. And then open it. We keep that open and issue.
Yes, ma'am.
Date of death not forthcoming in the affidavit. Other side copy to be served. Serve ಮಾಡಿದ್ದಾರೆ.
ಸರ್ವ್ ಮಾಡಿದ
ಅದು
It is-
ಗೊತ್ತೇ ಇಲ್ಲ. There is
It has been served through RPAD, my lords.
ಬಂದಿಲ್ಲ
ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಎಲ್ಲಿ
No, that RPAD cover and
ಈ ಐಎ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ.
ಕೊಟ್ಟಿದೆ.
ಇಲ್ಲ ನಮ್ಮ ಆಫೀಸ್ ದವರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ. You have to show us the proof.
My lords, your lordship may kindly see, I have, my lords, sorry to say this, why
That
is,
is not
your lordship may kindly see the,
third.
your lordship may kindly see the acknowledgement of what I have received. There is a memo I have filed.
Games ಇದ್ದಪ್ಪ ಅಂದ್ರೆ ಹೇಳ್ರಿ.
I have served through RPAD.
ನಮಗ್ ಸರ್ವ್ ನಮಗ್ ಸರ್ವ್ ಆಗಿಲ್ಲ
Your lordship may kindly see, I have taken it to respondent number.
ಕಾಪಿ ಕೊಟ್ರೆ ಏನು ಹೋಗುತ್ತೆ ನಿಮ್ಗೆ?
ಅಲ್ಲ ಕೊಟ್ಟಿದೆ. I have given a memo ಹಾಕಿದ್ದೇನೆ.
Memo pass?
Memo along with the acknowledgement, original acknowledgement I have submitted before the court. Your lordship may kindly see that.
When did you submit the memo?
My lords, that has been served, my lords, it is there before this honorable court, my lords.
14th June. ಅದ memo. ಇಲ್ಲಿ ಯಾವ್ದು 14 ಜೂನ್ ನಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ದೆ ಜುಲೈ ನಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. 14 ಜೂನ್ ಹೆಂಗ್ ಸರ್ವ್ ಮಾಡಿರ್ತಾರೆ ಅವ್ರಿಗೆ?
My lords, very recently this month.
File on 24/7.
My
How
lord-
do you serve it one?
ನಮ್ಗೆ ಯಾವ್ದೇ ಕಾಪಿ ಬಂದಿಲ್ಲ
Your lordship may kindly see.
ಅಲ್ಲ ಇಷ್ಟೆಲ್ಲ ಎಳೆದಾಡೋ ಬದಲು ಅವ್ರಿಗೊಂದು ಕಾಪಿ
ಅಲ್ಲ ಕೊಟ್ಟಿದೆ. ತಾವು ದಯವು
14/6 ಇದೆ.
ಹೌದು.
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಸಬ್ಮಿಟ್ ಮಾಡಿರೋದೇ 14 ಜುಲೈ ನಲ್ಲಿ ಸಬ್ಮಿಟ್ ಮಾಡಿದಿರಾ? ಅಪ್ಲಿಕೇಶನ್
ನಮ್ಗೆ ಯಾವ್ದೇ ಅಪ್ಲಿಕೇಶನ್ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ಒಂದ್ ಸ್ವಲ್ಪ
ವೆರಿಫಿಕೇಶನ್
ತಡೀರಿ, ಹೇಳ್ತಾ ಕೊಟ್ಟಿದೆ ನಿಮ್ ಇದಕ್ಕೆ ಯಾಕೆ ಇದ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? unnecessarily why you are making submissions which are, ಏನ್ ಮಾಡೋಣ ಮತ್ತೆ ಕೇಳಿ ನಿಮ್ಮ BM ಸಿದ್ದಪ್ಪ, your lordship may kindly ಕೊಡಿ, ಅದನ್ನ ನಾನು ತೋರಿಸ್ತೇನೆ. I have
ಅಲ್ಲ ಎಲ್ಲಿದೆ?
RPAD acknowledgement I have submitted before this honorable court.
See,
ತರ್ಸಿ ಇದು original.
ಇದು 2024 ಅಂತ ಹೇಳ್ತಾ ಇಲ್ವಲ್ಲ ನೀವು? ನಾವು ಹೇಳಿದ್ವಿ
ಅಲ್ಲ,
20
your lordship may kindly peruse the objections what has been raised before this honorable court on the last occasion.
ಆಯ್ತು, ಒಂದು ನಿಮಿಷ ನೋಡಿ. We asked 2023 ಅಲ್ಲಿ 14/7 ಫೈಲ್ ಮಾಡಿದೀರಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ಬಟ್ ಯು ಸೇ ದಟ್ ಇಟ್ ಇಸ್ ಸರ್ವ್ಡ್ ಇನ್ ಜೂನ್ ಹೇಗೆ ಅಂತ ಕೇಳಿದ್ವಿ. ಆದ್ರೆ ಅದ್ರ ಮೇಲೆ 2024 ಅಂತ ತೋರಿಸ್ತಾ
Yes, my lords. Yes, there is an objection raised by this honorable court. As per the objections, I have taken steps to respondent number 2 and 3.
ಎಲ್ಲಿದೆ ಎಕ್ನಾಲೇಜ್ಮೆಂಟ್? ಎಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಪುಟಪ್ ಆಗಿಲ್ವಂತೆ.
ಇಲ್ಲ, register ಆಗಿದೆ.
ನಾನು
ಫೈಲ್ ಮಾಡಿರೋದಕ್ಕೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ ನನ್ನ ಹತ್ರ.
Leonard Counsel for the appellant submits that he has served the copies on the counsel for respond number
2 and 3.
counsel for respond number ಎಷ್ಟವರು 2 and 3 and has even ಅಲ್ಲ ಸಿದ್ದಪ್ಪ ಅಂತಾರೆ ಪ್ರಶಾಂತ್
ಸಿದ್ದಪ್ಪ BM ಸಿದ್ದಪ್ಪ ಅಂತಾನೆ.
and has even submitted the postal acknowledgement in the registry on 14/6/2024. He even shows the acknowledgement of this office. ರಿಜಿಸ್ಟ್ರಿ ಶಾಲ್ ಸರ್ವ್ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಇದ್ರಲ್ಲಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ರಿಜಿಸ್ಟ್ರಿ ಶಾಲ್ ವೆರಿಫೈ ಅಂಡ್ ಪುಟ್ ಅಪ್ ಅದು ಒಂದಾಯ್ತು. ಇನ್ನೊಂದು ಅದು
I may be permitted to take steps on heirs of the deceased respondent number 1, my lords.
so far as the date of death of respondent number 1, the consequent appellant submits that the heirs of the respondent number 1 are not divulging the date of death. Therefore, the said office objection is kept open. Issue notice of service ಆಯ್ತು ಅದೊಂದ್ ಎರಡೇ ಅಲ್ವಾ objection?
Date of death of respondent number may be, respondent number 1 may be kept open, my lords.
Second set of IA file ಮಾಡಿಲ್ವಾ?
That has been filed, my lords. All objections complied except this date of death. We are not knowing this death of the deceased.
Second set of IA one of kept in 23 ಕಮ್ಮಿದೆಯಲ್ಲ ನಿಮ್ಗೆ is fine. ನೋಡಿ ನಮ್ ರಿಜಿಸ್ಟರ್ ಮತ್ತೆ ಯಾಕೆ ಈ ರೀತಿ ಮಾಡ್ತಾರೆ ತೊಂದ್ರೆ ಕೊಡ್ತಾರೆ. Office objection kept open ಅಂತ ಹೇಳಿ kept open. Issue notice of IA number 1 to 3 of 2023 to the proposed loss of deceased respondent number 1 list on
15/7. Cell number 9, Narsimurthy GV, HCGP for R1, Prashant
Here for our
BR.
lordship. Memo along with the cost is paid, my lord.
memo along with cost of rupees 1,000. The memo paid regarding cost of this payment of 1,000 is taken on record. ಇದರಲ್ಲಿ IA 1 of 2018 section ಹಾಕಿದ್ರಲ್ಲ?
ಹಾಕಿದೀನಿ sir. I have filed.
218 days.
ಇಲ್ಲ, but copy not served, my lord. The objection copy is not served.
Objection
Sir,
copy serve ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ. ಬರೀ ಗೌರ್ಮೆಂಟ್ ಮಾತ್ರ ಮಾಡಿ.
Statement of objection on IA filed by advocate for R2 and 3. ಇನ್ನೊಂದು connected matter.
Yes, my lord. ಎರಡು correct.
Amended cost title filed. Copy serve ಮಾಡಿ date of.
ಮಾಡ್ತೀನಿ sir. ಇವತ್ತೇ ಮಾಡಿ.
Now consider the appellant submits that the copy of counter to IA 1 of 2018 filed by counsel for respondent number 2 and 3 is not served on him. Response counsel shall submit the same list. ಅದಕ್ಕೊಂದು ದಿವಸ ಮತ್ತೆ ಯಾಕೆ ಇಡಬೇಕು? Do you give him the copy now?
ಇವತ್ತೇ ಕೊಡ್ತೀನಿ ಫೋಟೋ ಮಾಡಿಸ್ಕೊ.
ಇವ್ರು ಯಾವ ಅಥಾರಿಟಿ ನಿಮ್ದು? ಕಾವೇರಿ
ಕಾವೇರಿ ನೀರಾವರಿ.
ನೀರ್ ನಿಮ್ಮ ನೀರಾವರಿ ಇದ್ರಲ್ಲಿ ನೀರ್ ಹೇಗ್ ಹೋಗುತ್ತೆ ನಾವು ಸುಮ್ಮನೆ ದಿನ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ತಾ ಇರ್ಬೇಕು. ಕೊಟ್ಟಿದ್ರೆ we could have disposed of that application. ಕಾಸ ಅವ್ರು ಮಾಡೋಣ ಮಧ್ಯಾಹ್ನ ನೋಡ್ಕೊಂಡು ಹೇಳ್ತೀರಾ?
ಬೇಡ, next week ಹಂಗಾಕಿ. Next week.
List in the next week. Yes.
Cell number 10, Unikrishnan M, N Shankar Narayan Bhatt for R1.
Where first?
ಅದು ಎಂತದಕ್ಕೆ?
Here for the appellant. In this we not.
ಅದು ಎಷ್ಟು bureaucratic ಇದನ್ನ ಮಾಡ್ತಿರ್ತಾರೆ. Yes, what is this?
My lord, if this pertains to 2 acquisitions, there are about
Oh, correct. In some matters, there were applications pending. Therefore, we listed these matters in IA yesterday. In the 10 point, ಇದ್ರೆಲ್ಲ common TCRs or different TCRs?
By different judgments, but same
no,
problem.
what happened, my lord, is that if my lord may to kindly see the third matter, MFA 3108/2019. That is a lead matter because that was disposed of by the Honorable Court. And the other matters, my lord, they have followed this particular order.
Correct, but they were separate awards, separate evidence was recorded.
Yes, parties are all separate.
Right.
Acquisition is common.
Correct. Notification may be common, but not a common evidence was recorded.
Common evidence was not recorded, but my lord,
So let the TCRs come in the other matters. There are some matters where IAs are pending. That's why we ordered yesterday.
IAS, my lord, is pertaining to withdrawal of amount. My lord said that it can be decided with
ಹಾಕಿ ಅದರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ.
ಅಲ್ಲ ಅದರಲ್ಲಿಂದ ಮೊದಲಲ್ಲಿ 10th ನಲ್ಲಿ
ಅಲ್ಲ ನಾನು ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
release ಇದೆ.
My lord, after this matter was disposed of 3108, the LIC matter, in other matters, evidence were not let in, but it was all followed.
Correct. ಏನು TCS ಕಾಲ್ ಫಾರ್ ಮಾಡೋದಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿದೆ.
ಆಯ್ತು
ಬರ್ಲಿ.
ಆಯ್ತು.
In the meantime, there are some applications. In one application, there is a direct condonation. ಇನ್ನೊಂದು ಎರಡರಲ್ಲಿ withdrawal of amount ಇದೆ.
Yes, my lord, 10.6.
Date ಒಟ್ಟಿಗೆ ಮಾಡೋಣ ಅಂತ, because they were not willing to give any bank guarantee or other securities. ಹೌದು. Yes, my lord, I'm making submission from the bar. Last week ತಮ್ಮ ಮುಂದೆನೇ ಆಯ್ತು.
ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ರಿ. In one matter, my lord, some excess amount was paid and I was
And he had to give back excess amount
bank
which he had.
guarantee.
Order sheet ಅಲ್ಲಿ ಇರೋದು ಅದರಲ್ಲೇ ಬಂದಿದೆ.
My application was to return the amount which I had paid in excess.
For
So
that,
he said he has no money. Then my lord said it can be disposed of and we
ಇಲ್ಲ no money ಅಂತ ಇಲ್ಲ. Order is passed to give bank guarantee. And I asked my party to do that and he's in the process of doing.
For respondent submits that respondent number 1 is ready to furnish security for difference amount
Yes.
and main matter itself may be heard.
there.
He shall furnish security for a sum of 10 lakhs in the registry for payment of difference amount if at all the appellant succeeds.
Yes.
A 1 of 2021 is disposed of accordingly.
Yes.
ಅದು dispose ಆಗಿದೆ.
ಆಗಿದೆ, dispose ಆಗಿದೆ.
Yes, ma'am.
ಅಲ್ಲ,
In-
there is
in-
ಮತ್ತೆ at least
In other matters, my lord, 10.6 and 10.8, my lord.
IA 1 of 2023.
Other for that purpose,
And
one,
IA 1 of 2021 is disposed of. What is IA 1 of 2022?
Asking him to return the money, my lord, excess. ಅದು ಫೈಲ್ ಮಾಡುವಾಗ this honorable court said let him give security.
IA 1 of 2023 is filed by respondents. This respondent prays that I'm pleased to release the amount in
Yeah.
deposit as ordered by this court on 23/2/2023. 23/2023 in order ಆಗಿತ್ತು. 23/2/2020. ಅದು separate order ಆಗಿತ್ತು. 23/2/2000. ಅವ್ರ prayer ಇರೋದು 23/2/2020. ಅಲ್ಲ 23/2 ಏನಿಲ್ಲಲ್ಲ. Let us see here what is.
I'm aware of what happened. Well, it may not be recorded, but I will make a honest submission. An application was filed.
They have filed an application.
ಅಲ್ಲ ಏನಾಯ್ತು ಅಂದ್ರೆ my submission is this, my lord.
To
This
release
on,
the
ಹೌದು. This on,
patience ಇರ್ಬೇಕು. 23/2023 ಅಂತ ಏನೋ ಒಂದು ಆರ್ಡರ್ ರೆಫರ್ ಮಾಡ್ತಾರೆ. ಎನಿ ಸಚ್ ಆರ್ಡರ್ ವಾಸ್ ಪಾಸ್ಡ್ ಅಂತ ನೋಡ್ತಾ ಇದೀವಿ. ನಿಮ್ಮ ಹತ್ರ ರೆಕಾರ್ಡ್ ಇದ್ರೆ ನೋಡಿ ಹೇಳಿ.
ನಾನು ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ, ಮೂರೇ ಆರ್ಡರ್ ಆಗಿರೋದು. ಫಸ್ಟ್ ಆರ್ಡರ್ ವಾಸ್ ಸ್ಟೇಕ್.
ಇವ್ರು ಯಾವ್ದು ಕಾಣ್ತಾ ಇಲ್ಲಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತೀನಿ.
mistake, my lord.
It's a mistake. That is when ನಾನು
You make us to struggle so much.
ನಾನು ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ.
May not be mine application.
22/2023 ಅಲ್ಲಿ
February.
I'll do that.
Probably inadvertence in this case 50% of the amount was not deposited. Having regard to submission time granted under
I know that, I know.
50% of the amount.
That I will handle.
To withdraw that.
ಅಲ್ಲಿ ಏನು ಆಗಿಲ್ಲ. 22/23 ಕೂಡ ಯಾವ್ದೋ ಆರ್ಡರ್ ಇದಕ್ಕಾಗಿಲ್ಲ, ಅಂದ್ರೆ withdrawal ಆಗಿಲ್ಲ. But application, don't press this application. ಇಲ್ಲ ನಾವೇ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. There is no order passed. ಬರ್ಕೊಳ್ಳಿ. IA 1 of 2023 is to recall the order dated 23/2/2023 and verification. ಈ ಆರ್ಡರ್ ಯಾವ್ದು ಆಗೇ ಇಲ್ಲ. 23/2/2023 ಯಾವುದೇ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿಲ್ಲ. ಇವನ್ 23 ಕೂಡ.
My lord, we had filed an application seeking for refund of excess amount deposited. After which, my lord, this order was passed, asking him to give a guarantee for rupees 10 lakh, which has withdrawn in excess.
Tula is filed application.
Yeah, that is 10.4 million.
Then not filed.
ಅದರಲ್ಲಿ there are a direction to deposit, my lord, 50%. They did not deposit. I made a complaint to the
Sir, ಯಾಕೆ ಹಂಗೆ ಹೇಳ್ತೀರಿ? ಎಲ್ಲ ಕೇಸಲ್ಲಿ ಡಿಪಾಸಿಟ್
5023.
ಎಲ್ಲಾದ್ರಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ.
ಯಾವ್ದೋ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಎಲ್ಲಾದ್ರಲ್ಲಿ ಡಿಪಾಸಿಟ್
5023, I filed up.
ಕೇಳಿದ್ದು.
Correct. ಅದು ಅವ್ರು ತಪ್ಪಾಗಿ ಹೇಳ್ತಾರೆ. Chances are
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಇವ್ರ ಪ್ರಕಾರನ ನೋಡಿ 23/2 ಯಾವುದೇ ಆರ್ಡರ್ ಆಗಿಲ್ಲ. 22/23 ಆರ್ಡರ್ ಆಗಿದೆ. ಕರೆಕ್ಟ್ ಇದೆ ಅವ್ರು ಕೊಟ್ಟಿದ್ದವ್ರು ಹೇಳಿ ಸರಿ ಇದೆ. No order is passed on 23/2/2023 which
No, my
was
lord,
your-
they have not deposited the money as directed earlier. Then they sought for 2 weeks' time to deposit. Your lordship granted that time. Your lordship may kindly see the order.
ಹೌದ್ರಿ ಆದ್ರೆ ಈ ನೀವ್ ಹೇಳೋ ದಿವ್ಸಕ್ಕೆ ಯಾವ ಆರ್ಡರ್ ಆಗಿಲ್ಲ. 23/2/2023
ಎಲ್ಲ 23/2 ಇದರಲ್ಲಿ ಅವರು ಡಿಪಾಸಿಟ್ ಮಾಡಿರೋದು. There is a covering letter.
under IA number 1 of 2023, the order dated
Absolutely.
23/2023 is sought to be recalled, but no such orders. No order is passed on 23/2023, therefore the application is rejected. Yes, sir. Okay. Next.
No, my lord, in this one, your lordship directed to deposit, my lord.
In
That
here,
after the
matter-
deposit, I have made this.
Application and then discuss, submit. This next.
In 6.1 and 6.
6 ಅಲ್ಲಿ IA 1 of 2019 for condonation of delay of 253 days and for withdrawal. ಇದರಲ್ಲಿ ಇದು ನೀವು ಶಂಕರ್ ನಾರಾಯಣ್ ಭಟ್
Yes, in 10.6, my lord, I made an
ಕೊಡಿ
application.
ಅದು MFA 7416.
Because the respondent is deceased, therefore I made an application to come on record. Their LRs have made an application to come on records. That is the application for and condonation of delay and also setting aside abatement.
ಅಲ್ಲ IA 1 of 2000 ಅಪೀಲ್ ಫೈಲ್ ಮಾಡೋದ್ರಲ್ಲಿ ಡಿಲೇ ಅದು. IA 1 of Higher whether have any serious objection for condonation of delay?
It's all. All are connected matters, my lord. In one matter, it is. We have, even though I don't concede, my lord, but let the court.
ಹೋಯ್ತು ಎಲ್ಲ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಹೋಯ್ತು ಎಲ್ಲ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ರೀಸನ್ಸ್ ಹೇಳಿದೆ. Orders and IA 1 of 2020. Third, accepting the reasons assigned to explain the delay of 250 days in filing the appeal is condoned in the interest of justice. IA 1 of 2019 is disposed.
To be fair to respondents, my lord, they have all conceded to the accusation. They are they are not having any problem with that. Nobody has challenged. None of the owners.
3 of 2020.
Only the enhancement ಮಾತ್ರ ಬಂದಿರೋದು. In fact, ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
By the appellant pursuant to the order dated, ಇವ್ರದ್ರಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಬರೆದಿದ್ದಾರೆ 24/2/2023. ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀರಾ ನೀವು?
ಮಾಡಿ ಎಲ್ಲ ಕೇಸ್ ಮಾಡಿ.
He is seeking withdrawal of that 50% ಅಲ್ಲ.
50% my lord yes ಮಾಡುವುದು. 50% have no.
Deposited only 50%.
Yes, in one particular case, my lord had made a mistake.
Particular
Calculate.
case ಅಲ್ಲ ಈಗ 10.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಮಾಡಿದ್ರೆ 50 ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ರೆ
ಒಂದೊಂದಾಗಿ.
ಆಯ್ತು.
We do not know why you hurry when one matter is being heard.
ಆಯ್ತು. ಎಲ್ಎಸಿ ನಂಬರ್ ಹೇಳಿ.
ನಂದು.
Order I am.
Reject ಮಾಡಿದ್ದು ಅಂತ ಬರ್ತಾರೆ. ಹೌದಾ?
ಒಂದೊಂದು ಮುಗಿಯೋ ಅದನ್ನ ತಗೊಂಡಿಲ್ಲ. 2 and 3 MFA number 7469 of 2019 IA number 1 and of 2019 and 3 of 2022 ಬರ್ಕೊಂಡ್ವಿ. Accepting the reasons assigned to ಇದೆ delay of 250 interest of justice. ಆದ್ಮೇಲೆ 50% ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀರಲ್ಲ ನೀವು ಇದಕ್ಕೆ? Consider for the appellant to consider for release of 50%. ಅಂದ್ರೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ ಎಂಟೈರ್ 50% it will be released.
Only
ಸೂರ್ ಕೋರ್ಟಲ್ಲಿ ಮಾಡಿ.
50% is deposit, not the interest matter, only awarded 50%.
Let him
Deposited by the appellant. ಇಲ್ಲಿ ಮಾಡಿದ್ರೆ
Lower ಹುಣಸು ನಿಮ್ದೇ ಇದು.
directed to release digitally release the amount in deposit to respondent. ಅವರೇ ತಾನೆ ನಿಂಗೆ ಕೂಡ
Yes, my lord, yes.
ಅಲ್ಲಿ ಕ್ಲೈಮೆಂಟ್ ಆಗ್ತದೆ. Correspondent number 1 herein who is the claimant before the reference court.
Yes.
IA number 1 and 2, 1 of 2019 and 3 of 2023 are disposed of accordingly. ಇದನ್ನ ಮುಗಿಸೋದಕ್ಕೆ
Similar order may be passed in 10.4 also, my lord.
ಆಗೋಗಿದೆ ಆರ್ಡರ್ ಈಗ. You file
No.
appropriate application.
No, my lord, that is
Date ತಪ್ಪಾಗಿದೆ. Agreement date ತಪ್ಪಾಗಿದೆ.
Date ಅದೇ ಅಲ್ಲಿಂದ ಡ್ರಾಫ್ಟ್ ಮಾಡಿ ಕಳ್ಸಿದ್ದಾರೆ. That is the date they deposited, my lord. Because I produced that copy also.
What is the order dated 29/5/2024? At request finally 10 days time is granted. Failing which the appeal shall stand dismissed. ಏನದು ನಾನ್ ಸ್ಟೇಟಿಂಗ್ ಆಫ್ ಕರೆಕ್ಟ್ ಡೀಟೇಲ್ಸ್ ಆಫ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಪ್ಯಾರಾ PF ಕೊಟ್ಟಿಲ್ಲ. PF ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ after that we have complied ಮೇಲ. ಅದ ನಂತರ ಕಂಪ್ಲೈ ಮಾಡಿ. We have completed all observations.
Finishing process fee
Process fee ಅದೇ ಮಾಡಿದ್ದೀವಿ sir.
And
same thing is repeat
non-stating of correct name and details of appellant along with office note. More office
ಮಾಡಿದ್ದೀವಿ sir, ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್
office objection ಇದೆ. Condonation of payment and may be sent to pending branch.
PRC RMP ಇಲ್ಲ.
ಏನ್ ಬರ್ದಿದ್ದಾರೆ? Learned AG is directed to the notice to any branch and the office objections are complied with. Okay. TCR received. MFI for orders connected matters. Dismissal of appeal by order. PF ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಬರ್ದಿದಾರಲ್ಲ.
ಯಾವ ಕೇಸ್
For R1.
7
R1. Only R.
782.
PF. R1. Who is R1 here?
ನಂಬರ್
Claimant. Dismiss ಆಗಿದೆಯಲ್ಲ ಹಾಗಿದ್ರೆ ಈಗ. Order comply ಮಾಡದೇ ಇರೋದ್ರಿಂದ.
ಕ್ಲೇಮೆಂಟ್ ತಗೋಬೇಕ್ರಿ ಯುನಿಗ್ರೇಷನ್
ತಗೊಂಡ್ ನಾನು
ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿ
ನಾನು ಮಾಡ್ತೀನಿ
ನೀವು
sir.
ಮಾಡ್ಕೊಳ್ಳಿ.
ಯಾವ್ದು 72
Dismiss ಆಗಿದೆ.
Withdraw ಮಾಡಕ್ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟು
ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ.
ಯಾವ್ದು ಇದ್ರಲ್ಲ. Dismissal.
ಒಂದಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಾ ಅಪ್ಲಿಕೇಶನ್?
ನಾಳೆನೇ ಫೋನ್ ಮಾಡ್ತೀನಿ
ಹಾ?
ಮಾರ್ನಿಂಗ್
Also for the appellant submits that he files application for recalling the. ಮುಂದಿನ ವಾರದಲ್ಲಿ
ಏಫ್ ಕೊಟ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
ಆಯ್ತು ಸುಮ್ಮನೆ ಕೊಡ್ತೀನಿ ಬಾ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಅಲ್ಲಿ
ಯಾವ್ದಕ್ಕೊಂದು ನೋಟಿಸ್ ಮಾಡಿದೀವ ಇಲ್ವಲ್ಲ ಎಲ್ಲಾರು ನೋಟಿಸ್ ಹೋಗಿದೆ ಅಲ್ಲ ಇದು ಇದ್ರಲ್ಲೊಂದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಎಲ್ಲ ನಾವು ಡಿಸ್ಮಿಸ್ ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು
ಎಲ್ಲನೂ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ.
ನೀವೊಂದು ಆರ್ಡರ್ ಡೇಟ್
37.
ಅಲ್ಲಿ ಈಗ್ಲೂ ಮಾಡಿಲ್ವಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ಈಗ ಮಾಡಿದ್ರೆ ನಾವು ಅಟ್ಲೀಸ್ಟ್ ನಾವು ಇಫ್ ಯು ಪೇ ದ PF ವಿ ಕುಡ್ ಹ್ಯಾವ್ ರಿಕಾಲ್ಡ್ ದಟ್ ಆರ್ಡರ್
ಅಲ್ಲಿ ಪೇ ಟು ಡೇಟ್ಸ್ ಅಲ್ಲಿ PF ಅಂತ ಇವತ್ತು
ಮಾಡಿ
7825 ಮಾಡ್ತೀನಿ ಸರ್ ಈಗಲೇ ಫೈಲ್
10.8 mila.
10.8.
There the respondent is deceased. I have filed the application to come on record as.
Statement bringing the LRs of deceased R1.
Yes.
You have filed wakalat for the
Yes, ma'am. I have filed that application.
I am-
Wakalat.
CD in recalling the application not pressed by advocate for the appellant. I had to recalling the order dated 1/8/2000.
ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು
ಏನದು?
Yeah.
Which application is not pressed? I have one of CD memo. Third, second set to be filed memo. Along with copies of documents, the second set to be filed. What is the second set? You have filed application for withdrawal.
Yes, ma'am. I have filed application to-
ಏನೋ withdraw.
on behalf of the LRs and
ಅಲ್ಲ,
also an application to withdraw.
ಮತ್ತೇನೋ ಎರಡು IA recalling order dated 1/8/2020.
ಅದು ಅವ್ರು ಮಾಡಿರೋದು. I have not filed.
What is order dated 1/8/2020?
That my land should, because I am a pandit,
Application ಅನ್ನು ನೋಡೋಣ ಇರಿ ಗೊತ್ತಾ?
10.8.
1/8/2020. ತುಂಬಾ ಕೇಸ್ಗಳನ್ನ ಕನೆಕ್ಟ್ ಮಾಡಿದಾಗ ಹೀಗಾಗುತ್ತೆ. 1/8/2010.
ಅಪ್ಲಿಕೇಶನ್ ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಅಂತ ಇದೆ ಸರ್ ಅದು.
ಅಲ್ಲ ಆ ಅಪ್ಲಿಕೇಶನ್ ಅನ್ನ ಪ್ರೆಸ್ ಮಾಡ್ತಾ ಇಲ್ವಾ ನೀವು?
2 of 2023.
1/8/2022 ಯಾವ್ದು ಆರ್ಡರೇ ಆಗಿಲ್ವಲ್ಲ ಇದ್ರಲ್ಲಿ?
That is why my lord ಅದಕ್ಕೆ ತಪ್ಪಾಗಿದೆ ಅಂತ ನಾವು ಬಿಟ್ರಮ್ಮ.
ಯಾವ ಅಪ್ಲಿಕೇಶನ್ ಅನ್ನ ಪ್ರೆಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ ನೀವು?
ಅದೇ
This IA 1 of 2023 are not pressing.
1000.
IA 1 of 23 not pressed.
ಅಲ್ಲ ಇನ್ನೊಂದು ಎರಡು ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಅಂತ ಹೇಳಿ 2 of 1 of 23 is for condonation of delay.
2 not.
2 of 2023.
1 and 2 not pressed.
ಅಲ್ಲ what is IA 2 of 2023?
Recalling the order dated 1/8/22.
Recalling the order dated
Application
10/8/2022. Since the appellant's counsel is not pressing IA 1 of 2023 and 2 of 2023, the same are dismissed as not pressing. Okay. IA 3, 4 and 5, na? They are LR application.
ಅಲೋ ಮಾಡಿದ್ರು ಅಲೌಡ್.
I 4 and 5.
Hello, ಆಗಿದೆಯಾ ಇಲ್ಲ?
I 4 and 5 filed by the respondent.
Shankar Narayan Bhatt,
ಅಲ್ಲ,
already A to B ಗೆ representation.
Advocate ಅದು ಶಂಕರ್ ಅವರೇ he himself has filed to come on record.
Yes, ma'am. I myself has filed.
Actually, they should have filed it.
Allah, they should have filed it not to avoid the delay because of that. They have not taken.
Hello, madam.
I have done your job.
ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ, many people were there, so.
Let aside the abatement. ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಎಲ್ಲಾರ್ಸು?
ನಾಲ್ಕು ಜನ ಇದ್ದಾರೆ.
ಎಲ್ಲಾರ್ಸ್ A to D ಅಂತ ಇದೆ.
Seconds have to be filed ಎಲ್ಲ.
A to D.
She was respond number 1, huh?
Yes, madam. Respondent Vijay Kumari.
Orders and I number 1, 3 to 5 of 2023. ಏನ್ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಹಾಕಿದೀರಾ?
ಹೌದು ಕೊಟ್ಟಿವಿ.
Respond number 1,
Death certificate and
as per
also
the death certificate produced by the applicants, respond number 1 died on 26/6/2022. Therefore, the above applications are filed by her legal representatives.
ಅಂದ್ರೆ ಮೈಸೂರು
The above applications filed by her to come on record. Come on record as her legal representatives. Considering the yesterday delay, not necessary. Considering the reasons assigned, the delay of under 9 days in filing the applications is condoned. The abatement of the appeal against the first respondent is hereby set aside, and the applicants are permitted to come on record as respond number 1 A to D, na?
A to D.
As respond number 1 A to D. The appeal memo, I'm sorry, appellant, ನೀವು ಕಮೆಂಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ appellant should
ಮಾಡ್ತೀನಿ.
amend the constitution of the appeal memo and furnish the copy of the appeal memo accordingly.
Amendment of cost title.
IA 1 to 3, 3 to 5 of 2023 are disposed of accordingly. IA ಇನ್ನೊಂದು ಯಾವುದು?
ಇನ್ನೊಂದು for
198 days delay in filing the appeal. ಇಲ್ಲ ಅವ್ರದ್ದು ಇನ್ನೂ ಒಂದಿದೆ. You have another
yes,
application.
for permission to withdraw the deposit.
ಕಂಡೌನ್ ಮಾಡೋಣ ಬಿಡಿ. 198 days delay. ಎಷ್ಟು ಅಪ್ಲಿಕೇಶನ್ಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ? Orders and I number 1 of 2019. ಅದನ್ನೇ ಮೊದಲು ಮಾಡಬಹುದಿತ್ತು. ಏನಿದೆ ಸೇಮ್ ಬೇರೆ ಕೇಸಲ್ಲಿ ಹೇಳಿದಾಗ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ರೀಸನ್ಸ್ accepting the reasons assigned to explain the delay. Delay of 198 days in filing the appeal is condoned in the interest of ಅದಾಯ್ತಾ? 1 of 2024 ರಿಲೀಸ್ ಏನ್ ಹೇಳ್ತೀರಾ?
ಆಯ್ತು.
50% ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀರಾ?
ಹೌದು ಎಲ್ಲ ಕೇಸಲ್ಲಿ
ಎಲ್ಲದೂ
ಮಾಡಿದ್ದೀವಿ.
ಎಲ್ಲ 50%.
ಜಾಸ್ತಿ ಮಾಡಿ.
Now counsel for the appellant concedes for IA 1 of 2024 orders and I 1. Above application is filed seeking release of the 50% of release of the amount deposited by the appellant in compliance with the interim order of stay granted by the court. Appellant's counsel concedes for the release of the amount. Therefore, reference court is hereby directed. ಈಗ ಇವ್ರಿಗೆ ಯಾರಿಗೆ ಕೊಡೋದು 4 ಸೆಂಟ್ರಿಗೆ?
ಎಲ್ಲ
ಸೆಂಟ್ರಲ್ಲಿ
one husband is one and others are children.
Attegowda, her husband.
ಹೌದು.
ಅವ್ರಿಗೆ so children also become legal representatives ಅಲ್ವಾ?
ಹೌದು.
ಅವರು they also become class 1 heirs. They are also entitled.
Yes, ನೀನು
ಎಲ್ಲರಿಗೂ ಈಕ್ವಲಿ ಕೊಡೋದು ಅಂತ ಹೇಳೋದ?
ಅನ್ಬೋದು ಅಲ್ಲ ಆಗೋದು ಒಬ್ರಿಗೆ ಕೊಟ್ರೆ ಇದು ಈಸಿ ಟು.
ನೀವು ಅಲ್ಲಿ ಹೋಗಿ ಒಂದ್ ಕೆಲಸ ಮಾಡ್ಬೋದು, ಒಬ್ಬರನ್ನ ಅಥರೈಸ್ ಮಾಡಿ ಯಾರಿಗೋ ಒಬ್ರಿಗೆ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ. ಇದೆಲ್ಲ ಅಮೌಂಟ್ to the LRs of claimant who are respond number 1 A to D in the present case, and release the amount digitally and furnishing the required documents. Okay. ಅದು ಆಯ್ತಲ್ಲ, IA number 1 of 2024 ಮುಗೀತು. Next appeal is yet to be admitted. ಇದನ್ನ ಅಡ್ಮಿಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಅಂದಂಗೆ. ಇದು ಡಿಲೇ ಈಗ ಕಂಡೋನ್ ಆಯ್ತಲ್ಲ, ಡಿಲೇ ಕಂಡೋನ್ ಆದ್ಮೇಲೆ ಇದರಲ್ಲಿ ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್ TCRs ಬಂದ್ಬಿಟ್ಟಿದೆ, ಅಡ್ಮಿಟ್ ಆಗಿರ್ಲಿಲ್ಲ ಅಷ್ಟೇನಾ?
ಅಲ್ಲ, ಅವಾಗ ಎಂಟ್ರಿ ಮಾಡೋ ಕೊಟ್ಬಿಟ್ಟು they said call for TCR, that is how. Then it was.
Admit list for final hearing. ಇದರಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF and correct address to issue notice to R1. ಇದರಲ್ಲಿ TCR set to be called ಅಂತ ಇದೆ, admitted ಅಂತ ಇದೆ.
I'll pay.
At request 1 week time is granted to do the needful. ಇಲ್ಲಾಂದ್ರೆ ಹೋಗಿ ಇಲ್ಲಿ ಬೇರೆದ್ರಲ್ಲಿ ಮಾಡಿಲ್ಲ 4 weeks ಆಗಿ ಬೇರೆ ಯಾವ್ದ್ರಲ್ಲೂ ಡೇಟ್ ಕೊಡ್ಲಿಲ್ವಲ್ಲ ನಾವು ಬೇರೆ
ಇಲ್ಲ
ಮಾಡಿ
ಕೊಟ್ಟಿವಿ.
ನೆಕ್ಸ್ಟ್ 10.10 3,344 days delay.
Dismiss ಆಯ್ತಲ್ಲ ಅದು?
Notice, notice.
ಇದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ ಇನ್ನು ನೋಟಿಸ್ ಹೋಗ್ಲಿ ಬಿಡಿ
As
ಅಷ್ಟೊಂದು
well as on main.
3,344 days delay.
That's good.
Issue notice of IA1. ಇದರಲ್ಲಿ ಸ್ಟೇನೂ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್. Issue notice.
Issue
But
notice.
we have
ಯಾರು-
deposited for everybody. ಮಾಡಿದ್ದು ಎಲ್ಲಾರ್ ಮೇಲೆ ಎಲ್ಲಾರ್ಗು.
ಯಾರಿದ್ರಲ್ಲಿ ಮಲ್ಲೇಶಪ್ಪ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮೈಸೂರು ಸಬ್ ಡಿವಿಷನ್ ಮೈಸೂರು. ಇವ್ರು ಯಾರು ತಗೊಂತಾರ?
Government.
AC accept notice for respond number 2. So ತಗೊಳ್ಳಿ ಅವ್ರ notice respond number 2 is government assistant
Okay.
commissioner Mysore subdivision Mysore. Issue notice for respond number 1. Issue notice of I1 of 2019 traffic to the respondent. To respond number 1 4 weeks ಆಮೇಲೆ ಎಲ್ಲದರಲ್ಲೂ ಡೇಟ್ ಕೊಡ್ಬೇಕು.
29/8.
29. ಅದ್ಯಾವ್ದೋ ಒಂದು ಪಾಸ್ ಓವರ್ ಮಾಡಿವಿ ಇದ್ರಲ್ಲಿ.
Correct, sir. I'll pay process.
ಇಷ್ಟು
Please.
Rejected.
29/7.
ಇದು ಬೇರೆ.
Serial number 11, K. Chandrasekhar.
Appellant, madam, needful is done. Needful is done.
Learned proceed for the appellant submits that needful is done. Registry shall verify. If found correct, issue notice correspondent. ಏನಾದ್ರು ಇದ್ರ ಆರ್ಡರ್ ಆಗಿತ್ತಾ? ಆರ್ಡರ್
First address ಕೊಡ್ಲಿಕ್ಕೆ ಹೇಳಿತ್ತು. Even it was served on the respondent personally also. When she appeared before the honorable court to attend the 498 case.
issue notice to the respondent. It's down.
22/7.
Okay.
Serial number 12, Manjunath Prasanna.
Respond number 2 for the second. No representation for the appellant. 2 weeks time is granted to the second.
Serial number 13, B. Sudhakar. CGP for
For the appellant, my lord, we have deposited the amount, my lord.
ಏನೋ ಮೆಮೋನ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿ ಬರ್ದಿದ್ದಾರೆ. ಹೋದ್ ಸರಿ ಲಿಸ್ಟ್ ಟುಗೆದರ್ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ವಾ?
ಇಲ್ಲ ನಿಮ್ಮ order
ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಮೆಮೋ ಆಫ್ ಲಿಸ್ಟ್ ಆಫ್ MFs to be
ಅದ್ರಲ್ಲಿ-
listed together.
ಇನ್ನು ಸುಮಾರು ಇದಿತ್ತು. There were connected matters. All the matters have been
For the appellant states that he will file a memo of list of MFs to be listed along with this appeal.
I will file, my lord, all the MFFs have been admitted and TCS are called. I will file the
ಇಲ್ಲ,
memo,
ಇಲ್ಲ ಬಿಡಿ,
this memo.
ಇದು ಹೋಗ್ತಾ ಇರುತ್ತೆ.
Illa, my lord, in this case, TCR records may be called.
Mr. Counsel, this order is.
I understood. my lord.
This order is passed on 31/7/2023. ಈಗ ಒಂದ್ ವರ್ಷ ಆಗಿದೆ. ನೀವು ಏನೋ ಬೇರೆ ಕೇಸಸ್ ಇದೆ ಅದ್ರ ಜೊತೆಗೆ ಲಿಸ್ಟ್ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳಿದಿರಿ, ಇಲ್ಲಿವರೆಗೂ ಲಿಸ್ಟ್ ಫೈಲ್ ಮಾಡಿ.
ಇದೆ ಅಂತ. And
50%.
50% we have already deposited. my
Where
lord.
is the proof?
My lord, can I file, my lord? It is ready.
ಏನದು? ಏನೋ ಒಂದ್ ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದನ್ನ ಹಾಕಿರ್ತೀರಿ, ಟ್ರಯಲ್ ಕೊಟ್ಟಿನ ಇದನ್ನು ಹಾಕೋದಿಲ್ಲ. ಇಲ್ಲಿ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಇದೆಯಾ?
ಹೌದು 50 ಇದೆ.
ಕೊಡಿ ಲಿಸ್ಟ್. ಯಾಕಂದ್ರೆ ಅದರ್ ಸೈಡ್ ಇನ್ನೂ ಬಂದಿಲ್ಲ ನನಗೆ. ಕೃಷ್ಣಮೂರ್ತಿ ಸರ್ಡ್ ಲಿಸ್ಟ್ ಆಫ್ MFs to be filed. ಎಲ್ಲಾರು ಕೂಡ LIC ನಂಬರ್ ಹೇಗೆ ಗೊತ್ತಾಗುತ್ತೆ?
ಹಿಂದ್ಗಡೆ ಇದೆ. ಹಿಂದ್ಗಡೆ ಇದೆ ಪೇಜ್ ನಂಬರ್. LIC number 20, last serial number 8, 20 of 2017.
ಬರೀ ಲೆಟರ್ ಕಳ್ಸಿದ್ದು ಬರುತ್ತೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಆಗಿದ್ರ ಬಗ್ಗೆ
ಡೆಪಾಸಿಟ್ ಅದೇ ಅಲ್ಲ ಕೋರ್ಟ್ಗೆ ಡೆಪಾಸಿಟ್ ಆಗಕ್ಕೆ ಡೀಟೇಲ್ಸ್ ಕಳ್ಸಿರ್ತೀವಿ ಸ್ವಲ್ಪ.
ಅಲ್ಲ ಅದು
ನನ್ಗೆ ಅರ್ಥ ಆಯ್ತು
receipt
ಸುಮ್ನೆ.
ಕೊಡ್ತಾರಲ್ಲ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಕ್ಕೆ
ಹೌದು.
ಇನ್ ಎವ್ರಿ ಕೇಸ್ ಯು ಆರ್ ಫೈಲಿಂಗ್ ಇಟ್ ಲೈಕ್ ದಿಸ್ ಓನ್ಲಿ.
ಅಲ್ಲ ಅವ್ರು ಕೇಳಿದೀನಿ ಸುಮ್ಮನೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಇಂದ ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
ಬಿಡಿ ಅವ್ರು ಎಕ್ಸಿಕ್ಯೂಟ್ ನಾವು ಪ್ರತಿದಿನ ನೋಡ್ತಾ ಇದೀವಿ ಅವ್ರು ಕೊಡೋದೇ ಇಲ್ಲ. ಈಚ್ ಕೇಸಲ್ಲಿ ಕೋರ್ಟ್ ನಲ್ಲಿ ಅವ್ರು ಚಲನ್ ವೋಚರ್ ಕೊಡ್ತಾರೆ ಸರಿ ರಿಸಿಪ್ಟ್ ಕೊಡ್ತಾರೆ ರಿಸಿಪ್ಟ್. LIC number 20. Another constable apparent submits memo with copy of a communication said to be issued by the appellant to ಯಾರಿಗೆ ಕಳ್ಸಿದ್ದು?
ಇವ್ರು ಸಿವಿಲ್
DGP ಗ
ಅಲ್ಲ ಸಿವಿಲ್ ಕೋರ್ಟ್ಗೆ ಅಲ್ಲಿ ಮಾನ್ಯ ಹಿರಿಯ ಸಿವಿಲ್ ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್.
But actual receipt is not produced. If the amount is not deposited, the claimants are at liberty. Reference court is at liberty to proceed with the execution case. Deposit ಮಾಡಿರಲಿಲ್ಲ ಅಂದ್ರೆ ಮುಂದುವರಿತಾರೆ ಅವರು.
ಮಾಡಿದೀವಿ.
ನಾನ್ ಫೈಲಿಂಗ್. The counsel for the appellant had undertaken on 31/7/2023 itself to file the list of the connected matters, but no such list is submitted. ಈಗ ಇದ್ರಲ್ಲಿ ಏನಾಗ್ಬೇಕು?
ಇದು ಅಡ್ಮಿಟ್ ಆಗಿ TCR ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ಮ್ ಮಾಡಿ.
Therefore, less is matter in the usual course. Admit call for TCRs.
ಪ್ಲೀಸ್ ಮಾಡಿ. ಐ ವಿಲ್ ಫೈಲ್ ಮೆಮೋ ಆಲ್ಸೋ. ಅಲ್ಲ
And
ಆರ್ಗ್ಯುಮೆಂಟ್
question
ಟೈಮಲ್ಲಿ
ಮಾಡಿಲ್ಲಲ್ರಿ?
ಆರ್ಗ್ಯುಮೆಂಟ್ ಟೈಮಲ್ಲಿ
Cell number 14, Jagdishwara NR, Vaikesh
Common judgment ಆಗಿದೆ. Common judgment ಇದೆ. ಆದ್ರೆ ಅದು ಕೊಡ್ಬೇಕಲ್ಲ ಯಾವ್ದು ಅಂತ.
In this case, I appear for the respondent. In this matter, I have not filed the execution nor have deposited, withdrawn the amount. Since there was a reference made under section 3031 of the act that is pending for consideration, I am filing a memo that, here it is. That the appellant, the LAO's award has been wrongly deposited in LAC number 21 of 16 instead of
57 of 2006.
this is a reference under 18. The LAO's award has been deposited wrongly by the appellant BBMP in LAC 21 of 16 instead of LAC 8 of 16, madam.
This arises out of LIC
47, yes. So in this case,
where they have deposited?
Relating to the same respondent, there is another case, LAC 8 of 2016, that is a reference made under section 3031. The appellant has wrongly deposited that amount, LAO's award, in LAC 21 of 16 instead of LAC 8 of 16. The LAC 8 and 21 is pending for consideration before the.
Here order was passed to deposit it in this enhancement section.
Yes,
8
yes,
reference.
that I am not aware that, I am not aware about, as far as the deposit of 50% of the award amount, as per the directions of this honorable court.
47 ಮಾಡಬೇಕಾಗಿತ್ತು.
Other, I am not aware because I am not,
ಈ ಮೆಮೊ ತಗೊಂಡು ಏನ್ ಮಾಡೋದೀಗ?
allala, to know that they have wrongly deposited the LAO's award in another case. In fact, that in the pending case, I already filed a memo.
We filed in LIC number 80.
ಹೌದು.
8 of 2016.
ಹೌದು.
ನಾವು ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಂತ ಹೇಳ್ತೀವಿ. ಇದು ಇಲ್ಲ ಯಾಕೆ ಮಾಡಂತ ಹೇಳ್ಬೇಕು ನಾವು?
Uncle, to bring it to their note.
That matter is not before us.
Yes, that is there. To know that,
Correct, let them first produce the proof of other.
yes, let them produce. Yes.
ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ಈ ಕೇಸಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಸಾಕು. ಅವ್ರು ಯಾವ್ದೋ ಕೇಸಲ್ಲಿ
ಅಲ್ಲ ಈ ಕೇಸಲ್ಲಿ ಮಾಡಿರೋದು ನಂಗೆ ಐ ಆಮ್ ನಾಟ್ ಅವೇರ್ ಬಿಕಾಸ್
I'll verify and I'll produce it, please.
ನಾನ್ ಫೈಲ್
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ series of matters are-
with the execution ಅಷ್ಟೇನೆ.
I'll verify and I'll 2 weeks accommodation.
say that
DCF
is
ಕೂಡ
vacated
ಇದೆ.
ಅಷ್ಟೇ.
Court fee, DCF is also has to be made.
Because
2 weeks
50%
accommodation may kindly be granted, please. With regard to this memo, this
ನೀವು
is.
ಯಾರ juniors ನಿಮ್ಮತ್ರ ಬಂದ್ರೆ
ಅದನ್ನ ತಗೊಂಡಿಲ್ಲ ಬಿಡಿ
ಅಲ್ಲ, ಅದು-
ಟೇಕನ್ ನಂಬರ್
may pay with ಏನದು what are the pending?
It is only with regard to
This
DCF.
court fee of 27,199 is to be made good. ಅದು
ಒಂದೇ office objection ಇದೆ.
ಪಾರ್ಟ್ಲಿ
ಇದು ಕೊಟ್ಬಿಡಮ್ಮ ಮೆಮೋ ವಾಪಸ್
ಡೆಪಾಸಿಟ್ ಬಗ್ಗೆ ಏನು ಇದು ಮಾಡಿದ್ವಿ ಬಟ್ ಡೆಪಾಸಿಟ್ ನೀವು ಪ್ರೂಫ್ ಹಾಕ್ಬೇಕಲ್ಲ ಏನು
I'll file it within 2 weeks, please. Manoj.
ಡೆಪಾಸಿಟ್ ಬಗ್ಗೆ ಇಲ್ಲ. ಡೆಫಿಸಿಟ್ ಇಲ್ಲಿ ಬರೀ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರೀ ಕೋರ್ಟ್ ಫೀ ಬಗ್ಗೆ ಬರೆದಿದ್ದಾರೆ ಮತ್ತೆ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಸ್ಕ್ರೂಟಿನಿ ಬ್ರಾಂಚ್ ನಾನು ಇಲ್ಲಿ ಬರೆದಿದ್ದೇನೆ. At request finally. ಅದು ಕೋರ್ಟ್ ಫೀ ಕೊಡ್ಬೇಕಲ್ಲ ನೀವು? ಎಷ್ಟನೇ ಸರ್ ಇದೆ 21ರಲ್ಲಿ ಹಾಕಿರೋ ಕೇಸ್ಗೆ ಇಲ್ಲಿವರೆಗೂ ಕೋರ್ಟ್ ಫೀ ಕೊಡ್ತಾ ಇಲ್ಲ.
There is a deficit court fees, ma'am.
Correct, ಈಗ 2000
Fresh valuation has been made. Adar prakara the office has raised the objections. PBMP, please.
ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ BBMP. ಟ್ಯಾಕ್ಸ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ 3 ವರ್ಷ ಏನ್ ಮಾಡ್ತೀರಿ?
ವಾಪಸ್ ಕೊಟ್ಬಿಡೋಣ.
There is a number of connected matters also. I'll make it good within 2 weeks, please.
Finally, 10 days time is granted to pay the court fee, failing which the appeal shall stand dismissed.
There are also other connected matters also. This also may kindly be tagged along with that, please.
Office objection, sorry, if no proof is produced in regarding deposit of the amount in compliance with the interim order, the respondent claimant is at liberty to proceed with the execution case.
No, because 30-31 reference is pending. Till that is disposed of, I cannot withdraw this.
Correct. Irlilla andre we have only saying.
Yes.
We are only saying that.
Let them deposit, that's all. In compliance with the order of this honorable court, let them deposit.
ಆಯ್ತು ಹಂಗಂದ್ರೆ ಬರೀ 10 days time ಅಂತ ಏನ್ ಹೇಳಿದ್ವೋ ಅದನ್ನ ಮಾಡಿ.
Yes.
Interim order may kindly.
That petition appeal shall stand dismissed. ಈ ಕೋರ್ಟ್ ಫೀನು ಕೊಡದೆ ಇಂಟ್ರಿ
La
ಮಾಡೋದು.
ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ. Within 10 days I'll make.
ಮಾಡಿಲ್ವಂತೆ. ನೆಕ್ಸ್ಟ್ ಕರ್ಸಿ.
I'll verify it and I'll submit, please, minutes. As far as my knowledge goes, it has been deposited, please, minutes.
ಡೆಪಾಸಿಟ್ ಆಯ್ತು ಕೋರ್ಟ್ ಫೀ ಕೊಡೋದು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಕೋರ್ಟ್ ಫೀ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ how?
Alla fresh valuation mele it has been the deficit court fee has been made.
Anyhow, now he is saying that they can't execute 30 petition is pending.
Alla all the other execution petitions were closed for the time being.
One case.
Please, our execution petition file madilla antare so
Number 15.
ಕರೆಕ್ಟ್ ಮತ್ತೆ ಯಾಕೆ ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕು ಅಂತ ಈಗ ಅವ್ರು ಹೇಳಿದ್ದೆ ಹೇಳ್ಬೇಕಾಗುತ್ತೆ ನಾವು.
Cell number 15, Prashant BR, Gita Devi MP.
ಬರೀ ಟೆನ್ಷನ್ ಮಾಡ್ತಾರೆ.
Respondent.
There is 10 days delay, my lord, in this case.
Lord, the copies are not served on us.
Per state. Copies are not served.
But name has been showed.
Connected ಬೇರೆ matter ಇದೆ ಸುಮ್ಮನೆ. They have
Connected.
also filed a.
Which is that connected matter?
Where?
FFA 2157 ನಾ connected. ಇವತ್ತೇ ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
List this matter along with MFA number 2157 of 2016. ಇದು ಇಂಥದ್ದು ಯಾವಾಗ ಬಂದ್ ಹೋಯ್ತೇನೋ ನಮ್ಮ ಮುಂದೆ ಅಲ್ವಾ? ಬಂದ್ ಹೋಗಿತ್ತು ಅದು 2157 ಅಂತ ಅನ್ನೋದು.
TCR ಕಾಲ್ ಮಾಡಿದ್ರೆ ಅದರಲ್ಲಿ TCR
ಕರೆಕ್ಟ್. ಅದರಲ್ಲಿ ಸಬ್ಸ್ಟೆನ್ಷಿಯಲ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಮಾಡಿದೀವ ನಾವು? ಮಾಡಿರ್ಬೇಕು. ಇಲ್ಲಾಂದ್ರೆ ಅಡ್ಮಿಟ್ ಮಾಡದೆ ಏನು ಲಿಸ್ಟ್ ಅಲಾಂಗ್ ವಿತ್ MFA number 2157 of 2016 ಆನ್ ಒಂದು ಡೇಟ್ ಹೇಳಿ ಎರಡು ಒಟ್ಟಿಗೆ ಬಂದ. Substantial question.
10-7.
Please.
10-7.
Please.
Cell number 16, Sanat Kumar KM.
For the appellant. Filing the application to recall the order dated 17/4/2021, my lord. During
58 days in recalling.
Yes, my lord. During the COVID period, my lord, the matter was listed to take the steps for the respondent, my lord. The order was passed saying that, my lord, finally a week's time is granted to take steps to serve unserved respondent, failing which the appeal stands dismissed without reference to the bench, my lord.
17/4/2021.
Now, my lord, the
21 ನಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಇರೋದಿಲ್ವಾ ನೀವು ಅಷ್ಟು ವರ್ಷ?
no, my lord. It is dismissed without reference to the bench, my lord.
ಕರೆಕ್ಟ್. ಆದ್ರೆ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ ಡೈಲಿ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ ಬೈ ದ
Yes, my lord. It is a
ರಿಜಿಸ್ಟರ್ಸ್ ಮಾಡಿರೋ ಆರ್ಡರ್ ಅಲ್ಲ ಇದು ಅಪ್ಲೋಡ್ ಆಗಿರುತ್ತೆ.
this is the past during the COVID period, my lord. The
2021.
council on record, my lord,
Who was the council on record?
Sanat Kumar, my lord. At the time he is suffering from COVID, my lord. He has taken the vaccination also, my lord. The receipt has also been produced, my lord.
Even 2023.
Application filed in the year 2000. COVID-19 vaccination certificate
ಈಗ
also.
ಕೊಟ್ಟಿದ್ದೀರಾ ಪ್ರೆಸಿಡೆಂಟ್?
Process taken.
ಅದೇ ಅಫಿಡವಿಟ್ ಹಾಕಿದಾರಾ?
Yes, ma'am.
Perfect. Orders and I number 1 and 2 of 2023. Conduct model. Third, accepting the reasons assigned. Explain the delay of 578, delay and lapses and delay of 578 days in filing I-2 of 2023 is hereby condoned. The order dated 17/4/2021 dismissing the appeal for non-compliance is hereby recalled. The appeal is restored to the file. I have 1 and 2 of 2023. Restored to the file in the interest of justice. I have 1 and 2 of 2023 are disposed of accordingly. Issue ಈಗ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಮಾಡ್ಬೇಕಾ ಹೇಗೆ?
Process has been paid, my lord.
ಕಂಡೀಷನಲ್ ಅಂತ
Yes, madam. On 10/6 I have taken the steps, madam.
ಅಲ್ಲ ಈಗ ಇಷ್ಟು ದಿವಸಕ್ಕೆ ಅದು ಹೋಗಿ
Earlier I have also taken the one-time steps, my lord. On 7/11/2019 I have taken the steps.
what happened? Service ಆ steps ಗೆ ಏನಾಗಿತ್ತು? Whether it was served or unserved?
It is unserved, my lord.
Fine.
For the second time it was listed, my lord.
ಅಲ್ಲ ಈಗ ಕಟ್ಟಿದ್ದಾರೆ ಮೊದಲು ನಮ್ಗೆ ಹೋಗಿತ್ತಂದ್ರಲ್ಲ ಏನಾಗಿದೆ? 2017 MC ನಾ?
Now the fresh process has been paid, my lord.
There she had contested earlier.
Yes, my lord. Suit for divorce is
Issue notice to the
dismissed.
List on records call for ಆಗಿತ್ತಾ?
Hagila, my lord.
ಅಡ್ಮಿಟ್ ನೋಟಿಸ್ ಮಾಡಲ್ಲ.
To be called.
ಅಲ್ಲ ಅಡ್ಮಿಟ್ ಮಾಡೋಣ ಯಾಕಂದ್ರೆ ರೆಕಾರ್ಡ್ಸ್ ನೋಡಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋದು. Third, admit call for TCR, issue notice to the respondent, list on
22/7.
Much obliged.
Cell number 17, B Latif, Rakesh Kini.
This matter, my lord. Not received a copy of the appeal. No, I have asked them for a copy. They said they'll serve today. Maybe
You have
call next week.
received or not received?
Not received.
It's not.
But notice ಹೋಗಿತ್ತಲ್ಲ ಅವ್ರಿಗೆ.
Please, madam.
Condonation of delay.
They had
136
copy for the
days
trial.
delays.
That's why I filed Wakala.
You had appeared in the trial court.
Yeah, my.
ಕಾಪಿ ಬಂದಿಲ್ಲ ಅಂತ ಕೊಡ್ತೀರಾ?
ಕೊಡ್ತೀವಿ sir.
One sector. Possible respondent. ಏನಾಗಿದೆ ಆರ್ಡರ್? What is the order passed here? Petitioner. Petition and intent guardians of custody of the minor children as he has in a recent. Declared the guardian is dismissed. Copy serve ಮಾಡಿ.
Please, madam.
You have to request and get it. Notice serve ಆಗಿತ್ತಲ್ವಾ?
ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿಲ್ಲ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರು.
Yes, sir. Yes, sir.
ಸೋ ಮೋಟೋ ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ?
ಅಲ್ಲ, ನೋಟಿಸ್ ಆಗಿದೆ, ನಮ್ಗೆ ಸರ್ವ್ ಆಗಿಲ್ಲ. ನಾವು ಅದಕ್ಕೆ ವಕಾಲತ್ ಹಾಕ್ತೀವಿ. ಬಿಫೋರ್
But
ಟ್ರಯಲ್ ಕೋರ್ಟ್
notice ಆದ್ರೆ serve ಮಾಡಿರ್ತಾರಲ್ಲ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆ, ಸೇಮ್ ಪಾರ್ಟಿ. ಅದ್ರಲ್ಲಿ ಹೇಳಿದ್ರು ಮೆಮೊ ಹಾಕಿ ಈ ಮ್ಯಾಟರ್ ನಾವು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀವಿ ಅಂತ. ದಟ್ಸ್ ವೈ ವಿ ಫೈಲ್ಡ್ ವಕಾಲತ್.
ಅದಕ್ಕೆ ಕೇಳಿದೆ ಸೋ ಮೋಟೋ ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ ಅಂತ.
ಹೌದು.
First of the response submits that he has not received the copies. Appellant's counsel shall serve the copies only. List on
8/7.
Please.
Cell number 18, MP Geeta Devi, Sharat Gowda GB, Paran.
Praying for the appellant, my lord. My lord, the delay of 45 days, which, my lord, where we sought.
Condoned? Yes. ಇದೇನು ಎಷ್ಟೊಂದು ಜನ ಇದ್ದಾರೆ? ಮ್ಯಾನೇಜಿಂಗ್ ಪಾರ್ಟ್ನರ್, ಕ್ಯಾರಿಯರ್ ಏರ್ ಕಂಡೀಷನರ್, ಮ್ಯಾನೇಜಿಂಗ್ ಪಾರ್ಟ್ನರ್, engineering.
2 to 5 are the contract employees, my lord, immediate employees.
Immediate.
Please.
Administrative reasons ಹೇಳಿದ್ದೀರಾ?
Please, my lord.
Orders and number 1 of 2020. Third, accepting the reasons assigned to explain the what is delay of 45 days in filing the appeal is condoned in the interest of justice. I have 1 of 2020 is disposed of accordingly. This, what is the point involved?
My lord, where the respondent number 1 is establishment is covered on the ES Act, my lord, where the 2 to 5 were engaged in the contract employees and they have paid the sum under the different debts of more than 3 crore rupees. So we have sought for an contribution from January 2007 to March 2011, my lord. That is the contribution amount is rupees 20 lakhs rupees.
What is the substantial question of law? What is the point involved?
Plus, the external question of law, whether the interpretation of ESI court on
No,
section.
ಹಾಗೆ ಹೇಳಿದ್ರೆ ಆಗೋದಿಲ್ಲ ಹೇಳಿ.
No, because section 40 clearly says, my lord,
Is correct ಅಂದ್ರೆ ಏನು?
no, the liability is on the principal employer. Section 40 clearly says of the ESI Act, where even though if the immediate employer has been contracted, the liability is of the respondent employer to seek to pay the contribution, my lord. He is entitled for that.
He is liable.
He is liable, my lord.
What is held by 45A ಆಗಿತ್ತಾ ಇದ್ರಲ್ಲಿ?
Please, my lord, 45 order has been issued.
It was held in 45A. Records call.
Section 40 says that the obligation on the principal employer, my lord, to pay contribution in respect of the employees employed or through immediate employer.
40.
Please, my lord,
In the first instance.
please.
Directly employed by him, not being an exempt employee. So their contention was that they had outsourced him.
Please. But they'll be as an immediate employer. Immediate employer, ma'am. So the liability is on him to pay the contribution to the employees who have been employed through the immediate employer.
Filed by the applicant under so and so is hereby include order passed by the first respondent section. So the order was 45A order was passed only against this BHEL or TL? What is?
No, ma'am, the contribution was.
It's the first respondent.
Please, Bharat Electronics Limited.
that
Our issue ಆಗಿತ್ತು.
It was only against
Yes.
him, not against the immediate employees.
No, because he has the liability to pay all those things, ma'am. Because he has taken the contract from them.
Correct. Definitionally, immediate employer in relation to employees employed otherwise means. Where is the reasoning to hold that
No, it
immediate
is,
employer should be held liable first?
the ESI court has fastened the burdening on us, my lord. That is the only.
Paragraph judgment. Only on that ground, the order is reversed or on any other ground?
No, only ground is that we have issued show cause notice, so we have to substantiate, my lord, but the reliance which we have relied upon the Modala Ulan case, my lord, it clearly says this.
So where it shows from the judgment of the trial court.
This page number 31, my lord. Internal page, ink page is 23.
In which, para is to?
Para 24, where the,
Para 24.
please, my lord, the trial court is reliant on this judgment, but it's not applicable to this case, my lord.
Applicant is able to establish before the court that the order passed by so and so for the period is not sustainable. No, where is the reasoning? You said that ESI court held that.
ESI court has held us, we have to prove it, my lord. That is the ground which the ESI court has taken.
ಎಲ್ಲಿದೆ ಅದ reasoning? You said the ASI code says that immediate employer is liable, not the principal employer.
That is this,
Where is that finding? There is no convincing evidence on record to show that respondent called up. ಇಲ್ಲ notice ಕೊಟ್ಟಿಲ್ಲ ನನಗೆ. Admit ಇಲ್ಲ ಒಂದು no convincing evidence to show that first respondent called upon the response 225 to produce the documents except producing R1. ಅಂದ್ರೆ ಅವ್ರಿಗೆ document ಕೊಟ್ಟಿಲ್ಲ assess ಮಾಡಕ್ಕೆ ಸರಿಯಾಗಿ ಆಗಿಲ್ಲ. There is no effective cross examination of the applicant laid upon in respect of A1 to 13. There is no reason to disbelieve the evidence of the recital found in A1 to 13. There is no reason to disbelieve the documents challenged to reduce towards payment of contribution. Fourth respondent only supplied the material which only involves material component. How the whole model
42 boys happy to.
Arising of the provisions of 212 and 42. 212 are the employers. 212 is factory means premises including the proceeds thereof. And two are employment is even. And 40. Notwithstanding ಒಂದು ಎರಡು ರೀಸನ್ ಹೇಳ್ತಾರೆ ಅದು ಒಂದು ಇವರು they had called upon them to produce the documents,
but they have not
they had
produced.
not produced the documents. So he made the best judgment assessment ಅಂತ consider. ಎರಡನೇದು principal employer. The claim is that petition under section 45 was allowed.
Please, my lord.
17, 45.
75.
75 was allowed on two grounds. One is that the response 2 to 5, the immediate employers were called upon to produce the documents and they did not produce except exhibit R1 anತಾರೆ. What is exhibit R1?
R1 is the,
In a
he is the
of-
principal employer, my lord.
Admittedly, in this case, there is no convincing evidence on record to show that para 23. First respondent called upon response 2 to 5 to produce the documents. ಅಂದ್ರೆ ನೀವು ಅವ್ರನ್ನ ಕಾಲ್ ಅಪ್ ಮಾಡಲಿಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದಕ್ಕೆ.
No, the main contention is that principal employer has to produce all the documents because he has engaged the employers from the immediate employer, my lord. So the liabilities on him, he should ensure that whenever the,
called upon him.
yes, we have, even that we,
Called
that,
upon him. What is the document to show that you had called upon him? Statement of lease,
Oh, the-
copy of lease, copy of ESI.
these are maybe called, I'll verify it.
ESI. ಅಂದ್ರೆ records call for ಮಾಡೋಣ ಅನ್ಕೊಂಡಿಲ್ಲ ನಾನು. We'll call for the records. You
Please,
are not
ma'am.
able to tell us what exactly is the substantial question here.
I'll verify in the event records.
The question ಮಾಡಿಲ್ಲ ಏನು? So, ground raise ಮಾಡಿ. ಅಪ್ಪ 45 order. And then at least if you produce that 45A order, we'll come to know what was the ground raised by you.
I'll produce, my lord.
Produce ಮಾಡ್ತೀರಾ? ಇದೆ ನಿಮ್ಮ ಹತ್ರ ಈಗ?
Again, we have to seek it from the corporation, trial court record may
ಅದೇ
be,
ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ? But how do you argue it for admission?
records may be called.
Call for the TCRs. Call for the TCRs. Please come. Sorry, to examine whether there is any substantial question of law in the matter. Records are required. Call for TCR. Please come.
18/7. Sorry, 16/7. 16/7.
Have you read the file? Any substantial question of law is involved here?
I'll take instruction and 16/7.
Yes.
Seal number 19, Madhukar M. Deshpande, Government Advocate, Chandrasekhar P. Patil.
For appellant, for the respondent, cross objections. In serial number 56 to
production of
56.8, my lord. In all cases, they have filed application for additional evidence,
ಇದು
for
admit
which
ಆಗಿದೆ.
I have filed objections.
Memo.
The applications may be considered at the time of.
Common synapses are fine. There are connected matters on the consider.
ಹೌದು.
ನಿನ್ನೆ ಇದ್ರಲ್ಲೂ ಏನೋ some IAs are pending. ಈ additional evidence IA ಅಂತೂ that has to be heard along.
That has to be heard along with that.
ಬೇರೆ ನಿನ್ನೆ.
I'm sorry.
Non-filing of the amended appeal memo 19.1 ಅಲ್ಲಿ. Yes, sir. MFA 5732. Who represents the appellant here? ನೀವೇನಾ?
Current ಅವರು ನಾವು ಈ ಕಡೆ.
Who represents?
Cross objection.
ಅಲ್ಲ ಮಧುಕರ್ ದೇಶಪಾಂಡೆ.
Central government.
ಇದ್ರಲ್ಲಿ ಅಪೀಲ್ ಮೆಮೊ ಕೊಡ್ಬೇಕಲ್ಲ 19.1 ಅಲ್ಲಿ. Amended appeal memo. Non-filing of acknowledgement for having deposited 30% of the amount.
ಇಲ್ಲ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರೆ. ಅವ್ರು ಹಾಕಿಲ್ಲ.
ಈ 19.1 ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. ನಾವೀಗ ಎಲ್ಲದರಲ್ಲೂ ಸಪರೇಟ್ ಆಗಿ ಬರೀಬೇಕು. Counsel for respondent number 1 submits that appellant has deposited the amount. Therefore, office objections in that regard should complied. ಈಗ ನೀವು ಅದು amended appeal memo ಕೊಡ್ಬೇಕಲ್ಲ. At request 10 days time authorityಗಳೆಲ್ಲ 10 days time is granted to. ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿತ್ತದು? 2023 ನ 15/6/2023 ಇಂದ ಇಲ್ಲಿವರೆಗೂ ನೀವು ಅಮೆಂಡೆಡ್ ಅಪೀಲ್ ಮೆಮೊ ಹಾಕಿಲ್ಲ.
ಏನು ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿಲ್ಲ.
ನಿಮಗೆ ಗೊತ್ತೇ ಇರೋದಿಲ್ಲ ಬಿಡಿ. ಇರ್ಲಿಲ್ಲ ಯಾಕೆ ಬರೀತಾರೆ? ಕೊಡಿ ಅದನ್ನ 5732. Last time ನಾವು amendment ಏನೋ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ. 5/7/2023. When order was passed for ಇದು ಅದಕ್ಕಿಂತ ಮೊದಲಿನಿಂದ ಬರ್ತಾ ಇದೆ ಅದು ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಅದು 15/6 ಅದು ಮತ್ತೆ ನಮ್ಮ ಮುಂದೆನೆ ಬಂದಾಗ. Notice has not been written so far. Applicants have filed this application claiming that respondent number 1 passed away. Application was allowed. ಅದನ್ನ amendment 1 ವರ್ಷ ಆಯ್ತು ನೀವು ಮಾಡಿಲ್ಲ. At this finally 10 days time is granted to do the needful, failing which 10 days time is granted to file the amended appeal memo, failing which appeal shall stand dismissed. ಏನದು? ಅದಕ್ಕೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಏನು ಅಮೆಂಡ್ಮೆಂಟೇ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ನೀವೇ ಎಲ್ಲಾರ ಸ್ವಂತ ರೆಕಾರ್ಡ್ ಮೇಲೆ ಬಂದಿದ್ದೀರಾ? On your application it came on record and it was ordered to be amended.
Did not file application.
Correct. ಏನು ಅಮೆಂಡ್ಮೆಂಟ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. How did you say that? ಬರೀ ಡೆಪಾಸಿಟ್ ಆಗಿರೋದು ರಿಲೀಸ್ ಆಗಿರೋದು ಎರಡೇ ಗೊತ್ತಾಗೋದು. ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಗೊತ್ತಾಗೋದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಅದರಲ್ಲಿ ಏನೋ ಇದೆ IA ಫಾರ್ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅದೆಲ್ಲ ಆಗ್ಲೇ ಆರ್ಡರ್ ಆಗಿದೆ. ನೆಕ್ಸ್ಟ್ 19.3 ಅಲ್ಲೇನು ಏನು ಇಲ್ಲ ಬೇರೆ. 19.4 ಅದು ಅಷ್ಟೇ ಇದೆ. 19.5 ಅಲ್ಲಿ 19.6 ಅದರಲ್ಲಿ ಏನು 19.7 ನೀವು ನೋಡಿ. 19.8 advocate for appellant. 19.9 ನಲ್ಲಿ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಮೆಮೋ ಆಫ್ ಅಪಿಯರೆನ್ಸ್ ಆರ್ ವಕಾಲತ್ ಅಂತ ಇದೆ. ಎಸ್ ಮಧುಕರ್ ದೇಶಪಾಂಡೆ ಅವರು ಗವರ್ಮೆಂಟ್ ಇರ್ಬೇಕು. 19.9 ತಗೊಂಡು 19.9 ಅಲ್ಲೂ ಸೇಮ್ ಇದೆ, 19.10 ಅಲ್ಲೂ ಸೇಮ್ ಇದೆ. 19.11 19.12 1913 14 15 ಅಲ್ಲಿವರೆಗೂ ಹಾಗೆ ಇದೆ. 19.9 ಇಂದ ಏನು finally a week's time is granted to comply the office objections ಆಯ್ತಾ? ಇದು cross objections.
In all cross objections he was directed to.
ಅಲ್ಲ ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿದೆ ಅವಾಗ ಡೈರೆಕ್ಟೆಡ್ ಅಂತ ಅಂದ್ರೆ ಏನೇನು ಕಾಮನ್ ಆರ್ಡರ್ ಆಗಿತ್ತು?
ಕಾಮನ್ ಆರ್ಡರ್
ಕಾಮನ್ ಆರ್ಡರ್ ಆಗಿರ್ಬೇಕು.
ಕಾಮನ್ ಆರ್ಡರ್
ಮತ್ತೆ ಯಾವಾಗ ಹಾಕ್ತೀರಾ ಮಿಸ್ಟರ್ ಮಧುಕರ್ ದೇಶಪಾಂಡೆ?
Within a week we'll file.
2023 ಪೆಂಡಿಂಗ್ ಇದೆ. ಯಾವತ್ತರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿತ್ತು? ಕಾಮನ್
1/1/2023.
Production of additional evidence. Respondents accepts notice for respondent, find their memo of appearance in the registry within 2 weeks ಅಂತ ಆಗಿದೆ. 12/1/2023 1.5 years ಆಯ್ತು. At request, finally 2 weeks time is granted to file memo of appearance or wakalat for by Shri Madhukar and Deshpande for respondent. ಇಲ್ಲಾಂದ್ರೆ ನಾವು ನೋಟಿಸ್ ಮಾಡ್ತೀವಿ, ಯಾರ ಬಂದು ಯಾರ ಅಪಿಯರ್ ಆಗ್ತಾರೆ, ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ.
Finally, 2 weeks time.
Which is this authority? ISRO. ಇನ್ನೊಬ್ರು ಯಾರೋ appear
Beneficiary
ಆಗ್ತಾರೆ.
ISRO madam.
Assistant Commissioner, Land Acquisition Officer, Doddaballapura Subdivision.
Government.
Land acquisition officer, I am appearing.
Government, ISRO.
ISRO is,
ಬೇರೆ ಮತ್ತೆ ಯಾರ ಇದಾರಾ? Panel advocates. ನೀವು ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ
ಇಲ್ಲ, finally we'll file madam.
19.9 ಇಂದ finally 2 weeks time granted to Shri Madhukar Deshpande to file memo of appearance for R2. ಇಲ್ಲಾಂದ್ರೆ ನೋಟಿಸ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. 19.9 ಇಂದ 19.15 ವರೆಗೂ ಅದು.
ಆಮೇಲೆ
17 ಸೇಮ್ ಇದೆ. 17 ಅದನ್ನು ಅದ್ರಲ್ಲಿ ಹಾಕೊಂಡ್ಬಿಡಿ. ಇಲ್ಲೊಂದು ಯಾವ್ದೋ ಅಷ್ಟೇ ಇಲ್ಲ, 17 ವರ್ಗು
ಕಾಪೀಸ್ ಕೊಟ್ಬಿಡಿ, ಕೊಡ್ಲಿಲ್ಲ ಅದೊಂದು ಇನ್ನೊಂದು
ಕೊಟ್ಟಿದ್ದೀನಿ ಎಲ್ಲರೂ.
ಅವಾಗ್ಲೇ ಕೊಟ್ಟಿರ್ತಾರೆ. ಎಸ್ 2 weeks ಅಂತ ಹೇಳಿದ್ವಲ್ಲ ಅಂದ್ರೆ.
For admission, cell number 20, R.B. Sadashivappa, Padma S. Suttur.
ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರೆ
Plaintiff appeal, my lord. First respondent is her husband. He retired superannuation in the year 2011. But in the service registered, my lord, he illegally entered the name of the sixth respondent. Whereas other proceedings, my lord, the first respondent has categorically admitted appellant is his wife, and marriage is taken place in the year 1983. Since, my lord, they have no children, my lord, he has taken a sixth respondent, and he has produced the documents, my lord. He has married the sixth respondent, Arya Samaja, in the year 1978.
According to you, she was taken in adoption by this couple.
No, my lord, I am the legally wedded wife, not in dispute. He attained superannuation in the year 2011. Since, my lord, he has no children, my lord, with the appellant, he has taken sixth respondent.
ಮಗಳು ಅಂತ ನೀವ್ ಹೇಳೋದು.
ಅಲ್ಲ,
Adopted daughter ಅಂತ.
ಅಲ್ಲ, sixth respondent as a wife. He has taken sixth respondent.
Adoption.
taken ಅಂತ ಹೇಳ್ತಾ ಇರಲ್ಲ, he has got married.
And he has produced the documents, my lord. He married sixth respondent in the year 1978, somewhere in Arya Samaja. Whereas, my lord, the other legal proceedings, whereas, my lord, the first respondent jointly filed the.
Is his relationship with this lady?
No, he never denies.
Then what he said? He says she is second wife.
She's, my lord, the second wife. He says, my lord, the appellant is the second wife.
But age wise, ಅವರೇ ದೊಡ್ಡವರಿದಾರಲ್ಲ. That lady is senior.
Now, first respondent is no more. In the service registered, my lord, the name of the sixth respondent, my lord, he is forthcoming. If the statutes permits, my lord, I am also entitled 50% of the pension. That's all, my lord. He has to say, my lord, the KPTCL. If the statutes permits, my lord, so far as, my lord, the other department, railway department and other department, my lord, it is permissible, my lord, even the second wife also entitled pension. If the KPTCL, how you separate, they have made separate regulations for that.
ಅವ್ರದ್ದು ನಾವು ಹಿಂದೆ ಕಲಬುರ್ಗಿ ಒಳಗೆ ಕುಂತಾಗ ಕೇಳ್ತಿದ್ವಿ, ಏನು ರೆಗ್ಯುಲೇಷನ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಸರ್ವಿಸ್ಗೆ. Now they have done it.
I'll find out, kindly have this matter next week. I'll find out and place it on record.
just come.
Just come there.
Regulations is same, I think. Sir, ಆಗಿದಾರಲ್ಲ, Jescom ಯಾರಿಲ್ಲ?
ಎಲ್ಲರೂ ಆಗಿದ್ದಾರೆ.
I represent.
Records call for.
ಮತ್ತೆ private respond ಗೆ?
Private response, is served through paper publication.
My lord, he is the son through sixth respondent. The same was served through substituted service, my lord.
This for final. Or R3 and 5 ಯಾರೋ appear ಆಗಿದ್ದಾರೆ, R6 ಗೂ appear ಆಗಿದ್ದಾರೆ. 4, sir.
That's for 2, 3 and 5 minutes I represent.
ನೀವು ನೋಟಿಸ್ ತಗೊಂಡಿರ್ಲಿಲ್ಲ ನಿಮ್ಮ ಹೆಸರು 2, 3, 5 ಪದ್ಮಾ ಉತ್ತೂರ್ ಅಂತ.
Please, I represent Padma.
ಪದ್ಮಾ.
Yes.
ಇಲ್ಲ ಜಸ್ಕಾಮ್ ನೀವು appear ಅಲ್ಲ.
ಹೌದು, ಅವರು
Jescom ಇಲ್ಲ sir.
ಅವ್ರಿಲ್ಲ ಅಲ್ಲ, ಅವ್ರ ಹೆಸರು ತೋರಿಸಿಲ್ಲ. R4 ಸುಬ್ಬಾ ಶಾಸ್ತ್ರಿ ಫಾರ್ R6, R4 third unrepresented ಅಂತ ಇದೆ. He is appearing for R2, 3 and 5.
2, 5.
R1 is dead ಅಂತ ಹೇಳಿದ್ರಿ.
R1 is dead.
R1A, who is R1A?
Son, he is a son begot through sixth respondent.
He is held sufficient ಅಂತ ಆಗಿದೆ. ನೀವು ಜಸ್ಕಾಮ್ ಪೆನಲ್ ಮೇಲೆ ಇದ್ದೀರಾ?
ಇಲ್ಲ ma'am.
ಮತ್ತೆ ಯಾರಿದ್ದಾರೆ ಇದ್ದವ್ರು ಯಾರಿದ್ದಾರೆ ಜಸ್ಕಾಮ್? Are you aware?
Discom, my lord, Devraj is there, my lord.
HV Devraj.
HV Devraj.
Our copies are.
Yes, I will get,
please.
please, my lord.
Correspondent report, Jescom, those served as unrepresented. Shri Arori and
HV Devraj.
HV Devraj, one is standing counsel for respondent number 4 is requested to accept notice for respondent number 4. His name shall be shown in the process accordingly. Appellant's counsel shall serve the copies on him.
Yes, my lord.
Final hearing ಗೆ ಹಾಕೋಣ.
ಆಯ್ತು. Any date, my lord.
Admit. List for final hearing on 2 ವಾರ ಬಿಟ್ಟು. ಅವ್ರ ಕಾಪಿ ಸರ್ವ್
Please,
ಮಾಡ್ತೀನಿ ಮತ್ತೆ ಅವ್ರ ಬಂದು ಡೇಟ್ ಕೇಳಿ.
15/7.
Much of.
Till number 21, Sanat Kumar Shetty, Narkat Bandal.
He appeared for the appellant.
My lord, I appear for the respondent number 3. I have not been served the copies, my lords, so far.
I am for respondent number 1.
Is under the,
The protection order is not granted.
ಅಲ್ಲ ಇದು ಡಿಸ್ಚಾರ್ಜ್ ಕೇಳಿದ್ರು ಅದನ್ನು ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿಲ್ಲ.
Discharge ಅಲ್ಲ. Protection order ಕೇಳಿದ್ರಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇದೆ.
ಅಲ್ಲ ಡಿಸ್ಚಾರ್ಜ್ ಅದು ಮೊದಲು ಕೊಟ್ಟಿಲ್ಲ. ಅದರ ನಂತರ ಈ ಅಪೀಲ್ ಇಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಆರ್ಡರ್ ರಿಫ್ಯೂಸಿಂಗ್ ಟು ಡಿಸ್ಚಾರ್ಜ್ ದಿ in view of the subsequent events. My client may not pursue this matter. In view of the subsequent events, my client may not pursue this
What is
matter.
the subsequent?
ಅದಕ್ಕೆ ನಾನು ಮೆಮೊ ತಗೊಂಡವ್ರು 1 week time may be given.
ಹೌದು ಕರೆಕ್ಟ್. ಅಂದ್ರೆ you have challenged the order dated.
IA 3 and 5 are challenged. IA 3
There appellant says that.
ಎರಡು order.
Order dated 6/2/2016
ಹೌದು.
and IA 5.
ಹೌದು. ಒಂದರಲ್ಲಿ IA 5 ಇನ್ನೊಂದರಲ್ಲಿ IA 3. Both are for
IA 2.
discharge.
2 and 4 ಇರೋದು.
ಅದು ಬೇರೆ ಅದು ಬೇರೆ ಅದು ರಿಟ್ ಹಾಕಿದಾನೆ ಅದು ಅದೆಲ್ಲ ಈಗೆಲ್ಲ ವರ್ಚುವಲಿ ನಾಟ್.
So.
Next week it may be posted. If my client doesn't pursue, I will file the memo and.
2016 ಅಂದ್ರಲ್ಲ.
ಹೌದು.
IA 3 under section 41 of the act is
ಹೌದು.
hereby rejected.
Reject.
This application was not to arrest ಅಂತ ಕೇಳಿ.
ಅಲ್ಲ ಅದು
IA 4 filed by 3 filed.
IA
by
4
whom?
is different.
And IA 5 is filed by whom?
IA 5 is filed by the appellant seeking discharge of the.
ಇದು IA 3 and 5. ಅಲ್ಲೇ ಡಿಸ್ಕಷನ್ ಮಾಡುವಾಗ. So your application was rejected.
Yes, ma'am. Under the Insolvency Act, we were declared as insolvent.
You may not press it on that.
May not.
Appellant submits. He, appellant may not press the matter and seeks to take further instructions. List on. Copy ಕೊಡಿ in the meantime.
10 days.
10/7.
In the meantime, the appellant's counsel shall serve the copies on the counsel
Yes.
correspondent number 3. Yes.
Obliged.
ಈಗ ಇನ್ನೊಂದು memo for accept paper 21.1 ನಲ್ಲಿ.
Same.
ಎರಡು.
Same. Two different appellants.
ಅವ್ರು ತಗೊಂಡಿದ್ದಾರಲ್ಲ ಅಕ್ಕಮಾದೇವಿ ರೇವಟ್ has taken notice.
Yes, my lords, copies are not served. We have only after the paper publication.
I held sufficient ಅಂತ ಆಗಿದೆ ಕರೆಕ್ಟ್.
Yes. Yes, my lords, after paper publication, I have filed my wakalat.
ಕಾಮನ್ ಅಲ್ವಾ 3682 3683 ಓ ಇಲ್ಲಿದೆ ಹೆಸರು ಇದು ಬರಿಬೇಕಾದ್ರೆನಾ ಓಕೆ ಬರ್ಕೊಳ್ಳಿ ಇದರಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿ 21.1 ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಆನ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 entry was held sufficient ಬರ್ಕೊಳ್ಳಿ ಯಾರು ಶ್ರೀಮತಿ ಅಕ್ಕ ಮಹಾದೇವಿ ಅವ್ರ ಹೆಸರು ತೋರಿಸಿದಾರಾ ಹಿರೇಮಠ
ಇದು ಎರಡಲ್ಲೂ ಇದೆ.
appear for respond number 3. Is elderly, he is going to withdraw both the matters.
ಅದೇ I seek instructions and
Appellant's counsel shall serve the copies and counsel for respond number 3. List down and the date readable.
Seal number 22, M. Narayan Swami.
I appear for the appellants in this case and connected appeals, my lord. It is
Non-filing. Copy serve ಮಾಡಿದಾರ
copies, in fact, I served on R1 in all the 4 cases. In
the appellant here.
ಇದು ಕೊಟ್ಟಿಲ್ಲ 6869
today, in another case, in 2 appeals I have served. Today I am serving 2 cases today, my lord, on my learned friend.
bit of access 16
Getting
69
service of notice of order
70
connected. ಒಂದೊಂದಾಗಿ
70 72
ಈಗ ಕಾಪಿ ಬಂತ
68
ಸರ್ಡ್
ಒಂದು
ತಗೊಳ್ಳಲ್ವಾ
ಒಂದು ಕೊಟ್ಟಿಲ್ಲ ಮೇಡಮ್ 1036
ಇದು 10,370 ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರಾ
370 ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ
370
ಹಾ
ಕರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಒಬ್ಬರಿಗೆ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ
ಕೊಡೋಣ ಎಲ್ಲ ಕೊಟ್ಟಿದೆ.
copies are served on him. Therefore, office objections should comply. 22.1 ನಲ್ಲಿ awaiting service of notice of R2.
368 ಇವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್
On filing of memo along with acknowledgement has served the copies on advocate for R1. Copy serve ಮಾಡಿದ್ರ?
Copy not served.
ಅಲ್ಲಲ್ಲ, for R1 we have served copies and
serve ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ ಮಾಡಿದೆ. In fact, other colleague has taken, we don't mind in serving again.
R2 ನೀವು ನೋಟಿಸ್ ತಗೊಳ್ತೀರಾ ಇದ್ರಲ್ಲಿ?
ಹಾ ತಗೊಂತೀವಿ ಸರ್ ಕೆಬಿ ಮೋನೇಶ್ ಕೆಬಿ ಮೋನೇಶ್ BWSS
R2 is BWSSP. In await service ಅಂತ ಇತ್ತು. ಶ್ರೀ ಕೆಬಿ ಮೋನೇಶ್ ಕುಮಾರ್ ಲರ್ಡ್ ಕೌನ್ಸಿಲ್ ಅಂಡರ್ಟೇಕ್ಸ್ ಟು ಅಪಿಯರ್ ಫಾರ್ R2.
ಎಸ್
ಕಾಪಿ ಸರ್
ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್.
It is submitted that the copies are served. Therefore, office objections should comply. ಅದರಲ್ಲಿ ಮುಗಿತು 22.2 ನಲ್ಲಿ
ಅದರಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಸರ್
ಸರ್ವ್ಡ್ ದ ಕಾಪಿ
Yes.
10,369
ಅದು ಕೊಟ್ಟಿಲ್ಲ ಸರ್ ಅದು
ಕೊಟ್ಟಿದೆ.
ಅದು BL ಸಂಜೀವ್ ಸರ್ ನೋಟಿಸ್ ಆಗಿತ್ತು
Received the copy, acknowledgement is.
We will serve again.
that case.
We are appellant.
ನಾರಾಯಣ ಸ್ವಾಮಿ ಅಲ್ಲ 22.2 ನಲ್ಲಿ ನೀವು ನಾರಾಯಣ ಸ್ವಾಮಿ ಅಲ್ಲ
ಇಲ್ಲ, he is my colleague. I am representing.
ಓಕೆ ಅವರು ನಾರಾಯಣ ಸ್ವಾಮಿ
Yes, madam.
ನಮಗೆ ಗೊತ್ತಾಗೋದಿಲ್ವಲ್ಲ
Yes, my lord, yes, ma'am.
ಯಾರು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ತೀರಿ ಅವ್ರೆ ಅನ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ ಈಗ ಇದ್ರಲ್ಲಿ ಸಂಜೀವ್ ಸರ್ವ್ ಮಾಡಿದ್ರ ಅವ್ರು ಇಲ್ವಲ್ಲ
ಅಲ್ಲ, we don't mind in serving again because it's all arising out of the.
ವಕಾಲತ್ ಆಲ್ಸೋ
69 ಅಲ್ಲಿ.
Mr. BL ಸಂಜೀವ್ has filed ವಕಾಲತ್ ಇದ್ದಾರೆ BL ಸಂಜೀವ್ ಫಾರ್ R2 ಅಂತ ತೋರಿಸಿದೀವಿ ಇನ್ನು ನೀವು ಮೆಮೋ ಆಫ್ ಅಪಿಯರೆನ್ಸ್ ಹಾಕಿಲ್ಲ ಇಟ್ ಅಪಿಯರ್ಸ್ ನೋಡಿ ಇದ್ರಲ್ಲಿ ಸಂಜೀವ್ನವ್ರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಎಸ್ ಈ ಎಲ್ಲ ಸೀರೀಸ್ ಒಂದೇ ಇದ್ರೆ ಒಬ್ರು ಹಾಕಿ
My lord, all the 4 cases are arising out of the same common judgment and award.
ವಕಾಲತ್ ಇಲ್ವಾ ಹಾಗಾದ್ರೆ ನೀವು
I will take my name may be KB Manish Kumar.
ನೀವು ಅದಕ್ಕರ್ ರೆಸ್ಪಾಂಡ್
ಇಲ್ಲ KB Manish Kumar colleague.
ಸರಿ ಮನೇಶ್ ಕುಮಾರ್ ಸರಿ ಶ್ರೀ BL ಸಂಜೀವ್ has not filed ವಕಾಲತ್ in this case. Therefore, Shri KB Manish Kumar is requested to accept notice for respond number 2. He shall file the wakalat in the registry within 2 weeks. He submits that copy served.
ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಸರ್ 369 ಅಲ್ಲಿ
ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
ಆಯ್ತು
ಎಲ್ಲರಲ್ಲೂ ಕೊಟ್ಟಿದೆ.
ಅಲ್ಲ, ಕೊಡೋಣ, ಇನ್ನೊಂದು ಕೊಡೋಣ. ಅಲ್ಲ, we will give nothing. There is no problem as such because common judgment and award, 1 copy is enough. Yes, except change of the extent.
Right.
Verbatim repetition in all the appeals.
ಎಲ್ಲ ಬೇರೆ ಬೇರೆ ಇರುತ್ತಲ್ವಾ ಸರ್ವ್ ದ ಕಾಪಿ
ಅಲ್ಲ, ಕೊಡ್ತೀನಿ ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ.
ಅಪೆಲೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್ ಶಾಲ್ ಸರ್ವ್ ದ ಕಾಪೀಸ್ ಅಲ್ಲಿ ಸರ್ವ್ಡ್ ಅಂತ ಬರ್ಕೊಳ್ಳೋದು ಆಮೇಲೆ ಇನ್ನೊಂದು 22.3 ಅಲ್ಲಿ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಮೆಮೋ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಸರ್ವ್ಡ್ ದ
ಅದು ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ
10,370.
Sir.
Response counsel submit that copies are served on him. Therefore, office of sections should comply. ಅದನ್ನು ಒಂದು ಅವ್ರು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ, ನೀವು ಹೇಳಿದ್ರೆ ಅದೊಂದು ಕ್ಲೋಸ್ ಆಗುತ್ತೆ.
ಆಯ್ತು ಸರ್.
ನೀವು ಕೊಡ್ಬೇಕಷ್ಟೇ, ಜೆಂಟಲ್ಮೆನ್ಸ್ ಪ್ರಾಮಿಸ್.
Yes, yes, yes. In fact,
ಹಂಗಾಗಿ 22.2 ನಲ್ಲಿ ಬರ್ತದೆ ಅದರಲ್ಲಿ ಅದು ಹೊಸದಾಗಿ ಬಂದಿಲ್ಲ. KV Manish Kumar, lower counsel submits that he has received the copies. Office of sections should comply. ಈಗ ಇದರಲ್ಲಿ ಅಡ್ಮಿಟ್ ಆಗ್ಬೇಕಾಗಿತ್ತ?
admit ಆಗಿಲ್ಲ. All the cases are arising out of the same common in judgment and award.
ಆಗಿದೆ. ನೋಡಿ 22.1 ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
ಇಲ್ಲ, appeal not admitted.
Not admitted, my lord.
ಯಾವುದೇ ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
ಯಾವ್ದು ಆಗಿಲ್ಲ.
ಹಂಗಂದ್ರೆ ಎಲ್ಲದರಲ್ಲೂ TCRs ಬಂದಿದೆ ಅಂದ್ರೆ.
ಬಂದಿದ್ರೆ your lordship may kindly admit the appeals and post it for hearing, my lord. The 2018 matter, it's only for announcement.
ಕಾಮನ್ ಆಗಿ ಬರಬೇಕು. Admit, post for final hearing. ಯಾವಾಗ ಕೊಡೋದು?
18 matter.
2018 ನಮ್ಮ ಇದಕ್ಕಿಂತ ತುಂಬಾ ಹಳೆ LIC.
Your lordship fix a date any day convenient to the court. 16/7.
16/7.
Much of.
ಈಗ ಅದ್ರಲ್ಲಿ ಹೀಗೂ ಮಾಡ್ಬೋದು ನೋಡಿ, ಯಾಕಂದ್ರೆ ಎಕ್ಸೆಪ್ಟ್ ಒಂದು ಅವ್ರ ಸಂಜೀವ್ ಆಗಿದ್ಬಿಟ್ಟು ಉಳಿದಿದ್ದ ಎಲ್ಲದ್ರಲ್ಲೂ ಅವರೇ ಮನೇಶ್ ಕುಮಾರ್ನೇ ಅಪೇರ್ ಆಗಿದೆ. ಅದಕ್ಕೆ ಅದನ್ನೊಂದು ಹೀಗೆ 22.2 ಮೊದಲು ತಗೊಳ್ಳಿ, ಅದರಲ್ಲಿ ಅದು ಹೇಳಿದ್ವಲ್ಲ, ಆದ್ಮೇಲೆ ಮನೇಶ್ ಕುಮಾರ್ ಟೇಕ್ಸ್ ನೋಟಿಸ್ ಆದ್ಮೇಲೆ ಆಮೇಲೆ ಎಲ್ಲಾನು ಕಾಮನ್ ಆಗಿ ತಗೊಂಡು KV Manish Kumar submits that he has received the copies. Therefore, office of sections should comply. ಅದಾದ್ಮೇಲೆ admit, list for final hearing now.
16/7. Till number 23. Ranjan Kumar K.
For the appellant, my lords. The appellant is the husband and the respondent is the wife, my lords. The wife has filed the divorce petition under the.
You are agreed only by the permanent alimony?
Yes, my lords. Permanent alimony is 20 lakhs, my lords.
Correct. ಈಗ she has not appeared.
Yes, my lord.
As per RG circular ಅಂತ ಏನ್ ಹಾಕಿದ್ದಾರೆ?
They have no.
ನಾವು ನೋಟಿಸ್ ಪ್ರಕಾರ ಇಲ್ಲಿ ಕೂಡ ನಾವು ಇದು ತಗೊಳ್ತೀವಿ. You have to submit your affidavits and affidavit of assets and liabilities as per the judgment of Supreme Court.
Yes, I'll file, my lords.
ಅವ್ರಿಗೆ ಯಾಕೆ ಅಪಿಯರ್ ಆಗಿಲ್ಲ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ she only had filed the petition. For the appellants, counsel, admit call for TCRs. Appellants counsel shall submit the affidavit of his assets and liabilities in terms of the judgments of Supreme Court, judgment of Supreme Court in Rajneesh versus Neha, other citation court. List on.
Lord, stay, man.
Stay deposit ಮಾಡಬೇಕು ಎಷ್ಟಾದ್ರೂ. ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇದ್ದಂಗೆ ಕಾಣ್ತಾ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಇದೆ ಮ್ಯಾಮ್. It's there, ma'am.
ಎಲ್ಲಿದೆ ಅಪ್ಲಿಕೇಶನ್?
Section 39.
41.5. ಅದಕ್ಕೆ ಲಿಸ್ಟ್ ಮಾಡಿರ್ಲಿಲ್ಲ ನೀವು. 50% ಅದು ಎರಡು ಮಕ್ಕಳಿದ್ದಾರೆ ಈ ಕೇಸಲ್ಲಿ.
Yes, my lords.
There are 2 children. ಮತ್ತೆ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಇಂಟ್ರೆಸ್ಟ್ ಟೈಮ್ ಅಂತ ಬರ್ತಾರೆ.
My lords, in the judgment, in the page number 30, my lords.
Subject to the appellant depositing 50% of the decretal amount before the 50%. The amount ಹೇಳ್ಬಿಡೋಣ. Rupees 10 lakhs before trial court ಅವಾಗ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗುತ್ತೆ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡಿದ್ದಾರಾ?
No, my lords.
ಅಲ್ಲಿ ಡ್ರಾ ಮಾಡಕ್ಕೆ ಅವ್ರಿಗೆ ಈಸಿ ಆಗುತ್ತೆ. Before the trial court, within ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಕಟ್ತೀರಿ?
My lords, 10 lakhs because she has stated she is working in beauty parlor, my lords. Her salary is 5 lakhs, 5,000, my lords.
It is granted to wife and children both.
Yes, my lords, but 20 lakhs is
ಇದರಲ್ಲಿ ಎರಡು
much
ಮಕ್ಕಳಿದ್ದಾರೆ.
higher, my lords. There's no documents also produced, my lords.
Children are with her only.
You have not disputed that they are your children.
Yes, ma'am.
They are with
You
her
have
only.
only disputed whether Hindu Marriage Act applies to, Indian Divorce Act applies to you or not.
My lord, that's not,
Cruelty.
yes, ma'am. Cruelty is not been admissible.
Correct. ಇಬ್ರು
And-
ಮಕ್ಕಳಿಗೆ ಆದ್ರೂ ಕೊಡ್ಬೇಕಲ್ಲ 10 lakhs within 4
But
weeks from the date of.
10 lakhs is much higher.
List on 4 weeks on.
29/7.
29.
Cell number 24 adjourned. Cell number 25, Abram Kadambi, case Mahadevan.
Lord, this is that matter relating to limitation, my lord. That is, when there is a claim, does a fresh cause of action arise on account of the liquidator taking charge or not, my lord? That was the question posed by your lordships.
I mean, cause of action to him arises only on filing.
Please, that was the question posed by your lordships. The question is in fact answered by a full bench judgment of our court, my lord.
The original debt was not time barred before.
Original debt was not time barred, and I'm not even contesting it.
It was not.
It was not time barred. It was not time barred.
So the question is this 1 year, whether it commences from he receiving
Him receiving the statement of affairs and so on, which is what the learned company judge does. Would your lordships, my lord, please see the question posed by the court that was referred is at the bottom of the first page itself in the head note.
correct period of limitation.
For claims to be made under section 446 of the Companies Act, having regard to the provision in section 458A of the Companies Act. Would your lordships be kind enough to please turn to para 10.5, my lord, at internal page 307. May I read, my lord?
Yes.
Section 446 of the Act does not create any right or obligation. It only provides for filing of suits, claims, and other proceedings as set out in subsection 2 of 446 of the Act before the court winding up the company instead of a regular court. As already pointed out, it also provides for deciding of suits and proceedings filed and pending on that date, the winding up order passed by the company, by the court winding up the company. Section 446 of the Act does not prescribe any period of limitation. The period of limitation for suits, applications, or claims as set out in sections A to D of subsection 2 of section 446 is governed by relevant provisions of the Limitation Act or the provisions of the other law prescribing the limitation for the same. Therefore, on a reading of sections 446 and 458A, in the context these sections occur, it is not possible to hold that the cause of action for any claim, suit, or proceeding or application by or against the company to be instituted will accrue only on appointment of official liquidator as provisional liquidator. It is relevant to notice that the official liquidator only enforces or recovers the enforceable claims of the company which is being wound up and collects the assets of the company and settles the liabilities. If on the date of the commencement of the proceeding of winding up of the company, any claim by or against the company under the relevant provisions of the Limitation Act or any other law for the time being in force had become barred by time, the fact of passing of the winding up order and appointment of a provisional liquidator does not.
Whether as on the date of the filing of the petition.
Please, my lord.
This debt was time barred.
It was not time. I'm conceding that point. What I'm relying on is the previous sentence, my lord. That is, it is relevant to notice that official liquidator only enforces or recovers the enforceable claims of the company.
He steps into the.
He steps into the shoes. Exactly right, my lord. So the only exclusion that is available.
That submission you made on the last.
Please, my lord. So therefore, the only exclusion that is available is what is provided in 458A. Nothing new accrues to him on account of him taking charge as official liquidator of the company. Same principle, my lord, in fact, is reiterated in para 21 also.
The action and subsistence of the claim right except does not depend upon the passing of the page.
Both are quite para 21, my lord. Page 323. This is the answer that the court prefers. May I just read, my lord? Para 21. The correct period of limitation for claims under section 446(2)(b) is the relevant article in the Limitation Act as applicable. I'm sorry.
Page number?
Page 323, my lord.
Para 21.
Para 21.
311 also there is one para 21.
I'm sorry, perhaps that's some other judgment that was extracted. I'm sorry, my lord. This is the end of the judgment, 323.
Yes.
For reasons stated above. Our answer to the question referred to the full bench is as follows. The correct period of limitation for claims made under section 446 2B of the Companies Act is the relevant article in Limitation Act 1963 as applicable to the nature of the claims. Whether the claim is enforceable or not is to be determined with reference to the relevant article in the Limitation Act as applicable to the nature of the claim and not with reference to the form by which the claim is enforced or by who or through whom it is enforced. In a given case, if the claim does not fall under any of the relevant articles in the schedule to the Limitation Act, the residuary article 137 will apply. The expression when the right to apply accrues has to be decided with reference to the right of the company and the nature of the claim. In other words, as to when the right to recover the claim accrued to the company and not on the basis that the right to apply accrues only on the date the winding up order is passed or the official liquidator is appointed as provisional liquidator, as the liquidator enforces the claim of the company. Now, this is what I'm placing reliance on. Which is to say that merely because he is thereafter appointed does not mean that there's any fresh cause of action that accrues in his favor. But 446 2B is what the application filed by the official liquidator in our case is also.
Before the fourth, which is winding up. Hmm, 446 2B.
Please, my lord. Because this is a claim made by the company.
There is no limitation prescribed.
They say for this 446B,
Please, my lord.
applicable limitation, provision. of
Absolutely.
applicable-
137 applies. There is no difficulty.
So that is the law laid down there.
That is the law.
This
And
distinction between 458, that is not discussed there.
my lord, 458A, can I just
458A,
No, 458A is a different aspect altogether, madam.
let him submit, then he can,
Right.
notwithstanding anything, notwithstanding.
notwithstanding anything in the Indian Limitation Act or in any other law for the time being in force, in computing the period of limitation prescribed for any suit or application in the name of and on behalf of the company which is being wound up by the tribunal, the period from the date of commencement of the winding up of the company to the date on which the winding up order is made, both inclusive, and a period of 1 year immediately following the date of the winding up order shall stand excluded. So therefore, this is not a new period of limitation that is prescribed.
Correct here,
Please, my lord.
the company was ordered to be wound up,
Yes, my lord. My lords may please have the,
of winding up and.
my lord, I'll just tell your lordships the key dates, my lord.
Once.
Yes.
You have mentioned it in your.
I have given a short list of dates also, my lord. And it's there in the list of dates along with my petition also.
Hmm.
Please, my lord.
You are one of the,
I am one of the persons against, he says that I'm a debtor of the company in
of
liquidation.
the company.
Yes.
Now, when the company was ordered to be wound.
My lord,
winding up
in fact,
petition
even before that, winding up petition was filed on,
for 2012 is a winding up petition.
petition being filed. So that is commencement of winding up under the act.
Petition. Okay.
31/7/2015 is the winding up order,
31/7.
2015.
Winding up order
Please, my lord.
by this court.
And thereafter, he gets 1 year.
Appointment, when he was appointed,
He is appointed under the winding up order itself.
under the winding up.
Please.
For exclusion of. ಇಲ್ಲಿ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿರೋದು
ಆ period exclude ಮಾಡ್ಲಿ. I'm saying give him the complete benefit.
In computing the period of limitation, period from the date of the commencement of the winding up
Please,
the company to the
Till the-
date when it is wind up.
please.
wound up.
So that is
And
in our case,
Period of 1 year immediately following the date of winding up order.
absolutely. So therefore, the period from
31/7/2015 to
31,
37/2016.
please, my lord.
This application was filed on
This application, my lord, is filed on 19/4/2023.
Yes.
And my lords, respectfully, the learned company judge relies on the date on which the statement of affairs is filed.
So it
Which,
is interpreted like that.
my lord, in my respectful submission, limitation has to be interpreted strictly. If an exclusion has to be provided, it has to find force in the statute. What 458A does is only excludes these periods, no other period.
This is 100 petition is 119 of 2020.
Please, my lord. CA 119. The petition itself begins at page 45, my lord.
Page 42.
The application. And your lordships will see at page 46, it is under 446 2B. And this is seeking recovery. My lord,
6 crores 48 lakhs
Please.
42,830.
please, my lord.
All supported documents. So when they came to know about this pendency of this debt,
From, my lord, some background is required, my lord. I'm sorry for. My lord, when a winding up order is passed, this honorable court becomes custodian, virtually a owner of the property of the company in liquidation. It vests with this honorable court according to 456. This honorable court is the owner of the property, everything. Official liquidator is only custodian of those properties where I act according to the Companies Act and the orders of this honorable court as a company did. Well, company petition is filed. After winding up order is made, OL will not know anything about any of the company.
that
No,
one, already.
I'm sorry, my lord. To arrive at my contention that, my lord, 458A, I am not on the point that limitation is required to be extended at all. No, I am only requesting this honorable court to consider my limit, when the limitation starts, cause of action. That is the only question arising out of this case. My lord, the ex-directors are required to file statement of affairs and required to hand over books and records to me under 454. If they are not handing over books and records, I will not know anything about the company at all.
Winding up petition,
Please, my lord.
winding up petition was
One
filed
of
by
the creditors of the company in liquidation.
that order is here.
My lord, that order is not here, my lord.
You have the copy of that?
My lord, I was not a party to those proceedings.
Correct.
I will get the copy, my lord.
Of the creditor had filed.
Please, my lord.
Yes,
No difficulty.
These respondents were the directors and the company.
yes.
No, my lord, not no, my lord. It was only the company in liquidation. That is all. I was not a party. None of the directors were a party.
Show us the order, either of you.
I can get the order, my lord. It may be taken up some other day, my lord. I will.
Where to do all these exercises, only 1 year extensions. Here, 137, 3 year extension because of Company Act. Because he should collect everything and claim. That is saved. But he can't ask for till the filing, then I'll wait. They will not file 20 years. The limitation is extended. This one.
So brother is saying when you are appointed as a.
1 year extension is
You
given.
have to enforce your powers.
1 year under legislation is given to do all these exercise only.
My lord,
Not If the 10 years they will not file the statement of affairs,
My lord, my lord.
can limitation be extended for
No,
that?
what are your power? You can enforce that, no?
My lord,
Can we read into something which is?
Lala, 1 year is given for me to verify the books and records, provided he hands over the books and records to me. I will take a hypothetical question, my lord. My lord, winding up order is passed, my lord. Ex-directors is required to hand over books and records to me.
Non-filing penalty is there, criminal proceedings are there against directors, no?
Huh?
Please. Does not file the statement of affairs.
My lord,
no
it's a
power-
criminal offense, my lord. Fine is one, no, only fine is imposed, my lord. I have no right.
But it is your fault, sir.
See, you-
My lord, in the,
Limitation.
my lord, 1 minute, my lord.
You can sleep over the matter. You should show us that you had done something.
My lord, your lordship may kindly take page 36, my lord. Order, my lord. It gives a clear picture, my lord. Impugned order, my lord. Page 36, my lord. In page 36. May I read, my lord?
Yes.
Page, the objection, so and so, my lord. The company application is hopelessly barred by. In this regard, he submit that the first company petition of winding up COP is filed on 18/4/12. The winding up order have been passed in 2015. Any proceeding that the official liquidator ought to have taken before 30/7/2016 in terms of section 458A of the Companies Act. No action has been taken within the period of time. The claim of the officiality is hopelessly barred by time. His first alternative submission is that the demand having been made by the company in liquidation 19/12/2011, any proceedings ought to have been taken by 18/12/2014. The period from the filing of winding up petition and the order of winding up 1 year in terms of the section 458A is excluded. The proceedings could have been filed by 31/3/2019, taking into account the exclusions of the same not having been done, the claim having been made only so and so period of more than 3 years.
Their
My lord,
continuations are extracted.
continuation is there, para 4 is para 4 ಅಲ್ಲಿ ಇದೆ reason. Next para.
Para 4 ಅಲ್ಲಿ ನಿಮ್ ಸಬ್ಮಿಷನ್ಸ್ ಹೇಳ್ತಾರೆ. ಅಲ್ಲ ರೀ, ಅವ್ರದ್ದು ರೀಸನಿಂಗ್ ಏನಂತ ಹೇಳೋದ್ ಬಿಟ್ಟು ಬರೀ ನಿಮ್ದು ಇಬ್ಬರದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಅದನ್ನ ಓದಿ ಅಂತ ಓದಿಸ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ para 4 ನ para 5 ನಲ್ಲಿ whatever I have submitted in para 4 has been said yes by this honorable court in para number 5.
Now that is questioned here.
Yes, para number 5 ನಲ್ಲಿ ಯಾತಕ್ಕೆ ಕೇಳಿದಾರೆ ಅನ್ನೋದಕ್ಕೋಸ್ಕರ ಇದೆ. Para 4 ಅಲ್ಲಿ the statement of affairs of the elsewhere directors of page 38. The statement of affairs of the erstwhile directors was filed on 1/7/22, and the custody of all documents and books and accounts are handed over 23/5/22. Unless
ನಾವು ನಿಮಗೆ ಅದನ್ನ ಕೇಳಲ್ಲ. We asked a simple question of law.
Yes.
Now the companies, as per section 458, what is excluded is 4 years, right? Even is assuming that the debt was live on that date. Now,
but 4 years.
You had all the powers to enforce. You say that accounts were not submitted to you, therefore you were handicapped. You were not aware of their debts.
Yes.
It was not the debt due to you. It was the debt due to the company, right? So company had to give you. If they did not give, you had the powers to enforce that. But why did you not do that? Now, can we say after 7 years?
Powers to enforce is there in 454, where only criminal fine is imposed. There,
ಅಷ್ಟು ಪ್ರೆಷರ್ ಆದ್ರೆ ಬರ್ತಾರಲ್ಲ ಅವರು.
ಅಲ್ಲ our letter, winding up order passed on a particular date, after
answer our question. What action you took when they did not submit the accounts within that 1 year? What action you have taken?
There is a 454 application. There's criminal action. There is no civil action there.
Have you filed that?
Yeah, then 454 application. We have filed, and the delay has been condoned, and I have been given statement of books and records on 2000.
No. When did you file your application under section 454?
454 application file model detail you are right now, Nanatral. I have to get from the office.
ಆಗ ನೀವು ಅದೆಲ್ಲ ಡೀಟೇಲ್ ಕೊಡ್ಬೇಕಂದ್ರೆ ಅಡ್ಮಿಟ್ ಮಾಡಿ ಸ್ಟೇ ಮಾಡ್ತೀವಿ ನಾವು ಅಷ್ಟೇ.
Sir, you may have a difficulty. We are not on, but law is very clear.
My lord, I am not talking.
No,
My lord, I'm sorry, my lord, I am not made my side play. My lord, I am not talking about 458A or period of limitation or 1 year. I am not.
Under what law we have to extend?
No, my submission is only when the limitation starts as far as this case is concerned.
No, it will not change by case by case.
Have you brought any judgment?
According to me, limitation starts only from the date I get the.
According to section limitation.
Full bench.
Section is silent, my lord. My lord, cause of.
This question arises many times. Are you supported by any judgment on this point of the Supreme Court?
Contrary judgments are there.
Full bench judgment is clear.
Allah.
Yes, for stay.
Admit. You submit all those.
Yes, I will submit.
Admit. Interim stay. Interim stay further proceedings.
Of further proceedings in CA 119 of 20.
As paid for. And you can produce the records here only instead of calling those records. Interim stay as paid for. Official liquidator. 6 OSC. Serial number is 25. Another concept for respondent one. Shall submit. Submit when he file the records of commencement of the proceedings under section 454 Companies Act and the orders passed in that. Company petition copy
Original
winding up order.
Winding up order.
And the winding up order passed in the matter. Yes, list on.
29/7.
You submit them. Now
Yes,
we have heard you sufficiently.
For further hearing, seal number
Obliged.
26. Deepak J, MP Geeta Devi.
Lord, I undertaken to produce regarding the voice recording, what should be the procedure, my lord, I'm placing that, and also another 2 judgments. Husband's petition for divorce has been rejected. On the petition was on the grounds of adultery and cruelty. Your lordships heard it yesterday, my lord.
Yesterday you argued on this point.
Please, my lord.
Yes.
Only 2 judgments. One is the latest judgment regarding 65B, which is the 3rd judgment, my lord. The first 2 judgment, my lord, is para 2003 Dev Narayan Haldar. In this case, my lord, whether how cruelty has to be proved or any allegations and averments made, my lord, at para 20, my lord. This is actually under 125 proceedings. The allegations were there was cruelty, and that was the reason justification for her to stay separately. Therefore, my lord, the court says here, in any of these matrimonial matters, my lord, when evidence, what is the type of evidence to be placed on record?
Correct, that is the settled position.
Please, my lord.
If he
All
makes unfounded allegations of infidelity, that
No, my
amounts to
lord.
cruelty.
Here, evidence of contemporaneous nature therefore plays an important role. Now, my lord, where there's a dispute between husband and wife, it's
Are you reading?
at para 20, my lord, last
20.
paragraph. In the last para, my lord.
Para 20 and the.
Para 20. We therefore hold that the court was not justified in setting aside the finding recorded by its learned magistrate. We have reached this conclusion after appreciating evidence on record, since there is no discussion of evidence in the judgment of High Court. The counsel for respondent posed before us a question as a part of his submission as to why the respondent should leave a matrimonial home without any reason. In case where there is a dispute between husband and wife, it's very difficult to unravel the true reason for the dispute. After separation, when the relationship turns sour, all sorts of allegations, counter allegations are made against each other. Evidence of contemporaneous nature therefore plays an important role in such cases as it may reveal the thinking and attitude of the parties towards each other at relevant time. Such evidence is usually found in form of letters written by the parties to each other or to their friends or relatives. Or really the respondent was subjected to cruelty and harassment in the manner alleged by her, we have no doubt she would have written about such treatment to her friends or relatives with whom she may have corresponded. The reports allegedly made by her to the police may have thrown some lights in the aspect of the matter. Such evidence is completely absent in this case. This is what I was trying to bring to your lordships, my lord, that if this alleged adultery according to him had occurred, ಯಾರಿಗಾದ್ರೂ ಒಂದು ಲೆಟರ್ ಬರೀತಾ ಇದ್ರು. It happened in Germany. You would have written a letter, sent an email to any one of the family members and all his relatives or even his friend that
That's it. That is only observation. What is the general tendency ಅಂತ ಹೇಳೋದಕ್ಕೆ?
it's not an observation, my lord. Based on this absence of evidence, contemporaneous nature, the court set aside the contemporaneous ಅಂದ್ರೆ
ಅಲ್ಲಿ ಇದು ಯಾವ್ದೋ ಒಂದು ಯಾವ ಕಾಲದ್ದು 2003 ಈಗ ಲೆಟರ್ ಬರೆಯೋ ಕಾಲ ಎಲ್ಲ ಹೊರಟೋಗಿದೆ.
ಇಮೇಲ್ ಅದೇ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಇಮೇಲ್ ಅವರೇ ಇಮೇಲ್ ಬರೀತಿದ್ರಲ್ಲ, ಲೆಟರ್ ಕರಿಬಹುದು ಏನಾದ್ರೂ ಹೇಳ್ಬೋದಾಗಿತ್ತಾ?
We told you that if husband or any spouse makes the allegations of infidelity, it is held in several cases that is a sufficient cause to say separately because that amounts to cruelty. You are now arguing on the point of desertion, no?
ಕ್ರೂಯಲ್ಟಿ ಅವರೇ ಕ್ರೂಯಲ್ಟಿ ಅಂಡ್ ಅಡಲ್ಟ್ರಿ ಎರಡು ಹೇಳಿರೋದು, ಎರಡು ಹೇಳಿದ್ದಾರೆ. ಈವನ್ ಅಡಲ್ಟ್ರಿ ಮೈ ಲಾರ್ಡ್, I had made a submission.
ನಾವೆಲ್ಲ ಅದನ್ನ ಹೇಳಿದ್ವಲ್ಲ, he has not examined.
Please, my lord, I leave it at that, my lord. I had made a submission that
Other cruelty, ground of cruelty is alleged.
My lord,
or proved.
even if we keep aside these documents, these alleged emails that is produced, is there any circumstantial evidence that he could produce? That's where I bought this judgment, my lord. And the next judgment is regarding the voice recording, where according to them, Panchayati Naditu, Panchayati Nali CD produced Madidare. CD has not been identified by him. Voice has not been recognized and identified by him.
Statement is that Nilesh Kumar.
Nilesh Kumar, 2011, this para 33 and 39, my lord. Relying upon 1987 judgment, my lord, the Supreme Court says in 95.
Which page number?
Para 33, page 154 of the judgment, my lord. I could not write the internal running number, my lord.
You have not given numbers, page initiation.
Page initiation ಕೊಟ್ಟಿಲ್ಲ, I'll ಮಾಡ್ಕೊಡ್ತೀನಿ ನಾನು. At para 33, my lord.
Yes.
In Ram Singh versus Colonel Ram Singh, this court stated some of the conditions necessary for admissibility of tape recorded statement as follows. That was tape recorded. Now we have a CD of audio recording by a mobile. The voice of the speaker must be duly identified by the maker. In this case, the voice has not been identified. Other than producing the CD, he has not identified the voice. In other words, it is manifestly follows a logical corollary that the first condition for admissibility of such statement is to identify the voice of the speaker. Where the voice has been denied by the maker.
Analysis ಆಗ್ಬೇಕಲ್ಲ ಅದರದು. Lab analysis ಆಗ್ಬೇಕು ಬರೀ produce.
ಆಗ್ಬೇಕು.
Whether she had admitted or
Denied it.
Then lab analysis
ಆಗ್ಬೇಕಾಗಿತ್ತು, ಮಾಡಿಲ್ಲ.
ಅದಕ್ಕೊಂದು ಮತ್ತೆ judgment.
So all this has not been on.
What is said here?
There should be an accuracy.
Identification.
Voice identification should be done.
Lab analysis ಆಗ್ಬೇಕು.
ಆಗ್ಬೇಕು. ಅದೇನು ಮಾಡಿಲ್ಲ. They ask a question to us in the cross examination. Are you prepared for a forensic scientific report? She says yes. Madilla. Now all this would show that first of all, he does not identify the voice. He does not play to the court to identify the voice. Panchayati naditu ಮಾತುಕತೆ ಆಯ್ತು ಅಂತ ಹೇಳೋದಕ್ಕೆ ಯಾವುದನ್ನು ಪ್ರೂವ್ ಆಗಿಲ್ಲ. So there is no material on record that there was any such get together in the family after their return. ಹೌದು.
We do not know why are you citing these judgments. We do not know why are you citing this judgment because in para 39 it is said that this tape recorded evidence can be only used as a corroboration evidence. Right? If that is proved, that is used as a corroboration evidence. Prove agilla anta ಹೇಳ್ತಾ ಇದ್ರು, then why are you relying on this?
How voice recording has to be proved, my lord? In 1987, Supreme Court says it has to be played, voice has to be recorded, identified. He is not identified. So therefore, the allegation that the CD was produced, he produces a CD, my lord. The CD is not been play ಮಾಡಿ identify ಮಾಡಿಲ್ಲ. Therefore,
CD also is an electronic record.
electronic evidence.
Then how it has to be proved is laid out in this Arjun Panditrao Kotkar's case. Why are you going to those old cases?
All I'm producing, my lord,
It is
because
also an
CD,
electronic-
my lord, typically in this Pandit Rao's case, Arjun Pandit Rao case, how the voice recording has to be done is not stated, my lord.
But
How-
anyway, that is also an electronic
It
document.
is an electronic device, my lord. Apart from 65B, that is one is 65B production, my lord. Second is how to prove the voice recording. If a compact disc is produced to show that there was supposed to be an alleged panchayat. Even that has been not substantiated is what I am trying to place to your lordship's consideration, my lord. Pandit Rao's judgment, my lord, is confirming all this. The method for proof of voice recording is there in this 2011, which holds the field even today, my lord.
Yes.
Therefore, my lord, both the allegations of alleged adultery and cruelty has not been proved. There is no error in the order of the family court. The appeal has to be dismissed. Is my respectful prayer.
My lords, I would like to go through two sections of the Family Court Acts, my lord.
It can adopt its own procedure, antana.
No, my lord, section 14 says,
Notwithstanding evidence act and application of evidence act.
please, my lords, wherein a family court may receive any evidence, any report, statement, documents, information, or material that may, in its opinion, assist it to deal effectually with a dispute, whether or not the same would otherwise relevant or admissible under the Indian Evidence Act, my lords. So, my lords, the family court,
Consider.
please, my lords. My lords, the family court can consider
Consider to deal effectively with a dispute, whether or not the same would be otherwise relevant or admissible. So, may anta ide adu. Family court may receive anta ide.
Please, my lords, it says may receive, but my lords, family
Now
court
it is
is
received
not.
in evidence. Proved, that is one question. Receiving was one thing, proving is one thing.
Now, my lords, the exhibits what I've produced as a email conversations, it was not accepted only for the reason wherein I have not filed the application in the section 65B, my lords. Now, my lords, if you go through this section 14, it says the family court doesn't have to rely upon the Indian Evidence Act, my lords. My lords, I would like to go through section 10.
ನಿಮ್ಗೆ ಏನಾದ್ರೂ ಆ ರೀತಿ ಕಂಡು ಬಂದ್ರೆ notwithstanding
Receiving is different.
may receive. Otherwise, notwithstanding
Report, statement, documents, information, matter that may be in opinion.
yes, sir. Which is the other section you are referring?
My lords, section 10, subclause 3. Now, it says, nothing in subsection 1 or subsection 2 shall prevent a family court from laying down its own procedure with a view to arrive at a settlement in respect of the subject matter of the suit proceedings or at the truth of the facts alleged by the other party and denied by the others, my lords.
Now, what is that compelling circumstance for us to adopt our own procedure other than the, overriding the evidence provisions of the Evidence Act and other things here?
Please, my lords. My lords, the family court can look into any documents.
These applicable for settlement.
My lords, it says,
Notwithstanding in subsection 1 and subsection 2, nothing in subsection 1 and 2 shall prevent the family court from laying down its own procedure with a view to arrive at a settlement in respect of subject matter of the suit or proceedings or at the truth of the facts alleged by one party and denied by the other party.
my lords, it says, subject
Correct,
matter
may
of the
anta ಇದೆ.
suit
In both-
or proceedings.
In both cases, may, in both sections,
Please. It
what
says-
is the compelling circumstance for us to exercise discretion, not to go by the Evidence Act or
Please. Indeed, my lords, it
Section,
says, it says
subsection
may,
1 or 2.
my lords, it says may, but my lords, the adultery and cruelty, I have to prove only through the circumstantial evidence, which I have produced, and
Actually, section 10(3) is with regard to the application of civil procedure code and criminal procedure code.
my lords, it says the family court can lay down its own
Correct.
procedure,
Family
right?
code, despite first subsection 1 and 2 say that in case of civil matter, CPC shall apply.
See.
In case of criminal matter, CRPC
CRPC
shall
shall
apply. And 3 says that notwithstanding anything stated in 1 and 2, it can adopt its own
Procedures, my
to arrive at a settlement or find out the truth. Now here, the dispute is not with regard to the adopting civil procedure code or criminal procedure code. Proof of this disputed document. So only section
10.
14 at least
14.
can be removed. 14 also it says may. What is the circumstance for us to overlook Evidence Act and adopt some other procedure?
My lords, there is citation which says, I don't have the citation, but it says, the family court not bound by technicalities of the CPC or Indian Evidence Act, my lords. I couldn't find the citation, but
So
it is
now,
there.
correct, 14. Now what exactly you can invoke is section 14, not 10, because
Not 10.
here there is no issue of whether CPC shall be applied or not.
Not.
So only 14.
Please.
14 also we are asking that it is a discretionary power.
It is a discretionary power.
Why? What is the compelling circumstance for us to, superseding or taking the Evidence Act?
No, my lords, wherein the
See, if
exhibits.
something happens within the 4 walls of the house, analysis. You have not done that.
I
also.
am relying upon the emails IDs, my lords. I am not looking into the CDs because I have not produced even the translated copy of that. Now, my lords, if that 65B, if it is overlooked, my lords, email IDs, whatever I have produced conversation, it shows very clearly that there was adultery, my lords. And even, my lords, the IP address, what itself was admitted by the respondent number 1.
She says both of you are using the same mail. Yourself
My
and
lords,
her
regarding
friend.
that also, there's an admission that she was using the 2 email IDs, which is yahoo.com. That also she has admitted. And she even said the email IDs were created by the husband, she said.
Oh,
After
those
going to
both were
Germany,
created by him.
both IDs were created by husband, she said. I even accept that. But those email IDs were used by her. That also she has admitted.
Where is the evidence to show that she alone had the complete domain over those email IDs?
That question was not put forward.
Okay. Then how can you improve it now? All right, if you prove that she alone had the control over those 2 email IDs, then at least there will be some semblance of force in your submission.
My lords, it can be remanded back only for the purpose wherein I can file a
But
section
remand it after so
65B.
many years. Remand is not a matter of course, out of 41 to 23. Is it a matter of course or a matter of right? No challenging. Please take yours. Dismissal of this petition for trial. The petitioner in MC number 2143 of 2008 on the file of first edition principal family case Bangalore has preferred this appeal. Ariga or Barlila. The appellant was the petitioner. Respondent number 1 and 2 are respondent 1 and 2. In MC number 2144 of 2008 before the trial court. For the purpose of convenience, they are referred to henceforth according to the ranks of the trial court. The marriage of the petitioner and respondent was solemnized. Why 3 years registration again? Marriage was solemnized on 22/5/2002.
Registered on 19.
And
Please, madam,
registered on
22/5/2002.
19/8/2005. Why? ಇದು ಇರ್ಬೇಕು ಫಾರ್ ದಿಸ್ ಡಿಪೆಂಡೆಂಟ್ ವೀಸಾ ಅದಕ್ಕೇನಾರು
Visa.
Marriage of petition and the response was solemnized on 22/5/2002. ಎಲ್ಲಿ ಅದು? In Shivaprabhu Kalyana Mandapa, Rajajinagar, Bangalore. The parties are Hindus and governed by Hindu Marriage Act 1955. For short, HM Act. The marriage of the parties was registered on Christian registration ಬಗ್ಗೆ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರ ಈಗ ಇದ್ರಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ ಅಲ್ಲ ಇವರು ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಟಾಟಾ ಕನ್ಸಲ್ಟೇಷನ್ ಇನ್ 2005 IDJ in 2005 ಕರೆಕ್ಟ್ 19/8/2005 ಅಂತ ಹೇಳ್ತಾರೆ. ಮದುವೆ ಆಗಿದ್ದಿಲ್ಲ 25 the copy of the marriage invitation, photos. Marriage was registered before registrar of marriage definitely. On the date it was registered in document number 3 ಅಂತ ಇರೋದಿಲ್ಲ ಅದು exhibit ಆಗಿದ್ರೆ ಆಗಿರೋದು. What is that exhibit? ಅಲ್ಲ 3 ವರ್ಷ ಬಿಟ್ಟು ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ ಬಟ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಹಿಸ್ ಅಲಿಗೇಷನ್ soon thereafter the cruelty started. And the same was registered on 19/8/2005. ಬರೀ ಇದೆಲ್ಲ ಅವ್ರದ್ದು ಜಾಬ್ ಪ್ರೊಫೈಲ್ ಅದೇ ಇದೆ ಜಾಸ್ತಿ. The petitioner and first respondent stayed at in-laws house. ಮದುವೆ ಆದ ತಕ್ಷಣ ಅವ್ರ ಮನೇಲಿ ಇದ್ರ ಮೊದಲು. After marriage, petitioner and respondent started to there in Hyderabad.
While the petitioner was working at Hyderabad.
Got transferred to
Bangalore, wherein he shifted to in-laws house.
So he says soon after 40 days he shifted, he found some indifferent behavior. There are no children out of the marriage, no?
Minus one son is there.
The date of birth not there.
5/10/2003.
5/10/2003 is the date of birth. Registration 19/8/2005.
Minus, I think that is only for the traveling purpose for the visa. Dependent.
Out of proceed wedlock, the couple were blessed with the child, the son by name Shreyas on 5/10/2003. 5/10/2003. ಇಲ್ಲಿ ಎಷ್ಟು ವರ್ಷ ಇದ್ರು ಅತ್ತೆ ಮಾವನ ಮನೆಯಲ್ಲಿ? ಬೆಂಗಳೂರಲ್ಲೇ ಇದ್ರು. ದಿಸ್ ಟಾಟಾ ಕನ್ಸಲ್ಟೆನ್ಸಿ ಎಲ್ಲ ಬೆಂಗಳೂರಲ್ಲೇ ಇದೆ. ರಾಮಮೂರ್ತಿ ನಗರ್. Petitioner purchased a house in Ramurthy Nagar.
Minus November 2003, the petitioner has taken up a rented house.
In the month of October 2005, ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ. In March 2005, he purchased a house in Ramurthy Nagar ಅಂತ ಹೇಳ್ತಾರೆ.
Please.
For a period of loan period of 20 years. Airbus project. So he went abroad in 2000.
October 2005, my lords.
19th November 2005. ಅಲ್ಲ ಆಫರ್ ಮಾಡಿದ್ದು ಅಕ್ಟೋಬರ್ ನಲ್ಲಿ.
19 November.
After 40 days of the marriage, For 40 days after the marriage, the couple lived in the house of the petitioner. Thereafter, due to the employment of petitioner, he shifted to Bangalore. Until he purchased a house till January 2000.
2005.
March 2005. Until March 2005, they lived together in the house, in the parental house of respondent. In March 2005, he purchased a house in Ramurthy Nagar by availing bank loan, and they shifted to the said house. In November, on 19th November 2005, in 19th November, registration avagadu 1908 andre, for that purpose they got registered the marriage. The couple flew to Germany due to the deputation adu, due to the employment. Same employer deputed him.
Please.
Due to the deputation of the petitioner by his employer Tata Consultancy Service Limited for a project. Finally, ಯಾವಾಗ ಇಬ್ರು ಸಪರೇಟ್ ಆಗಿ ಇರಕ್ಕೆ ಶುರು ಮಾಡಿದ್ರು. ಮದರ್ ಆಫ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಎಕ್ಸ್ಪೈರ್ಡ್. ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಒಬ್ಬರದೇ ಹೇಳ್ತಾ ಇದ್ವಲ್ಲ, ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಅಂತ ಮಾಡ್ಬೇಕು ಅದನ್ನ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1. ರೆಸ್ಪಾಂಡ್ ಅಂತ ಹೇಳಿದೆಲ್ಲ 1 ಅಂತ. ಅದ್ರ ತಾಯಿ ತೀರ್ಕೊಂಡಾಗ ಬಂದವ್ರು ತಿರುಗಿ ಹೋಗ್ಲಿಲ್ಲ ಅಂತನಾ? Came back to petitioner to Hamburg, Germany. In June 2006, due to the death of respond number 1, she came to India and again went back to Germany. So both of them come together in May 2007.
Please.
ಇಲ್ಲ, ಯಾವಾಗ ಸಿನ್ಸ್ ಬರ್ತಾರಲ್ಲ ಮತ್ತೆ ಮೇದಲ್ಲಿ ಹೋಗ್ತಾರೆ, ಯಾವಾಗಿಂದ ಸಪ್ರೇಟ್ ಆಗಿ ಇರಕ್ ಶುರು ಮಾಡಿದ್ದು? ಎಲ್ಲ ಹೈಡ್ ಪಾರ್ಕ್ ಎಲ್ಲ ಹೋಗಿದ್ದು ಬೇರೆ. Now we are seeing about the admitted facts. Finally, ಯಾವಾಗ they started living separately. July 2007. So finally, she returned back in 1st November 2007. Thereafter, they have not gone back. Miss, what was their period past separation?
My lords, I think separation is 1/11/2007. From there, then dispute started, my lords.
Correct. ಹೇಳಿದಿರಾ cause of
No,
action?
it is not specifically mentioned from when they were separated.
ಇಲ್ಲಿ ಇಷ್ಟುದ್ದ ಪಿಟಿಷನ್ ಬರ್ದಿದಾರಲ್ರಿ ಅದರಲ್ಲಿ. She doesn't know Kannada. That's why. There is. Where have you stated your cause of action column? Cause of action, para 44. Arose on 22/5/2002. When got married, the subsequent days when respondent one has been clear. But last when they separated,
It is not mentioned.
not mentioned. in the
Not
petition.
mentioned.
Such a long petition.
According to the fact, it says 1/11/2007 when she came back to
Came
India.
back, that's all.
From
That's
there,
all.
dispute started.
But there. Germany. Believing her, he sent her back on the helper. 6th of October. Mother-in-law passed away in which year? That was in 2005. Oh. Nowhere it is stated, no? In 10th October. No. In para 34, he says on 10th October 2007, he came to know about the relationship. So we can say since November 2007, they are living separately.
Please,
They
my
are
lords.
saying November. 30 SMS between November 2017 and February 2008. Petition is filed in which year? 2008.
2008.
By the, since the end of 2000, we'll just once again, any deportation it has come? Since the end of 2007, the couple are living separately. Next one. The petitioner filed MC number. Madam, notice ಕೊಟ್ಟಿದ್ದು ಇದೆ. No. Petition filed MC number 2143 of 2008. Under section 13(1) and 1A of Act 1955. Against the respondent, against respondent number 1 and 2, alleging that respondent number 1 is leading adulterous life with the respondent number 2. He claimed that that is also an undisputed fact. Respondent number 2 was a colleague of him. Respondent number 2 is colleague of respondent number 1. He claimed, in the petition he claimed that during their stay in Germany, respondent number 2 used to visit his house, and he himself respondents and their other colleagues used to go for picnics and trips. During that time, also, the respondent used to have undue intimacy with the first respondent used to have undue intimacy with respondent number 2. On the park bench. During one of such trips, his colleague Sudhir Nagraj witnessed the respondent number 1 and 2 being in an intimate condition in an objectionable manner, and he informed the petitioner about the same. She used to pressurize him to bring the second respondent home, and she was not taking care of the child. there were exchange of lot of emails, SMS. Innೊಂದೇನು ವಾಯ್ಸ್ ರೆಕಾರ್ಡಿಂಗ್ ಫೋನ್ ಕಾಲ್ ಅದು.
Please, my lords, it's a
Phone
call
calls
record.
between respondent number 1 and 2. When ಇನ್ನೊಂದು ಯಾವ್ದೋ ಹೇಳ್ತಾರಲ್ಲ, this matter was taken before his and the petitioner getting convinced about the relationship, he informed the brother and fiction paragraph. The brother, which paragraph of the fiction is that? Uncle brother ಅವ್ರ ಬಗ್ಗೆ ಹೇಳ್ತಾರಲ್ಲ.
My lords, 21,
Para 21.
please.
Grandmother since
Her uncle Shankar, brother Raju.
Other than respond number 1's uncle.
Raju.
Other is hot thrice. Own uncle Shankar. ಇದು ಒಂದು. ಇನ್ನೊಂದು brother also admitted and admonished her ಅಂತ ಹೇಳ್ತಾರಲ್ಲ. A panchayat was ಇನ್ನೊಂದ್ ಕಡೆ ಎಲ್ಲ ಬಂದಿದೆ ನೋಡಿ, ಅವರು ಅವ್ರ ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ ಅವರು ಒಂದು ಮೀಟಿಂಗ್ ಮಾಡಿದ್ರು ಅಂತ. ಇಲ್ಲಿದೆ ಪ್ಯಾರಾ 39 ಅಲ್ಲಿ. The adulterous activities of respondent number 1 and 2 were witnessed by Shankar, uncle of respondent number 1. A meeting was convened. In the house of respondent number 1 at his instance. In that meeting, on confronting respondent number 1, she admitted in front of her, ಯಾರ್ಯಾರು ಇದ್ರು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, her uncle Shankar, her brother Raju,
and family,
her grandmother and other family members.
Please.
About her relationship with respondent number 2. ಆಮೇಲೆ she is living in her grandmother's house. Her brother, uncle ಎಲ್ಲೋ admonish ಮಾಡಿದ್ರು ಅಂತ. Her brother pleaded with the petitioner to forgive his sister and give her life. Even thereafter, she continued her adulterous activities. By such of the acts of the respondent number 1, he is subjected to cruelty and he is. It's not possible for him to continue the matrimonial life. Thus, he sought decree for dissolution of marriage. The respondent contested the question. In her statement of objection, she denied the allegations of adultery or any indifferent behavior or holding of any meeting in her parental house, etc. As against that, she contended that the petitioner subjected her to cruelty, demanding money when for purchasing the house, and her father paid rupees 5 lakhs with great difficulty for construction of the house. She admitted both of them going to Germany on employment, due to the employment of the petitioner, but denied the other allegations. He contended that the petitioner was cruel even when her mother passed away. And took her back to Germany. Her allegations, ಕುಡಿತಿದ್ರು ಅಂತ ಹೇಳಿದ್ದಾರೆ. He was addicted. It was the petitioner himself who was bringing his colleagues, including the second respondent, to house, their home. And there used to be normal socializing. ಎಷ್ಟುದ್ದ ಹೇಳಿದಾರೋ ಅಷ್ಟುದ್ದ ಹೇಳಿಲ್ಲ, ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿ ಹೇಳೋದಿಲ್ಲ. ಅದನ್ನ ಸುಸೈಡ್ ಮಾಡ್ಕೊಳಕ್ ಟ್ರೈ ಮಾಡಿದ್ರು ಅಂತ. He tried to commit suicide.
She
Come back to India, and that one instance, the first respondent tried to commit suicide. She was threatening him anta. Sorry. The exchange of emails between her and the second respondent. Emails, phone calls and SMS between her and the second respondent alleged were denied. Total denial. He himself, somewhere she has said some medical condition.
That's what it says in the denial.
ಇವ್ರದ್ದು ಅಲಿಗೇಷನ್ 44 pages ಬರೀ ಅದ್ರ ಡಿನೈಲ್ ಎಲ್ಲ ಹೋಗಿದೆ. Now, what is her substantial defense in that? Para 44. ಇನ್ನೊಂದ್ ಕಡೆ ಎಲ್ಲೋ ಓದಂಗಿತ್ತು. Was spending her vacation. The petitioner himself neglected the respondent and her son. She claimed that with the ulterior motive of deserting her, he has filed the petition making reckless allegations against her. And she sought the dismissal of the petition. Next one.
It is not a match for him.
We saw that.
Because
After so many years of marriage, In support of the case of this case, the petitioner was examined as per the law.
Also filed objections. He denied the allegation.
But our any evidence ಮಾಡಿಲ್ಲ. Okay, respond number 2 house para 38 ಅಂತ. Respond number 2 filed objection denying the allegations of adultery and exchange of email, etc. He claimed that he is not aware of any conversations between the petitioner and the first respondent or about their family affairs. And he used to go to the house of the petitioner only on his invitation as a colleague. He denied all allegations made against him. In support of the case of his case, petitioner got himself examined as PW1 and got marked exhibit P1 to P147. Again, HDFC bank statement, for what purpose that was produced? Respondent number 1 got examined herself as RW1. On hearing the parties by the influence judgment and order, dismiss the petition, holding that the allegations of cruelty and adultery and cruelty were not proved. Next. Timothy so and so level counsel for that not proved. The trial court further held that the exhibit P2 the compact disk and exhibit P3 to 145 the email messages but not proved. In accordance with and as required under section 65B of the Evidence Act. Evidence Act. And the evidence of PW, the evidence of the petitioner was only a self-serving statement. Next one. Srimati so and so. So your only thrust is on this exhibit P3 to 145. Srimati so and so Law Council appearing for appellant vehemently contends that that respond number 1 admitted that she was sending mails on yavudu email IDs on email IDs. What are those 2 email IDs? On email ID shown in exhibit P3 to P145. Can you say which are those email IDs? Just now you said. No, she said during the course of evidence, respond number has admitted that she was using those. That she was sending email ID. She was handling.
My lords, it is location.
And one the question.
My lords, in cross-examination page
You have
number
extracted that.
36.
Mobile SIM ಬಳಸುತ್ತಿದ್ದೀರಾ ಅಂತ. You said you do not know Kannada, but you have extracted all Kannada only in appeal memo. Kannada question.
My lords, that is
No, that is not her.
Ranjita location.
This is this no this Chinna sweetheart Yahoo comments. Ranjita
Lokesh.
gmail.com page number 30 of judgment.com. Therefore, the certificate under section 65B was not required. Relying on section 14 of the Family Courts Act, she contends that Indian Evidence Act 1872 is not strictly applicable to the family court proceedings. And for effectual adjudication of the matter, the court may receive evidence, any report, statement or documents irrespective of any bar under the Indian Evidence Act. She claims, she submits that the trial court has overlooked the material admissions of the respondent of respondent number 1. That is also RW1 in therefore the impugned judgment order suffers illegality. For contrast, Srimati Gita Papana submits that when the petitioner came before the court seeking the dissolution of marriage on the claim of adultery and cruelty, the burden was on him to prove that same. Though he claimed that his colleague, Sudhir Nagraj was, and her uncle of RW1, Van Shankar, were the eyewitnesses. He did not choose to examine them, nor he examined any persons who allegedly participated in the panchayat and were witnesses to the confession of the first respondent. When respondent number 1 clearly disputed the emails at exhibit P3 to P145 and conversation said to be recorded in exhibit P2 the compact disc. Despite that, the appellant, petitioner did not produce 65B certificate, 132, nor sought reference of exhibit P2 for the lab analysis for vice test. Therefore, the trial court was justified in dismissing, rejecting the ground of adultery and cruelty. Thus, she seeks dismissal of the appeal. We will continue in the afternoon. In support of her submission, she realized that ಇದೆಲ್ಲ ಫಸ್ಟ್ 2 ಏನು ಜಡ್ಜ್ಮೆಂಟ್ ಬೇಕಾಗಿಲ್ಲ ಕೋರ್ಟ್ ಕರೆದಷ್ಟೇ 3 ಯಾಕೆ ಬೇಕು ಅಂತ ಹೇಳಿ first 2 judgments are not required, only third judgment, that Supreme Court judgment regarding 65B ಅವರು ಅದನ್ನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅವ್ರ ಪ್ರಕಾರ even without that could have support of her submission ಇಷ್ಟೇ ಬರ್ಕೊಳ್ಳಿ. She relies on the judgment of the Supreme Court in Arjun Pandit Rao Kotkar versus Kailash Kusharao Gorentel 2027 SCC page 1. We'll continue in the afternoon. Okay. P7.
27 ಅಂತ ಫರ್ದರ್ P7.
Application for recalling.
ಏನು ಮಾಡಬೇಡ ಡೇಟ್ ತೋರಿಸು. ಎಲ್ಲ IS disposed of. ಅದನ್ನ ಹೇಳೋದು ಪರ್ಮಿಟೆಡ್ ಟು ವಿತ್ಡ್ರಾ ಹೇಳಿದ್ರು.
Dictation. Dictation. Have you seen it?
230 matter.
2:30. We are dictating one matter. After that, we'll take up.
For further hearing,
And records. I'm considering the submission of both side and I'm examining the records. The point that arises for determination is whether the trial court, whether the dismissal of the petition by the trial court, by the impugned order, dismissal of diverse petition by the trial court, by the impugned order is sustainable in law. Next. The petitioner sought decree for dissolution of marriage on the ground of adultery and cruelty. Therefore, the same was disputed by the respondent. The burden was on the petitioner to prove those two grounds. In the petition, there were in the petition. Except the allegations of respondent one being adulterer. ಅವ್ರ ತಂದೆ ಮೇಲೂ ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ದಾರೆ ನಾನೆಲ್ಲ ನೋಡಿ. ಫಾದರ್ ವಾಸ್ ಅ ಡ್ರಂಕರ್ಡ್ ಅಂತ ಹೇಳಿ. The only other instance of the cruelty alleged in the question was that first respondent was not permitting him the physical proximity. 2007 ಅಲ್ಲ ಅದು para 14 because of her relationship with respondent number 2. The burden was on him to prove that respondent number 1 was living adulterous life with respondent number 2. As such allegation is serious in nature, legally acceptable evidence is required in proof of the same. To prove the said allegations, the petitioner relied on exhibit P2. The compact is allegedly containing the conversation between phone conversation. CDRs collect madilla. Phone conversation between respondent number 1 and 2. And exhibit P3 to P145. Email as well as SMS, sir.
It's an email conversation.
Emails, allegedly exchanged between respondent number 1 and 2. Response denied that exhibit P2 contains their voice.
The CD was the conversation between the panchayat madidru anta helidralla adralli the conversation between himself, his wife's grandmother, wife's brother.
Sorry.
Second respondent is mother, brother.
Conversation. Hagadre adak will come to next. First email will meet that.
CD conversation
tappagbardu, but first that will come to the second part because
Very well,
he has
very
to
well.
prove he
Very
has not examined any of them.
Very well.
Exhibit P2 bitkudi. Exhibit P3 to P145 allegedly contain the exchange of emails between respondent number 1 and 2. Respondent number 1. First they have filed respondent number 1 and 2 both denied them of objection. Respondent your cross examination will another about that PW1 cross examination only This is RW1 ಇರ್ತದೆ. ಹೀಗಾಗಿರ್ತದೆ. Xerox copy. PW1 cross examination ಅಲ್ಲಿ touching that ಒಂದನೇ ಎದುರುದಾರಳು she was relative. They were consequent marriage. According to him, this relationship started in the year 2000.
Prior to the marriage, relationship between my husband and me.
No. R1 and R2, this relation petition ಅಲ್ಲಿ ಏನೋ 2003 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
2005. ಅವ್ರು ಅಲ್ಲಿ ಹೋದ್ಮೇಲೆ ಜರ್ಮನಿಗೆ ಹೋದ್ಮೇಲೆ 2003 ಜರ್ಮನಿಗೆ ಹೋದಾಗ
2003 ಏನೋ ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ ಪಿಟಿಷನ್
ಮಾಡಿದ್ದಾರೆ. ಅದು
2003 ಅಲ್ಲಿ
ಜೊತೆಗೆ ಅವ್ರು ಒಟ್ಟಿಗೆ ಇರುವಾಗನೇ ಇಲ್ಲೇ ಅವ್ರ ತಂದೆ ಮನೇಲಿ ಇರುವಾಗನೇ she was disinterested ತರ ಹೇಳಿದ್ದಾರೆ. ಅವರು ಪಿಟಿಷನ್ ಅಲ್ಲೂ ಸಹ ಹೇಳಿದ್ದಾರೆ ಅದೇ ರೀತಿ.
ಪಿಟಿಷನ್ ಅಲ್ಲಿ 2003 ನಲ್ಲಿ she was
ಹೌದು
not showing any interest in him ಅಂತ ಏನೋ ಹೇಳಿದ್ದಾರೆ. ಆ ಇಮೇಲ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಡೇಟ್ ಯಾವ್ದು ಇದರಲ್ಲಿ?
That is my lord's 20th March 2007.
7 ಅಲ್ಲಿ then
My lord starts from
5 emails, 6 emails.
no, those emails are dated. ಇಲ್ಲಿ ಯಾರೋ ಸುಧೀರ್ ಅನ್ನೋರು ಹೇಳಿದ್ರು ಅಂತ
2007
February 2007.
2007 ಅಲ್ಲಿ ಹೇಳ್ದ ಅಂತ ಹೇಳ್ತಾರೆ. ಸುಧೀರ್ ಅನ್ನೋರು, ಸುಧೀರ್ ನಾಗರಾಜ್. In May 2007, he says he found ಇಲ್ಲಿ ಪ್ಯಾರಾ 14 ಅಲ್ಲಿ May 2000 in the year March 2007 ಅಂತ ಹೇಳ್ತಾರೆ ಪ್ಯಾರಾ 12. Petitioner claims that in para 12 of the petition, petitioner claims that respond number 1 developed an affair with the respond number 2. Respond number 2 correct in March 2007 ಅಂತ ಹೇಳಿದ್ರು. ಇಲ್ಲ ಅವಾಗ ಹೇಳಿದ್ರು ಅಂತ.
all the emails are only
no, he says in para 12 this meeting was conducted in March 2007 when they came back to their parental house. Then she revealed about that ಅಂತ ಹೇಳ್ತಾರೆ. But petition is so bald. ಯಾವಾಗಿಂದ ಶುರುವಾಯ್ತು ಏನು ಅಂತ ಹೇಳೋದೇನು? Right? Is that correct?
Please, my lord, it is not mentioned specifically.
But he says in C para 12, in May 2007, when they came to Bangalore, when questioned about her conduct, she gave evasive reply and suspecting that on the request of her grandmother, she revealed the name of respondent number 2. ಅಂತ ಹೇಳ್ತಾರೆ ಅವಾಗ್ಲೇ ಗೊತ್ತಾಯ್ತು ಅಂತ ಅವ್ರಿಗೆ. In para 12 of the petition, he says that suspecting her conduct in the presence of in her parental house when she was employed, she revealed her relationship with respondent number 2 in the presence of her grandmother, etc. So ಇದು 2008 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡೋದಕ್ಕೆ ಒಂದು ಇದನ್ನ
ಕಾರಣ.
PW ಇವ್ರ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ both of them were using that ಅಂತ ಹೇಳೋದನ್ನ ಕೇಳಿದಾರಲ್ಲ. ಹೈಡ್ ಪಾರ್ಕ್ ಏನು ಹೇಳಿದ್ರು.
The emails, my lord.
Both of them were using that
Same
Email,
laptop.
yeah.
same laptop.
He was also having knowledge of that password.
ಪ್ರತ್ಯೇಕವಾದ ಪಾಸ್ವರ್ಡ್ ಸಹ ಕೊಡಲಾಗಿತ್ತು.
ಹೌದು.
ನಾನು ಗುಂಪಿನ ನಾಯಕನಾಗಿದ್ದೆ. ಪೇಜ್ 39 of his devotion.
Please, my lord. ಕಂಪ್ಯೂಟರ್ ನನಗೂ ಮತ್ತೆ ಎದುರಾಳಿಗೂ ಈ ಸಂಸ್ಥೆ ಇಮೇಲ್ ಸಂಪರ್ಕ ವಿಳಾಸ ಕೊಟ್ಟಿತ್ತು, ಪ್ರತ್ಯೇಕವಾದ ಪಾಸ್ವರ್ಡ್ ಅನ್ನು ಸಹ ಕೊಡಲಾಗಿತ್ತು.
ಆಯ್ತು, we can say the cross examination of PW1 as well as the evidence of RW1 shows that the petitioner himself had facilitated PW, the first respondent, to use his computer, and on his email ID only she was.
He created an email for her.
But he was also using.
He was also using. He knew
on
the
his
password.
Email ID only. She was sending mails whenever required. Thus, it becomes clear that that email was accessible. Email account was accessible to both of them. Both of them.
ಪಾಸ್ವರ್ಡ್ ಅನ್ನು ನಾನೇ ಮಾಡಿಕೊಟ್ಟಿದ್ದೇನೆ. He admits the password.
He admits that he only had created the password for the said email account. In the camera. Therefore, it becomes hard to accept that ಅಂತ ಮೆಸೇಜ್ ಅದ್ರ ಮೇಲೆ ಕಳಿಸ್ತಾರೆ. She sends such messages on through said email, which was accessible to her husband also. Secondly, the certificate as required under section 65B of the Evidence Act was not produced to prove those emails. Really, the last in view of Constitution bench, Arjun Pandit Rao Kotkar.
Para 60.
Bench consists of the Honorable Supreme Court in Pandit Arjun Pandit Rao Kotkar's case referred to Supra has held that unless the certificate required under section 65B of the Act is produced, the Evidence Act is produced, such secondary evidence, namely the printouts of emails are not admissible in evidence. Leave apart the proof of the same. Therefore, the trial court was justified in rejecting the said email. Exhibit P3 to P145, as proof of the alleged exchange of emails between obstructional emails between the respondent number 1 and 2. Next one. So far as exhibit P2, the compact disc, the petitioner claimed that regarding the conduct of respondent number 1 and 2, Panchayat was convened in the parental house of parental house of respondent number 1, and in that in the said Panchayat, respondent number 1 confessed about her adulterous life. And her uncle and grandmother had admonished
her brother, respondent number 1's brother.
Our uncle also participated ಅಂತ
ಇಲ್ಲ ಬ್ರದರ್ ಅಲ್ಲಿ ಅವ್ರ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳಿದಾರಲ್ಲ ಬೇರೆ
ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಬ್ರದರ್ ಅಪಾಲಜಿ ಕೇಳಿದ್ರು, ಗ್ರ್ಯಾಂಡ್ ಮದರ್ ಮುಂದೆ ಅವ್ರು ಒಪ್ಕೊಂಡ್ರು ಅಂತ ಅಲ್ವಾ?
Please. Uncle, brother, grandmother and the relatives.
She was admonished it was further alleged that the brother of respondent number 1 pleaded to show mercy, apologizing, I'm sorry, forgiving respondent number 1. And all those conversations were found in exhibit P2. Basically, to prove such panchayat, the petitioner did not examine any of the persons who participated in the said panchayat. Secondly, to prove that the conversation contained in alleged conversation, ಅದನ್ನ play ಮಾಡಿ ನೋಡಿನೂ ಇಲ್ಲ.
ಅವ್ರು ಪ್ಲೇ ಮಾಡ್ಲೇ ಇಲ್ಲ, ಐಡೆಂಟಿಫೈ ಮಾಡ್ಲಿಲ್ಲ, ಅವ್ರ ಎವಿಡೆನ್ಸ್.
Conversation contained in exhibit P2 was
voice was not identified by the PW1.
Respondent number 1 and the other persons stated by him. The said document, I'm sorry, no requisition was made by the petitioner to the court to send that for voice identification test or lab test. Therefore, the trial court was
The respondent
justified.
has denied the voice.
More so when respondent denied the voice. Therefore, the trial court was justified in rejecting exhibit P2 also. From the
Rejecting.
Thirdly, the petitioner claimed that the adulterous relationship of respondent number 1 and 2 was witnessed by his friend one Sudhir Nagaraj. Sudhir Nagaraj. ಅವ್ರ ಫ್ಯಾಮಿಲಿ ಅವ್ರು ಬರೋದಿಲ್ಲ ಅಂದ್ರೆ ಅವರಾದ್ರೂ ಬರ್ಬೋದು.
In para 11 ಅಲ್ಲಿ
Sudhir
ಹೇಳಿದ್ದಾರೆ,
Nagaraj.
ಸುಧೀರ್ ನಾಗರಾಜ್.
But he was not, and he revealed to the petitioner about such relationship, but he was not examined. ಮತ್ತೆ ಅಂಕಲ್ ಅನ್ನು ಹೇಳಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು, ಅವರ ಅಂಕಲ್.
Even before they went there, the petitioner claims that one Shankar, the uncle of respondent number 1, informed him about the adulterous life of respondent number 1. Even he was not examined. The couple had a child out of the marriage. Yaವಾಗ 2003 ಅಲ್ಲ?
Please,
They born in 2000?
Well, it's 5/10/2003.
2003.
ಮದುವೆ ಆಗಿರೋದು?
2002. He was 5 years old.
2002.
Born in the year 2003 itself. The petitioner claimed that even at the beginning of the marriage itself, ಮೊದಲೇ 2003 ಒಳಗನ ಅವ್ರ parental house ಅಲ್ಲಿ she was indifferent ಅಂತ ಹೇಳಿದ್ರು.
Immature, irresponsible ಹೇಳಿದಾರಲ್ಲ, para 4 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. Luxurious life.
She was leading luxurious life.
Demanding.
The petitioner, I'm sorry, respondent number 1 was irresponsible, demanding jewelry, luxurious life, etc. Our father ಹೇಳ್ತಾರೆ. And the marriage was consanguine marriage. ಅವ್ರ ತಂದೆ ಹೇಗಿದ್ದಾರೆ ಅಂತ ಇವ್ರಿಗೆ ಗೊತ್ತಿರೋದಿಲ್ವಾ ಮೊದಲು?
ಹೌದು. ಸೋದರ ಮಾವ ಆಗ್ಬೇಕು. He must be the maternal uncle for her.
This man was a maternal uncle.
Maternal uncle. This petitioner is the appellant here, Lokesh Jagannath.
But he did not raise any whisper about her such conduct till 2008. Till filing of this petition in 2008. He also makes allegations against the father of first respondent, saying that he was an alcoholic and chain smoker, etc. But he himself admits that the respondent number 1 and himself were related by blood even before their marriage. And he willingly married her. After 6 years, After 6 years of the marriage, he comes up with the allegation that his father-in-law was a drunkard and smoker. ಸತ್ತೋಗಿರ್ತಾರಲ್ವಾ ಅವರು by that time he had died. That too after the death of his father-in-law. He had died. ಎಲ್ಲೋ ಬಂದಿದೆ ನೋಡಿ. ಅವರಿಬ್ರು ತೀರೋಗಿದ್ದಾರೆ ಅಂತ ಅಜ್ಜಿ ಮನೇಲಿ ಇದ್ದಾಳೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. May 2007 in the she started denying. In the petition he claims that since May 2007 the first respondent started denying him physical proximity, but as pointed out by the trial court, in his cross-examination he admits that between May 2007 and October 2007 they had physical relationship with each other. The trial court. So far as the section reliance on section 14 of the Family Courts Act by the learned counsel for the appellant, the said as the general principle, the parties, the proceedings are governed by the Evidence Act. Section 14 makes only exception by way of discretion to the family court. For receiving the evidence or any report, even though the same is irrelevant or inadmissible under the Evidence Act. But that comes with a qualification that such a report or document should assist the court to deal effectually with a dispute. In the present case, as already pointed out, the petitioner admitted that along with he also had a control over the device through which the alleged mails were sent. Secondly, he did not examine any other independent witness to the alleged adultery, though he named them. He named them. Therefore, there are no reasons either to the trial court or for this court to exercise the discretion under section 14 to receive an inadmissible documenting or rely on that. Look from any angle. There is no merit in the appeal, hence the appeal is dismissed with cause of conva. Questions, at 2:30 first of all, why they had mentioned it at 2:30? They wanted. Oh, I don't know, they mentioned ಮಾಡಿ 2:30 ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. ಹಾಗೆ ಎಲ್ಲ ಬೇಗ ತಗೊಳ್ಳಿ ಅಂತ.
2:30 ಮಾಟ. Set number 52. Patil Bharti Tamanna Gowda, T.S. Rajarajeshwari.
I'm the appellate in this case, madam.
Who were pressing this 2021?
ಆದ್ರೆ ಇದು ಏನಾಗಿದೆ ಮೇಡಮ್, 2 times marriage, second marriage, second divorce, both the parties.
Both
And-
parties?
are married twice
Huh.
and ಎರಡು ಸಲ.
Order.
No, yeah. The marriage in question now before this court is the second marriage for both the
Yes.
Both the
spouses.
parties, huh?
Yes.
Each one had an amicable settlement in the first marriage and this was the second marriage. My contention before the lower court was the second marriage was suppressed and she's got some mental health issues like her IQ is very low, which has been mentioned in the earlier case. I appear for the husband
Now we have
respondent.
two parted matters. So you requested, so we have listed it at 2:30. ಇಲ್ಲಾಂದ್ರೆ ನಾಳೆ ತಗೊಳ್ತೀವಿ. ಅವೆರಡು ಮುಗಿಲ್ parted ಇದೆ ಇನ್ನು ಎರಡು which are older than this.
ಅಲ್ಲ ಆಯ್ತು ಮಾಡ್ಬೋದು.
ನಿಮ್ದು 2021 ಅದು ನಮ್ದು parted matters 2017. ಎರಡು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅದಕ್ಕಿಂತ ಓಲ್ಡರ್ ಇರ್ತವೆ. ನಿಮ್ದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಯಾವ್ದು? ನಿಮ್ದು 2014 ಅದೆರಡು ಕೊಡಿ. ಸೊ
ಯಾವತ್ತಾದ್ರೂ ಮಾಡಿ.
two matters will take up.
ಅಲ್ಲ.
ಅದ್ರಲ್ಲಿ ಯಾರು ಇರ್ಲಿಲ್ಲ, ಅಕಸ್ಮಾತ್ ಇದಾರ ಇಬ್ರು ಯಾರು ಹೇಮಂತ್ ಕುಮಾರ್ ಅಂಡ್ ಸುಧಾಕರ್, ಇವರು PP ಹೆಗ್ಡೆ ಅವ್ರದ್ದು ಸೋಮರೆಡ್ಡಿ ಅಂಡ್ ಗುರುದತ್. ಯಾರು ಹೇಮಂತ್ ಕುಮಾರ್ ಅವ್ರ ಕೇಸಲ್ಲಿ ಇದಾರ? ನೆಕ್ಸ್ಟ್ ಯಾರು ಹಿಯರ್? ಅವ್ರು ತಗೊಂಡ್ಮೇಲೆ ತಗೊಳ್ತೀವಿ ನಿಮ್ಗೆ. Because they are parted.
Further hearings, number 28.
ಇವ್ರದ್ದು ಮುಗಿಸೋಣ ಮೊದಲು. ಯಾರ್ದು SFC ಮ್ಯಾಟರ್ ನಿಮ್ದಲ್ಲ, ಅವ್ರದ್ದು SFC. ಯಾರು ಹೇಮಂತ್ ಕುಮಾರ್ ಅಂಡ್
ವೆಂಕಟೇಶ್ ಸೋಮರೆಡ್ಡಿ
ಅಲ್ಲ ವೆಂಕಟೇಶ್, ಹೌದು ಅದ್ರಲ್ಲೇ ಕರೆಕ್ಟ್. ಇವ್ರದೇ ಮಸ್ಟ್ ಅಲ್ವಾ ಫಸ್ಟ್ ಇರೋದ SFC. ಹೇಮಂತ್, ಯು ಆರ್ ದೇರ್. ಹೂ ಇಸ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ ಹಿಯರ್?
But it's not SFC.
ಅಲ್ಲ, ಬರೀ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್.
Family court.
ಫ್ಯಾಮಿಲಿ SFC ಅಲ್ಲ, we made a mistake.
Yes.
FC ಅಂತ
SFC ಇದೆ.
SFC SFC ಒಂದು ಇತ್ತು ಅದು ಮುಗಿದು ಬೆಳಿಗ್ಗೆ ಸಾರಿ FC ಇದು ಶುರು ಮಾಡಿದ್ರೆ
ಏನಿಲ್ಲ ಇದ್ರದ್ದು ಜಸ್ಟ್ ಕೇಳಿದೆ ಅನ್ಸುತ್ತೆ. ನಾನು ನಿನ್ನೆ ಜನರಲ್ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡಿದೆ.
Yes, what
It's
was
an ex parte judgment decree of divorce, ma'am.
correct?
I would yesterday.
ಅದಕ್ಕೆ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಕೇಳೋಣ ಅಂದ್ವಿ. If you was heard, there is a child. Okay, ನೀನೆ we had heard it, right?
Yesterday. Minutes.
ನೀವು
He was in UK.
ಇದು ಅಲ್ವಾ, ಅಲಿಮನಿ ಇಲ್ಲಿ ಬಂದ್ರೆ ತಿರುಗಿ ದೇ ಡೋಂಟ್ ಹ್ಯಾವ್ ಅ ಹೌಸ್ ಟು ಸ್ಟೇ, ಅಲಿಮನಿ ಕೊಟ್ರೆ ಓಕೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಿ ನೀನು. ಏನ್ ಹೇಳ್ತಾರೆ?
It's on his legs, my lords. He'll come, my lords. He's ready.
ರೆಡಿ ಇದ್ರು ಬರ್ಬೇಕಲ್ಲ. Get him.
That to what she says, my lords.
Expert decree will proceed to pass judgment. Naresh, this one is only on the ground of desertion it is granted.
Yes, my lords. My lords, she was in UK. It's a admitted fact, my lords.
Paper sub service ತಗೊಂಡಿದ್ದಾರೆ, paper publication
Paper
ತಗೊಂಡಿದ್ದಾರೆ.
publication here in Bangalore.
Bangalore.
Correct, she according to
So before paper publication, my lords, they have issued process to UK. The wrong address, it was not served, but paper publication is taken here at Bangalore and she was placed expert.
that is sufficient to set aside the judgment and decree.
It's a fraud played on the court, man.
2003 now 20 years ಆಯ್ತು. There was delay, ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ, there was delay in
Yes,
filing the.
yes, ma'am. That has been condoned by this honorable court, my lords.
ಏನ್ ಗ್ರೌಂಡ್ ಇದೆ ಅವ್ರಿಗೆ? ಅದಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅವರು.
No, my lords. Ground is there, my lords.
What is the ground, you tell us?
The ground is that, my lords, after the decree of divorce, my lords, the respondent herein has remarried again.
ಅದನ್ನ ನಿನ್ನೆ ಯಾರೋ ಹೇಳಿದ್ರಲ್ಲ ಇದಕ್ಕೆ.
That's, I was there.
You were
was-
there,
He has married again.
For that we said we cannot, conform a
My lords,
decree only
the-
to legitimize the second marriage ಅಂತ.
My lords, there are several judgments of the Supreme Court, my lords, which says with respect to that.
Yes.
Therefore,
Show us what is that Supreme Court judgment. Now also what they said, there is a, mentally unsound daughter, 37 years ಅಂತ
She
ಹೇಳಿ.
is living, the both mother and daughter is living on a social security provided by the
That you have said.
government over there. I have a document also along with my affidavit I have submitted.
If you make some arrangements, at least for daughter you have to make arrangement, relationship is admitted.
please.
Well, she is 63 years old. Well, she was working as a lecturer earlier. Due to her advanced age, well, no universities or schools are hiring her. She is living entirely in a social security provided by the government over there. I have produced the documents to show that she is living in a social security along with my affidavit, my lords, along with her affidavit. That is there before the court.
Statement of objection. Then appeal having by infractors ಅಂತ application ಹಾಕೊಂಡವ್ರು ಇವ್ರೆ. ಇವ್ರ
Is-
ಮದುವೆ ಆದ್ರೆ appeal ಆಗಿರಿ infractors ಆಗುತ್ತೆ.
Judgments of the Supreme Court. my
They
lord, which-
produce a judgment stating that my lords,
Which is the
appeal is delayed anta. In that case, my lords, what the judgment they have produced, in that case, my lords, the matter is contested. The wife contests the matter, she suffers a decree, thereafter she delays in filing an appeal. In that way, of the matter, the appeal was dismissed, but in this scenario, my lords,
period
it is an ex parte completely, my lords.
first marriage does not.
She was not even known.
See, apparently she was living in a foreign country. They have taken a paper publication in this country.
Yes, my lords. My lords, it is at the insistence of the respondent, my lords, they both were staying in UK. He also accompanied them while going to UK with them at the first instance. And he returns back, he goes back. He says that you please stay here in the better prospects of the, or better future of the daughter.
Wife contracting the second marriage during pendency of appeal against the divorce decree.
No, it's not right. It cannot be right.
Second marriage was not void ಅಂತ hold ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇನೆ. Yes, unless and until this decree is not set aside, it becomes void. ಏನು ಇದ್ದಂಗೆ ಕಾಣಲ್ಲ ಅಷ್ಟೇ. We'll proceed to dictate the
No,
judgment.
my lords, it's there.
Then you should get them, whether we should wait for them.
No, my lords.
Go and get him within 10 minutes. We
Please.
take up the next matter, otherwise we'll proceed to pass the judgment.
Please.
ನಿನ್ನೆ appeal ಮಾಡಿದ್ರಲ್ಲ.
Cell number 29, B. Sudhakar, Gurudatta K.
I am for the first respondent, my lord.
Appeal and my lord, in this case, my lordship, I requested to file better affidavit. My lord, I sent the email little bit late, my lord, I could not read.
ಹೆಂಗಂದ್ರೆ dismiss ಮಾಡ್ತೀವಿ ಅಷ್ಟೇನೆ.
kindly.
2520 days ಗೆ ಏನು ಇಲ್ಲ. See, there cannot be two yardsticks, one for you and one
Hello.
for them.
Maybe, my lord, I will file an affidavit, my lord, then make lordship may take decision, my lord. Hello.
We
On the
have given you time to file an
Please,
affidavit.
my lord, I have sent. It is my mistake, my lord.
Upon,
Only
I mean,
a
adjourning
week's
to-
time, my lord.
Only for the parties' convenience.
A week's time, my lord, then my lordship may,
Appeal is filed in the year 2020.
please, my lord.
Why of the limitation act? So many appeals of the government are dismissed on that.
Please, my lord. ಒಂದು affidavit ಹಾಕ್ತೀನಿ, ಅದಾದ್ಮೇಲೆ court can take decision.
23 came to my knowledge, same was referred to government pleader for my opinion. Last time here ಮಾಡಿದೀವಿ ನಾವು.
ಅದೇ ಸ್ವಾಮಿ, ಅದು ಬೆಟರ್ affidavit ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ.
Your government advocate himself suggested that it's not a fit case to appeal.
Only a week's time, my lord, I will file.
Between 2013 to 15, no explanation.
ಅದೇ.
And then now last time, 2000,
It was observed by the court, my lord, then I told.
2015 to ಎರಡು ಸರಿ explain ಮಾಡಿಲ್ಲ ಅಂತ. 2015 ಇಂದ ಮತ್ತೆ 2020 ವರೆಗಿಂದು explain ಮಾಡಿಲ್ಲ ಅಂತ.
ಅಲ್ಲ. A week's time, my lord, then court may pass.
See, we were not, there was no obligation for us to grant you. ಆಯ್ತು ಏನ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಅಂತ ಕೊಟ್ಟಿದೀವಿ ಅದು.
ಬರೀ ಒಂದು ವಾರ ಸ್ವಾಮಿ. ನಾನು ಅದಾದ್ಮೇಲೆ ಕೋರ್ಟ್ ಮೇ ಪಾಸ್ ಆರ್ಡರ್ಸ್. Court may pass my lord. A week's time, my lord, then court may pass orders.
Orders and I number 1 of 2020. This appeal is filed, heard, this appeal is filed challenging the award dated 5/1/2013 passed by in LIC number 2 of 2006 passed by the principal senior civil judge Shimoga. ಅಲ್ಲೂ ಕಾಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲ?
ಅಲ್ಲಿ contest ಮಾಡಿಲ್ಲ.
The reference is in time ಅನ್ನೋದು ಒಂದು ಪಾಯಿಂಟ್. Value of the compensation 47 per square feet.
Per square feet.
ಎಕ್ಸ್ಚೆಕರ್ಸ್ only 1 week ಮ್ಯಾಮ್ ಆಮೇಲೆ
ಅಲ್ಲ
court
ನಾವು
ma'am.
ಎಷ್ಟು ಸಾರಿ ಕೊಡ್ಬೇಕು ಟೈಮ್
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ನಾನು ಒಂದ್ ಸ್ವಲ್ಪ ಡಿಲೇ ಮಾಡಿದೆ ಅಷ್ಟೇ.
ಅಲ್ಲ ನೀವು ಆಗಿದ್ರೆ ಯು ಆರ್ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ನಾವು ಇಫ್ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ ಯಾವ್ದು ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ದಟ್ ವಾಸ್ ಆನ್ 11/6/2014 2024 ಅಫಿಡವಿಟ್ ಹಾಕಕ್ ಹೇಳಿದ್ದೆ ಅವಾಗ
ಅದು ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್
ಬೆಟರ್ ಅಫಿಡವಿಟ್
ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ
11/6 ಆಸ್ ಎ ಫೈನಲ್ ಚಾನ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದೀವಿ ಅದು
ವೀಕ್ಸ್ ಟೈಮ್ ಇಫ್ ಐ ಆಮ್ ನಾಟ್
ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಇಂಪ್ರೂವ್ ಯಾಕಂದ್ರೆ ಅಷ್ಟು ದಿವಸದ
ಅವ್ರು ಏನಾರ ಒಂದೇ ಒಂದು ಚಾನ್ಸ್ ಕೊಟ್ಟು ನಾನು
ಏನ್ ಹೌ ಆರ್ ಯು ಗೋಯಿಂಗ್ ಟು ಎಕ್ಸ್ಪ್ಲೈನ್ ಇಟ್ ಪ್ಲೀಸ್ ಟೆಲ್ ಅಸ್
ಮೇಡಮ್
ಫಾರ್ ಯು ಸೇ ಇನ್ ಯುವರ್ ಅಫಿಡವಿಟ್ ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ನೀವೇ ಹೇಳ್ಕೊಳ್ತೀರಿ ಯುವರ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಸೆಡ್ ದಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಫಿಟ್ ಕೇಸ್ ಟು ಪ್ರಿಫರ್ ಅಪೀಲ್ ಅಂತ 2000 ಯಾವಾಗ ಹೇಳಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ ದಟ್ ವಾಸ್ ಇನ್ 2013 ನಲ್ಲಿ ದೆನ್ ಅಪ್ ಟು 2015 ಏನ್ ಮಾಡಿದ್ರಿ ಅಂತ ಇಲ್ಲ 2015 ನಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ಗೆ ರೆಕಾರ್ಡ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ವಿ ಅಂತ ಹೇಳ್ತಾರೆ ದೇರ್ ಆಫ್ಟರ್ 2015 ನಲ್ಲಿ ಇಲ್ಲಿ ನೋಡಿ ಪ್ಯಾರಾ 9 ನಲ್ಲಿ on 3/11/2015 the company secretary has written a letter to the chief administrative officer stating that it is better to settle the matter by paying the amount ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ನೀವೇ ಒಪಿನಿಯನ್ ಹೇಳ್ಕೊಂಡಿದ್ದೀರಿ ಇಲ್ಲಿ ಇಟ್ ಇಸ್ ಬೆಟರ್ ಟು ಸೆಟಲ್ ಅಂತ ಹೇಳಿ ನೋಡಿ ನಾಟ್ ದಟ್ ನಿಮ್ಗೆ ಟೈಮ್ ಕೊಡಬಾರ್ದು ಅಂತಲ್ಲ ಮಾಡಿದ್ರು ಏನು ಇಂಪ್ರೂವ್ಮೆಂಟ್ ಆಗೋ ಚಾನ್ಸ್ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ
ಅಲ್ಲ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ 1 ವಾರ ಟೈಮ್ ಕೊಟ್ರೆ ಅದು ನೀವು ಡಿಸ್ಮಿಸ್ ಏನಕ್ಕೆ ನಾನ್ ಡಿಲೇ
It's also sale deeds are considered even on merits.
ಸೇಲ್ ಡೀಡ್ಸ್ ಆರ್ ಕನ್ಸಿಡರ್ ಬಟ್ ನಾಟ್ ಆಫ್ ಸೇಮ್ ವಿಲೇಜ್ ಮೆಲೋಡ್ ಇಟ್ ಈಸ್ ಆಫ್ ಡಿಫರೆಂಟ್ ವಿಲೇಜ್
ಅಲ್ಲಿ ಮೊನ್ನೆ ಹೇಳಿದ್ರು
Development
ನೀವೇನ್
cost
ಎವಿಡೆನ್ಸ್
53%
ಮಾಡಿದ್ರಿ
ಬಿಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲ ಮಾಡಿದ್ರ
ಕರೆಕ್ಟ್ ಇವ್ರು ಏನು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ ನೀನ್ ಅದನ್ನ
Yes.
ನೀವ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ವಲ್ಲ ಅದು ಸಿಮಿಲರ್ಲಿ ಸಿಚುವೇಟೆಡ್ ಎಲ್ಲ ಅಂತ PW1 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದೀರಾ
ಮಾಡಿದ್ರೆ ಸ್ವಾಮಿ ಈ ಪಾಯಿಂಟ್ ಬಂದಿಲ್ಲ
ECRs ತಗೊಳ್ಳಿ ಈಗೇನು ಅಡ್ಮಿಷನ್ ಸ್ಟೇಜ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದ್ರ ಬಗ್ಗೆ ಏನಾದ್ರು ರೆಫರೆನ್ಸ್ ಇದೆಯಾ
ಇದು ಈ ಪಾಯಿಂಟ್ ಮೇಲೆ ಮಾಡಿಲ್ಲ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿ
ಮತ್ತೆ
ಈ ಪಾಯಿಂಟ್
Evidence ಮಾಡಿಲ್ಲಲ್ಲ.
ಪ್ಲೀಸ್
There is no evidence.
even
for-
if we condone the delay how is it going to help you because you have not led your evidence limitation question ತಗೊಂಡ್ರೆ ಆದ್ರೂ ಮಾಡಿಲ್ಲ evidence you have not
they have to prove my lord we have not done our evidence
have succeeded.
but they have to prove their
ಅದಿಲ್ಲ ಬಿಡಿ ಆಗೋದು ಸುಮ್ಮನೆ
ಒಂದು ವಾರ ಟೈಮ್ ಕೊಟ್ರೆ ಸಾಕು ಆಮೇಲೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ
ನಿಮ್ ಪ್ರೇಯರ್ ರಿಜೆಕ್ಟೆಡ್ ಅಂತ ಬರ್ಕೊಳ್ಳೋಣ
ಬೇಡ ಬೇಡ
there is inordinate delay of there is inordinate delay of ಎಷ್ಟು 2520 ಎಷ್ಟು ವರ್ಷ ಆಗುತ್ತೆ
6 years
2520 days in filing the appeal the it is not the case of the appellant that the judgment in question was an ex parte judgment. The records show that they have appeared in the matter. In the affidavit, to condone the delay, even if it is longer one, the same shall be satisfactorily explained, and it should be shown that there was sufficient reason for the appellant for not filing the appeal in time. Or 2520 days delay has to be sufficiently has to be explained. The in para 5 of the affidavit, the executive engineer,
executive engineer
his the appellant states that they came to know about the award on 5/1/2013 itself. Award 5/1/2013 alva
2000
5/1/2013 itself, and referred the matter to the government pleader for opinion. According to the appellant itself, the government pleader gave an opinion saying that the matter is not fit for appeal. The deponent states that on 5/1/2015, he sent the documents I'm sorry, documents were furnished to him by SLAO on 5/1/2015. But he sent them to the Advocate General's office on 11/9/2015. ಹೇಗಾಗುತ್ತೆ ಅದು 5/10/2015 ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ರೆ 9/11/9 ನಾವು ಮೊನ್ನೆನೂ ಕೇಳಿದ್ವಿ ಈ ಪ್ರಶ್ನೆನ 11/9/2015 ಗೆ ಹೇಗೆ ಕಳಿಸ್ತೀರಿ? It is not said
Prior to that.
how the documents were secured on 5/10/2015 were sent to the Advocate General even before the said date, namely 5/10/2015. The affidavit further states that on 23/4/2015, Advocate General addressed a letter to Principal Secretary, so concerned Principal Secretary, to bring the notice to the Government Advocate of High Court. And on the requisition of verification, on requisition of the Government Advocate, the documents were furnished to the Government Advocate on 5/10/2015. But the appeal is filed on 2/28/2020. What was done between 5/10/2015 and 28/2/2020 is not at all explained. As against that, the deponent himself states that on 3/11/2015, Company Secretary has written a letter to the Chief Administrative Officer, Chief Engineer, Executive Engineer, KNNL, stating that it is better to settle the matter paying the amount. That goes to show that ಸುಮ್ನೆ ಈಗ ಏನಾರ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದಕ್ಕೆ ಅಪೀಲ್ ಹಾಕಿರ್ಬೇಕು ನೋಡಿ ಅಷ್ಟೇನೆ.
My lord, as it was that much of delay, my lord, we told I will not draft the affidavit. You should draft, you should ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾವೇ ಹೇಳಿ. That is the.
ತಪ್ಪಾಗಿದ್ದಾರೆ. False.
That itself goes to show that the appellant was advised to settle the matter instead of filing the appeal. Further, the records show that before the trial court also the appellant did not lead any evidence. Deposition copy ಇದೆಯಾ?
ಇಲ್ಲ.
The trial court based on ಯಾವುದು ಮತ್ತೊಂದು ಅವಾರ್ಡ್ ಮೇಲೆ ಮಾಡಿದಾರಾ? ಇಲ್ಲ.
SR value. SR value ಅಲ್ವಾ?
Sale.
ಎಲ್ಲೇ miscellaneous 3-year statistics per acre. ಯಾವ್ದ್ರ ಮೇಲೆ ರಿಲೈ ಆಗಿದ್ದಾರೆ? ಎಕ್ಸಿಬಿಟ್ C1 ಅಂತ ಅವರು ಒಂದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿರೋದು, ಒರಿಜಿನಲ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್. ಏನೋ ದೇರ್ ಇಸ್ ಸಮಥಿಂಗ್ ರಾಂಗ್ ಇನ್ ದಿಸ್ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಮಾಡಿದ್ರು?
ಯಾವ ಒಂದು ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಇದೆ.
Yes, as per the award, 3-year statistics were taken into consideration, wherein least amount of 84,210 per acre, highest amount of 1,80,000 average is taken. ಓ, ಅದ್ರ ಮೇಲೆ ಇದು ಹಾಕಿರ್ತಾರಲ್ಲ, ಏನು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಿರ್ತಾರಲ್ಲ ಪಾರ್ಟಿಷನ್ ಡೀಡ್. Property was within residential area. That's all. ಎಲ್ಲ ಪಾಯಿಂಟ್ಸ್ ಒಟ್ಟಿಗೆ ತಗೊಂಡಿದ್ದಾರಾ? ಸೊ ದಟ್ ಅಮೌಂಟ್ ಇಸ್ ಲೆಸ್ಸರ್ ದೆನ್ SR ವ್ಯಾಲ್ಯೂ ಅಂತ
ಅಂತ ಹೇಳ್ತಾರೆ, ಅವ್ರು ಹೇಳ್ತಾರೆ.
For converted land. So award nallane discuss ಮಾಡಿರ್ಬೇಕು ಅವರು.
Please.
Any evidence to substantiate its contention that the reference was beyond time. And the claim of the claimant is exorbitant. Exorbitant. The Shivraj Singh is the one. Settled. ಇದಲ್ಲ ಬೇರೆ ಇದು ಮೊನ್ನೆ ನಾವು it is settled principle. It is settled principle of law that the government does not stand in different footing than any other litigant before the court. Though sufficient opportunity was given to file a better affidavit, the same is also not done.
My lord, that is not.
ಅದು ಬೇಡವಾ?
ಅದು ಬೇಡ.
ಅದು ಬೇಡವಾ? Okay. ಯಾಕೆ ನೀವು ಕಳ್ಸಿರ್ತೀರಲ್ಲ?
ನಾನು ಕಳ್ಸಿದೀನಿ ಸ್ವಲ್ಪ ಡಿಲೇ
ಇಲ್ವಲ್ಲ ಅವಾಗ?
ನಾನು ಸ್ವಲ್ಪ ಇದು ಮಾಡಿದ್ದೀನಿ ಅಷ್ಟೇ, ಡಿಲೇ ಆಗಿದೆ ಅಷ್ಟೇ ಅದನ್ನೇ.
Absolutely no grounds are found to condone the delay. By no stretch of imagination. The ಇಲ್ಲವೇ ಇಲ್ಲ explanation sufficient ಅಲ್ಲ. Absolutely no ground. Absolutely there is no explanation for such inordinate delay, much less the sufficient reason. Therefore, the application is rejected. Consequently, the appeal is dismissed.
Please.
Excuse explanation.
Number 28,
Please.
Hemant Kumar D, Venkatesh Reddy.
Pardon me, my lord. My legs.
ಏನ್ ಮಾಡೋದು? We should keep waiting for you.
No, I was here only, my lords. I'm extremely sorry. Kindly
You
apologize.
don't empower your team.
No, they are empowered completely.
They are empowered, then why don't they argue? It's an expertise judgment. You have taken notice by paper publication.
Please.
And records show that she is living in some other country. And it was submitted that first you took the court notice to UK address, and there after it you have taken substituted service in Bangalore, which is that Mangalore local paper.
But in fact, the appellant and the respondents are relatives, my lords. They have common relatives as well.
Husband and wife.
Yesterday he made one proposal. Now they have 37 years old.
40-year-old daughter.
Mentally,
ಇಲ್ಲ ಅದು instructions, my lord. After this divorce, remarriage has happened. They are present.
remarriage.
Vipin.
First, out of this marriage, they have a daughter aged
No, my lord.
37 years.
She is employed, left the husband employed in London. This wife, she is PhD scholar, employed in London. Her daughter is also employed, aged 40 years now.
Where is the records? For
Nothing now on the same allegations. Please.
The only thing, now this service was not sufficient.
Please. No, that aspect, I beg to place some materials which is already on record, placed on record. my lord.
Yes.
The contention, according to her, that she is in London, etc. And kindly see, she has been visiting Mangalore. Permanent place of address is Mangalore. For that purpose, my lords, kindly see her own admitted documents. May I pray the honorable court to see the list of documents produced before this honorable court, my lord.
Yes. On September 2019, 29 2019, Ada.
So, on my
Statement
lord,
of objection.
14th June 2022.
14th June 22.
14th June 2022, my lords. This is about the,
14th June 22.
please, there kindly see, my lord. The documents pertaining to the case before the trial court and also
Citations ಇದೆ ಅದ್ರ ಜೊತೆಗೆ document
ಅದ್ರೊಳಗೆ page 27, my lord,
page
that
27.
marriage has already been divorce is 2007. After 2007, 2011, there is a remarriage by registered document, page 27.
Affidavit IA for disposal
ಅಲ್ಲಲ್ಲ ಸ್ವಾಮಿ ಇದ್ರೊಳಗೆ
14/6/2020.
ಐ ಆಮ್ ಸಾರಿ ಅದ್ರೊಳಗೆ 14/6 ಅಲ್ಲಿ ಎರಡಿದೆ. My lord, one is
Yes.
list of documents ಅಂತ ಇದೆ. I pray the honorable court to kindly see the list of documents first.
Yes.
One is that page 27.
Page 12.
Showing the registration of the second marriage on Honorable court got the same registration of the second marriage on 28 December. What is the effect? I will submit little later, my lord. 28 December 2011.
ಅಲ್ಲ ಇವ್ರ ಜೊತೆ ಅದಲ್ಲ ಅದು ಇನ್ನೊಂದು ಮ್ಯಾರೇಜ್.
Oh, second marriage. After the divorce of this,
At least you should have invited your daughter for the marriage, second marriage.
my lord, is a case. I don't want to repeat this, reiterate what has happened earlier, but the thing is, my lord, she herself deserted, and I don't want to say
Daughter
how.
cannot desert you.
Daughter has been stopped from even speaking to the father since long time. And she went along with the daughter. What happened was that there is a bank manager. She said when she had already done BCom at Mangalore, my lord, then MCom. She said, I'm going for higher education. He left. And after higher education, she said, I have a PhD opportunity in UK. She went there. Then never turned back. She was visiting Mangalore regularly. She did not turn back at all.
145 of 2003 was the petition, right?
Madhve, it's for me, date of marriage.
Date of marriage is
4/5/1983 is the date of marriage.
4/5/83 is marriage.
Date of that child, Varsha, my lord, who is now 40 years,
Date
is
of birth
date
of
of
the
birth
child
27/5/1984.
27/1984.
She moved to UK in 1991. Of course, UK address she has never informed. That is the ever mentioned in the petition.
Address, no, UK address in your petition.
Last known address, which was known to us.
No, somewhere you have now, you only gave some. You document.
We have mentioned, my lords, UK,
Family
last,
code 745 of.
howದು, last known address, and but she was visiting continuously Mangalore. Mangalore is her permanent place.
ಅಂತ ಕೊಟ್ಟಿಲ್ಲ ನೀವು.
My
ನಿಮ್ಮ
lord,
petition copy ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ.
my lord, actually her permanent address, even
so and so Bangalore,
please,
Roshni Mangalore,
Mangalore.
West Gate Close,
Please.
Canterbury, UK. Second address Mangalore ಕೊಟ್ಟಿದ್ದೀರಿ.
ಹೌದು.
Last known address ಅಂತ ಕೊಟ್ಟಿಲ್ಲ.
That I will, my lord, as far as her own admission there is there, my lord, showing that she is in Mangalore only. I will come to that little later, my lords. My lord, the MC petition is filed, the date 1991 she moved to UK. MC petition is filed on 26/5/2003. As per 74, MC number 745 of 2003. Date of judgment is 23/7/2007. My lord, appeal period of 90 days lapsed in October, 23 October.
Delay is condoned, no?
Now delay is condoned, my lord.
So ಇದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ ಕಂಡೋನ್ ಮಾಡಿರ್ತಾರೆ. She had no notice ಅಂತ.
My lord, delay is condoned. I will not speak because since delay is condoned, I am permitted to submit on merits and on other aspects, my lords. Otherwise, I will not have right to submit only. My lord, the date of judgment is, sorry, 23/7/2007. Second marriage is after 4 years on 18/12/2011. Registration 2800 ಮದುವೆ ಆದ್ಮೇಲೆ.
ಎಲ್ಲಿದೆ ಅದು?
ಅದರೊಳಗೆ
Registration, date of marriage, please tell us.
marriage, date of marriage is 18/12, my lord. 18/12/2011. Registration after 10 days on 28th December 2011.
20th is.
Now, my lord, after this, she files a case under 125 CRPC in Mangaluru on 15/6/2016.
15/6?
2016.
2016.
Please, my lord, as per criminal MC 42 of 2016, page 28, in the same, my lord. Same list of documents.
Page 28.
28, very next page, my lords. After registration. And here also, husband was residing in Bangalore. She never attends to him. She is regularly coming to Mangalore. residing permanently in Mangalore, though employed in UK, and she herself shows her address. In
ಅದು
the,
ಇವಾಗ 2016 ಅಲ್ಲಿ.
please, my lord.
Hmm.
I thought she has to now say she when she came, etc., my lord, and from which address, from which date she is there. 2016, my lord. Correct. Her address, your lordship, kindly same address.
CC ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಇದು criminal MC ಅಂತ ಮಾಡಿ.
Private complaint.
ಅಲ್ಲ ಅದು first ಇದು 28 your lordship kindly. First page number 28. First is page number 28. That's 125.
Yes.
Husband's address mentioned as Bangalore. Her address is mentioned, and page 29, relevant portions from her own statement. Page 29, para 3, line number 3, obtained PhD so and so from Hyderabad. Next para 4, line number 2, she was a postgraduate in economics. The middle portion, in the year 1991, petitioner moved to UK to pursue her PhD. Last but fifth line, in the year 97, petitioner secured an employment in UK, etc., etc. Next para, page number 30, last but 4 lines, she says, she unemployed ever since the last several years due to recession in UK. Present, she is living with the government dole of 19 pounds per week. Submits that the petition in which the petition resides is under mortgage, house is mortgaged to local bank, could not repay the loan, etc. Then next page 31, para 8, in the middle portion, she says she has come to know about the second marriage. She mentions about the second marriage. Second marriage solemnized on 18/12, registered on 28/12. And next page, para 10, petitioner is residing, so and so. And along with this, she produces only some documents, document number 5, copy of the marriage certificate.
5 is.
ಅದೊಳಗೆ ಅದೇ page ಅಲ್ಲಿ, list of documents ಅಲ್ಲಿ, document number 5. When this he entered into the second marriage, in the form, my lord, it's shown as remarriage. After divorce, remarriage has happened. She produces only this document. She has obtained certified copy of everything, and she pleads ignorance of the second marriage, and also files a complaint. Kindly see next page, criminal case for bigamy. And this
was filed in which year?
Ugly to then 16.
16/6/2016. This petition was filed on 15/6/2016.
15.
Correct. Idraleno she says she came to know about his marriage.
Afterwards, that cannot be so, because once you obtain the certified copy of the second marriage documents itself, when got the second marriage,
Where is the document to show that when she acquired?
she has produced it. We have only this
When she
document.
has secured that on a certified copy.
ಇದ್ರೊಳಗಿಲ್ಲ. She has produced only this much, because that form is there, my lords.
No,
I would
not
just-
you have
That may not be very much, only to show.
You have produced. She has not
It
produced.
is her petition, my lords.
Her petition, but she had secured it long back ಅನ್ನೋದಕ್ಕೆ ಏನಿದೆ?
Anyhow, much prior to this filing of this petition.
Much prior ಅಂದ್ರೆ ಎಷ್ಟು ವರ್ಷ?
At least a day prior to filing of this petition, 2016. At least a day prior to that, 2016. Now she suppresses about that, 2016.
This is 2017 ಅಲ್ಲಿ petition file ಮಾಡಿದೆ.
Yes, files 2017 later, stating that now I come to know.
15/6/2016.
Please.
And petition is filed on 21/4/2017. Order sheet ಕೊಡಿ ಇದು. When this order is passed on IA 1/2017, delay condonation. ನೋಡಿ ನೀವೇ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದು 4/12/2019 ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ. Learner Council for Response submits that respondent is willing to release or relinquish his half share in the flat apartment in the name of the daughter, provided the appellant agrees for confirmation of the judgment and decree of the family court.
ಹೌದೌದು.
ಮತ್ತೆ ಈಗ ಅವ್ರು ಅದನ್ನೇ ಕೇಳ್ತಾ
ಈಗ ಅನಂತರದ್ದು, ಈಗ kindly see, my lord, now the problem is this. Now his age 2016 ಆಗ 62 ವರ್ಷ ಈಗ ಆಲ್ಮೋಸ್ಟ್ 72 ವರ್ಷ ಬಂದಿದ್ದಾರೆ ಅಲ್ಲ ವಿಪಿನ್ ಸುವರ್ಣ. He has married now, his health has deteriorated.
19 ನೀವು ಒಪ್ಕೊಂಡಿದ್ದೀರಿ.
ಅದಕ್ಕೆ ಅವ್ರು ಒಪ್ಪಿಲ್ಲಾಗ ಹೋಯ್ತದು, ಅವ್ರು ಒಪ್ಪಿಲ್ಲಾಗ
I'm sorry, my
ಆಗ ಅವರು ಕೋಟಿ ಕಟ್ಲೆ ಕೇಳಿದ್ರು ಅಷ್ಟೇ. ಈಗ he is almost in the fag end of his life, his second wife is also there. And now there he has already, she has filed a petition under DB Act under 125 in Mangalore, exhausted all the remedies, and thereafter full-fledged inquiry, the court holds that she is employed in UK, she has suppressed her income, and therefore the petition is dismissed on merits. Those subsequent events are
That order has attained finality.
recent, that has been passed, they have to challenge it, my lords.
Whether that has attained.
They have to, they can challenge it, but they cannot have.
We
my
have to see in this case.
No, my lord, your lordship may kindly
In
see.
this case, we have produced an affidavit along with the document to show that she is living in a
Yes.
social. Is before this honorable court, my lords.
Not about that.
That is one thing. They are stating that, my lords, it is only after filing of these two cases, my lords, which he has referred. In filing an objections, he got this judgment and decree of divorce, my lords, then he has produced.
Yesterday,
Only then she comes to know. After that, she has filed this appeal.
we wanted to see that orders are 1 of 2017. ಯಾವತ್ತಾಗಿದೆ ಅಂತ. ಅದೆಲ್ಲ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ.
ಹೌದು.
Yes, 18/12/2019 order is passed.
No, I do consider this position, my lord, as far as the condonation of delay is concerned, now I may not be able to be.
Yes, there is a bona fide and unintentional reason as to why there is a
Please.
delay in filing the appeal. ಇದೆಲ್ಲ ಗಾಟ್ ಮ್ಯಾರಿಡ್ ಎಟ್ಸೆಟ್ರಾ ಎಲ್ಲ ಅವಾಗ್ಲೂ ಹೇಳಿದಿರಿ.
ಹೌದು, ಹೌದು. No, my lord, as for condonation of delay, I fairly beg to submit to the honorable court, my lords.
Are sufficient.
Please.
We note that reason assigned by the appellant.
No, my
for
lord,
condonation
I am
of
not on
delay
the-
is Sufficient and it is condoned. On same grounds ಇತ್ತಲ್ವಾ?
I am not on condonation of delay, my lords. I do
No,
concede, I cannot now argue.
The application was allowed on the same ground that she was not
Delay,
served.
my lord.
She decree is granted
my lord.
without hearing her.
No, my lord.
On the same ground here
No,
also.
I cannot plead on the condonation of delay, my lords. I do I am only bringing it to the notice for another purpose, my lords.
No, now you are trying to say that
No, no,
she
no, no.
was aware.
No, no,
she
no.
Filed this petition, etc.
No, how the petition is filed, the only the modus in which it's filed, that's all. It's for another purpose, the collateral purpose only, that's not the main purpose, my lords. Why I am submitting to the honorable court is kindly see that document, my lords.
Ask the client to take his seat.
Please, my lords.
Ask
And
the
good
client
for
to take his seat. At least ಮಕ್ಕಳಾದ್ರೂ ಇರ್ತಾರಲ್ಲ ಅವ್ರಿಗಾದ್ರೂ ಕೇಳ್ಬೇಕಲ್ವಾ?
ಯಾವ ಸ್ವಾಮಿ?
Now daughter might have
No, my lord, in fact, now the daughter has a responsibility of looking after the aged father. She never comes here. She is employed there, all this. No, 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 I don't want to say anything because, my lords,
And they were young when they needed.
I'm very sorry to say, don't, my lords, I let no blame come on me, my lord, stating that I am now blaming the ex-wife, but she is responsible. My lord, after having going to UK, my lord, she should come back and reside with the husband. After only PhD ಮಾಡಿ, husband sends everything. No, this is the started set of
We were
affairs.
saying, if not for the wife, he has the responsibility.
It is
for
the wife
daughter.
who has stopped the daughter from speaking to the husband, and she has kept the child away, and now also she is guilty of suppression of material facts. She had employment, she had rich,
Petition was filed. This
she has all the income, all the materials, she suppressed everything from the honorable court.
filed
She wants to sit in UK.
2003. When this petition was filed in 2003, what was the age of the daughter? ಈಗ 37 ಅಂದ್ರೆ 2003 ಅಲ್ಲಿ ಎಷ್ಟಿರುತ್ತೆ?
84.
20 years, 37.
ಮೆಜಾರಿಟಿ ಆಗಿದೆ. ಮಾತಾಡ್ಲಿಕ್ಕೆ ಬಿಟ್ಟಿಲ್ಲ ಇದು.
20 years, 17 years ಇರುತ್ತೆ ಅವಾಗ.
ಮಾತಾಡ್ಲಿಕ್ಕೆ ಬಿಟ್ಟಿಲ್ಲ. She is guilty of keeping the child away.
ನೀವೇನ್ ಮಾಡಿದ್ರಿ? ಕಸ್ಟಡಿ
We have-
ವಿಸಿಟೇಷನ್.
Now, my lord, may I submit, my lords? Let me put myself into his shoes. The wife goes and stays in UK. How can I get him back? I am a bank manager. How? It's impossible.
When we come to the issue of the daughter, he switch over to the wife's issue.
No. Now they claim not for me, for the daughter you give, etc. Now we are in a serious precarious situation, my lords. As for the financial condition, there's only one house. You want second wife is there. What fault she has committed? I can't desert her and say that the property be transferred to the.
You can desert a 17-year-old daughter.
That, I'm with great respect, my lord. That's not true.
So
No. She got
you
lucrative employment.
to her
No,
second
no.
wife.
No, my lords. She got lucrative employment after PhD. She stays there. She doesn't even come
ಅಲ್ಲ,
back.
only mother has the duty to take care of the child.
No, we have the duty. She did not allow him to speak
ಅವ್ರು
to
allow
the daughter.
ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವೇನ್ ಮಾಡಿದ್ರಿ? Did you file any petition for visitation rights or
No, in some,
custody?
Custody impossible. 17 years same custody kedu Swami.
Whatever circus you try to make here, it comes to that only. This
No,
was
no, 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 no. Your lordship may kindly take it in this way.
decree was passed
Seeking
with-
custody of 17-year-old, 18-year-old daughter is impossible task, my lords. Seeking custody by the husband. And that too,
In your
she is in
petition,
UK.
please take us
My
through
lords,
your
this petition itself speaks, my lords.
According to your
1991 itself,
petition,
he has been deserted.
deserted according to your petition, cause of action ಹೇಳಿರ್ತೀರಲ್ಲ?
1991, the cause of action, he says
Yes.
from the date of marriage itself, there is a, 1991, there is a desertion.
And
Cause of
I-
action is 1983 itself.
Cause of
My lord,
action for the
kindly
petition.
appreciate the practical
Corruption,
difficulty
4.3.
of the husband also, my
Thereafter,
lords.
during 1991, when the respondent went to Yorkshire, and
Please.
during 1997.
Is her own petition,
when
her own
petitioner last decided together as husband. So,
Her own petition says 91 she went and she doesn't say.
ಅದಕ್ಕೆ ನಾವು ಹೇಳೋದು, ನೀವು 1991 ಅಲ್ಲೇ ಡೆಸರ್ಷನ್ ಆಗಿದ್ರೆ, ಅವಾಗ what would be the age of your child?
Age of
8
the child,
years.
according to her, my lords,
8
she has
years, my
left.
lords.
No, no,
8
she
years, 7
herself
years.
said, my lords, she has left UK in 1991, my
From-
lords. Set the age, she second the
My
child.
lords, he also accompanied them to
Client is
UK.
not in, some western country, he is in India. There is a lot of difference between attitude towards the life in
ಹೌದು,
western countries
ಹೌದು.
and in
ಅದು
India.
ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ನಮ್ ದೇಶದೊಳಗಿದ್ರೆ ಅದಿರುತ್ತೆ, ದೇಶದಿಂದ ಯುಕೆಗೆ ಹೋದ ತಕ್ಷಣ ಅಲ್ಲಿ ಯುಕೆ ಕಲ್ಚರ್ ಬರುತ್ತೆ, ಅದಕ್ಕೆ ಅವಳು ಮಾತಾಡಿಲ್ಲ, ಗಂಡನಿಗೆ ಮಾತಾಡಿಲ್ಲ, ಮಗು ಮಾತಾಡ್ಲಿ ಬಿಟ್ಟಿಲ್ಲ,
ನಾವು ಗಂಡನ್ ಜೊತೆಗೆ ಮಾತಾಡಿದ್ ಕೇಳ್ತಾನೆ ಇಲ್ಲ.
ಮಗು ಬಿಟ್ಟಿಲ್ಲ, ಮಗು ಬಿಟ್ಟಿಲ್ಲ, my lords.
ನೀವೇನ್ ಮಾಡಿದ್ರಿ ಅಂತ ಕೇಳ್ತಾ ಇದೀವಿ.
Could not do anything. I plead my helplessness. That is happened to every husband here who has been deserted by the, my lords, it happens.
Happens to every husband.
No, no, who has,
ನಮ್ಮ ಮುಂದೆ
no,
ಅಷ್ಟೊಂದು
no,
custody
who has
case ಗಳು
taken the child outside, who has taken the child outside, it becomes impossible.
And now in
It
the
all
family
depends.
court, you see so many cases where the couple abroad are fighting for the custody of the children who are in India.
ಕೆಲವೊಮ್ಮೆ ಏನ್ ಮಾಡ್ತಾರೆ ಸರ್ ಇಂಥವ್ರು, ಅವಳು ಅಲ್ಲಿ ಇದ್ದಾಳೆ ಮತ್ತೆ ಅವಳ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿ ತೊಂದರೆ ಮಾಡೋದೇನಂತ ಬರುತ್ತೆ.
See now,
The question is, my lords,
her ground of petition is that she was not served.
not served that well, that I will,
Correct.
I beg to
Now
take my lord to
accepting that the delay is condoned.
delays conduct.
But what ground you have now?
I have the ground, one ground is page number 28, I showed to my lord that in one petition she shows she is residing in Mangalore. Page number 33,
Page number
33, one more case she files with the same address of Mangalore.
In 2016.
16, my lords.
What is the change, my lords? They never say. Now all of a sudden, now my permanent address.
Page number 30 and
Yes, yes.
33.
33 and also page 36, my lords. He is residing at so and so, page 36, same thing, same pleading. This is my lord. They never say, I abandoned Mangalore, I was never in Mangalore. On the other hand, they say,
Correct.
I am residing.
But after seeing all these things, the document was produced in 2000.
Oh, she has herself produced it. She has filed it.
ನೀವು
2016, my lords.
No, no, 2016 petition, she has filed a petition, my lords. I am filing before this honorable court.
It is a place of her mother.
ಹಾಕಿದ್ದೀರಾ? See, this was considered while condoning the delay.
I am not
All
in
these
condemnation of delay. I am not, I am only on the,
Not on condonation.
I am only on
Grounds
the,
are same.
please.
Now there is
No, 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 no. Kindly see, my lord.
constructive
Kindly see, my lord.
adjudicator.
As the condonation of delay is concerned, my lords, whether the appeal should be
Not
taken on
agree
it.
there. That was also contested.
Yes, my lords.
That's
That
that's
was
only a
also
condonation of delay.
contested. You know,
I beg to
conceal
submit.
ಮಾಡಿ
That's the
delay
intent.
condone ಮಾಡಿದ್ರು ಅಂತಂದ್ರೆ all right.
Yeah.
You can again urge these
No, no,
grounds.
at the interlocutory stage, my lord, that was the position, my lord. Now kindly see, my lord, on merits I am submitting,
There
whether
is
the
judgment, interlocutory stage.
notice is correct or not. This material was not there. ಎಷ್ಟು ತಾರೀಕಿಗೆ condonation ಮಾಡಿದ್ರು? With great respect, my lords, these materials. ಇಲ್ಲ, produce ಮಾಡಿ.
For their own fiction, she was. I mean.
May I submit one aspect, my lords?
ಅಲ್ಲಿ ಇರ್ಬೋದು ಏನು. See, this is- surface of constitution. ಮಗು ಇದ್ಮೇಲೆ ಏನು ಇರ್ಬೇಕಕ್ಕೆ?
May I submit one aspect with kind permission? Probably if I have understood the question of the honorable court correctly, whether this document was produced at that time, if there is a question, my lord, this was not at all within us. We did not know.
This point was probably raised.
ಇಲ್ಲ, ಇದಿರ್ಲಿಲ್ಲ, ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ. She residing in Mangalore document ಎಲ್ಲ ನಮ್ಮ ಹತ್ರ ಯಾವ್ದು ಇರ್ಲಿಲ್ಲ.
ನೀವು ಕೊಟ್ಟಿಲ್ಲ, but you were aware that this petition.
ಇಲ್ಲ, ಅವ್ರ ಕೇಸ್ ಹಾಕಿದ್ಮೇಲೆ
ಯಾವತ್ತೂ
he has filed a case, we got the summons later,
delay condone
and then we have contested it, then we have challenged it in the high court. Nam criminal case ಆಯ್ತು, register ಆಯ್ತು, 494 they got registered criminal case. We came to know only after the case was registered.
In 2019, 8/12/2018, 2019. By that time, this petition.
ಇಲ್ಲ.
My lords,
Now
by
Hakila.
that time,
Any
my
of that
lords,
was not produced because of
No,
court.
Hakilla, but you content.
by that time they have contested, my lords, they have contested and they have
My
filed
learned friend
only
has
at that,
completed,
no, no, let me.
complain.
Only
If
at that
you want to
point-
go on arguing, let him, no,
We'll
no,
see our
let him not.
state- We'll see our
Focus, no,
statement. We'll see
Please.
our statement of objection. There was no delay condoned.
This is produced, your lords, 2/3/2022, the date when I will have to, if the date when we came to know is after the summons was served on us from that court. Any of this question,
Statement of objections.
certified copy created. It's served on us. This was not produced, my lord, that's all. Your lords may kindly appreciate the effect of this. This cannot stop me from placing the truth before the honorable court, my lord, that the address shown by her is Mangalore. Only on that point, my lord.
ನೀವೇ ಹೇಳ್ಕೊಂಡಿದ್ದೀರಲ್ಲ ನಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ.
Yes.
Suppressing this fact, appellant has filed MC number 42 of 2016.
ಹೌದು.
ಅದು criminal miscellaneous. No, you said this matter was not placed before the high court ಅಂತ.
ಇದು ಮೆಮೊ ಹಾಕಿದ್ದಿಲ್ಲ, ಮೆಮೊ ಹಾಕಿದ್ದು ನಾವು 2022ಕ್ಕೆ.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ
Please, please.
ಹೇಳಿದಿರಲ್ಲ.
Please, my lord.
ಪ್ಯಾರಾ
No, my
8
lord.
ಅಲ್ಲಿ. No, now you are trying to say that this fact was not brought to the notice of the court. She filing in 2016 this criminal miscellaneous petition. But in para 8 of your statement of objection, you have said appellant has filed suppressing the true facts and making false allegation. Appellant herein has filed a case against respondent in MC number 1242 of 2016 for restitution of conjugal rights.
It is only after that. my lords.
Ultimately ನಾವು ಏನು ಹೇಳಿದ್ವಿ ಆಯ್ತು.
No, my lords. Please.
ಈ ಪೊಸಿಷನ್ಸ್ ಎಲ್ಲ ಈ ತರ ರಿವರ್ಸ್ ಆಗಿ ಆಗ್ಬಾರ್ದು ಅಂದ್ರೆ ಅದೇನು ಅವರು ಹೇಳಿದ್ರು ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ವಿ. ಅದರ್ವೈಸ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಪ್ರೊಸೀಡ್ ಟು ಪಾಸ್ ಆರ್ಡರ್ ಆನ್ ದ ಮೆರಿಟ್ಸ್.
My lord, as far as the party is settling, we have absolutely no objection, my lord. His difficulty also is informing, my lord, that's all. Otherwise, putting a
He was a retired bank manager.
retired bank manager, he is now residing with his second wife, only one house.
He will repeat that.
So second, no, this is the situation, no other assets except the house. No other assets except the house.
We have
Now, my
made
lord,
a
may I
say-
submit only one thing?
Once you have made a statement before the court that he gives up his half share in that property.
No, they demanded, at that time, they demanded much more, they demanded crores. Now they come up because after full-fledged inquiry before the competent court, my lords, the court holds that he is not entitled to. There is already a reasoned order by a concerned court, my lords, on this point.
That's a false submission made both.
We will pass on, may I pass on, my lords?
ಅವ್ರು ಮುಗಿದ್ ಹೇಳಿ ಆಮೇಲೆ.
May, this is not under appeal, I feel. There is a judgment passed by the competent court, my lord. If my lord permits, we'll pass on the judgment. Because what they say repeatedly is false ಅಂತ ಯಾಕೆ ಹೇಳ್ತಾರೆ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ, matter was
May
referred
I
to
pass on, my
mediation.
lords? There is a judgment
These are
passed.
referred to the mediation center.
Section 9 petition.
ಅಲ್ಲ ಇದು MFA, this matter was referred to mediation, my lords. At that point of time, the husband was very blunt and he said, he don't want to settle.
My lord,
So she went
Alright.
back.
now,
Now you argue on the main matter, that's all.
please. Now, my lord, now the claim etc. is concerned, my lord. There is a duty cast in the courts below, my lord, to place all the materials. There was evidence was also led. She was examined in this case, my lords. And she failed to produce her true details. And this order has been passed on 13th August 2023. She is represented by the advocate. And she continues to show the same address. Given in evidence. Now there is no appeal. I don't want to say anything, my lord. There is no appeal filed against this. Now, my lord, merits as for this case is kindly permit me to submit 2-3 sentences on merits as far as this case is concerned. My lord, the situation is this, my lord. Now, whether, first question is this, my lords, whether there was proper service and the
Yes.
appeal is maintainable.
2023, no? 31/3/2000.
Howdu, howdu,
31/8/2000.
howdu. UK ಇದ್ದಾಗ ಎಲ್ಲ ಡೀಟೇಲ್ಸ್
This is different, this is criminal miscellaneous 100.
ಅಲ್ಲ ಮತ್ತೊಂದು ಹಾಕಿದ್ದಾರೆ ಡಿ ವಿ ಆಕ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಮತ್ತೊಂದು 125 ಹಾಕಿದ್ರು ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ 125 ಇದು ಮತ್ತೆ ಡಿ ವಿ ಆಕ್ಟ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಹಾಕಿದ್ದಾರೆ
Dismiss. ಅದು ಯಾವಾಗ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ?
I'm sorry, I don't have the exact date of that.
Criminal miscellaneous 42 of 2016 is also dismissed.
Sorry, I'm not able to have the date right now, my lords. Kindly see.
Are you aware?
Not aware of it, my lords. I'm not aware.
Yes.
It was told
My
to me
lord.
that it was pending consideration. Now, I don't know.
Or
As he
movement
submitted this
ಬಿಟ್ಟಿದ್ದಾರೆ,
disposed.
merits ಮೇಲೆ ಏನು argument
ಆಯ್ತು
ಮಾಡ್ತಾರೆ?
My lord.
ಏನ್ exercise ಮಾಡಿದ್ರು ಆಗೋದಿಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ. We'll make our endeavor to place the true fact.
No, no.
One aspect, I don't know how
ಆದ್ರೆ
to
ಅವ್ರಿಗೆ
overcome
either
this.
this way, that way settle ಮಾಡಿ
ಇಲ್ಲ ಇಲ್ಲ.
ಅಂದ್ರೆ
ಈಗ
parties are not ready
No,
for
my lord,
that.
in Neha versus Supreme Court said, both of us are bound to produce the true facts for this reason. Person residing outside, through the process of this court, I cannot get all the details. Their income, what's their assets, etc. I cannot get, my lords. They don't produce all the assets, details,
See,
etc.
now we are not considering that maintenance, we are.
Please,
we
please.
argue
Now, my
on
lord,
merits.
then I may come to only 2 points, my lord, on this point. Point number 1 I wish to canvass is last known address, residential address is this address, Mangalore address. And that's admitted to be the present address also in the judicial proceedings. So that has not changed. And notice is taken on the last public notice, advertisement on the newspaper is taken, my lord, in Deccan Herald and also Prajavani, both daily newspapers in the last address. Therefore, under order 5, my lords, rule 20, it's taken in the last known address, which is not in dispute.
Yes.
I also beg to sub-rule 1 capital A, my lord, of
This
rule 20, my lord.
that rules, the fire rule 20.
It should be in the last known address, and sub-rule 2 of rule 20 provides substitution shall be notice shall be effectual as if it's actual.
Now, what you wanted to show from five?
5 rule
20
20 provides for substitute service, my lords. Kindly permit me only on this sub 20 sub rule 2. 1A provides for the newspapers publication, my lord, at the last known address. 21A, my lord.
Omitted ಅಂತ ಇದೆ ಅಲ್ಲ ಇದ್ರಲ್ಲಿ 328.
Shall be on the, I'm sorry. He omitted.
ಯಾವಾಗಿಂದ ಇದು 1? It is omitted from
20.
with effect from 1 to 1977 ಅಂತ ಇದೆ ಅಲ್ಲ. Sub 20A.
Allala, 20, my lord.
Karnataka
1 capital A, my lord,
Report amendment to
inserted by act. I am reading SCC, my lord, with the latest edition, my lord. I'm so sorry if I'm wrong, my lord. Kindly pardon me
No.
if I'm wrong.
This is ಯಾವ್ದು ನಮ್ ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟ್ ಇರೋದಿದು. As amended by Act 4 of 2020, 15, ಯಾವ publication? 2016 publication. 2016 publication.
No, my lord, it's only newspaper publication. It provides for newspaper publication.
Order 20, Order 5, Rule 20, capital A provides for
Alla,
newspaper publication.
21 capital A, my lords, if I'm wrong. 21 capital A.
21 capital A, yes.
Also, please.
Yes.
Grateful, my lords. 1 capital A. By the court acting under sub rule 1, order service of an advertisement in newspaper shall be a daily newspaper circulating in a locality in which the defendant is last known to have actually and voluntarily resided. Carried on business the person so and so. The last known address, it cannot be disputed because now she continues even now.
Circulating in which the defendant is last known to
Yes.
have actually a
Last,
voluntarily
and
resided.
this aspect, now it's left, onus is left on
You said that she has shifted to
that, my lord.
Okay.
Now there's one gap.
last known address
Yes.
ಅಂತ.
Now, my lord, known means known from my sources is Mangalore only I mentioned, and he should say
But
now
you
before
have
this
given the address in your petition. ಎರಡು address ಕೊಟ್ಟಿದ್ದಾರೆ.
Reside. ನಾವು ಮಂಗಳೂರು ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಎರಡನೇ ಅಡ್ರೆಸ್, ಒಂದನೇ ಅಡ್ರೆಸ್ ದುಬೈ ಜಾಬ್ ಪರ್ಪಸ್, ಸಾರಿ ಲಂಡನ್ ಅಡ್ರೆಸ್.
First process is paid to London address.
ಲಂಡನ್ ಅಡ್ರೆಸ್, ಲಂಡನ್ ಮೇಲೆ ಫಾರ್ ಜಾಬ್ ಪರ್ಪಸ್.
That
Yeah,
London
given
address you
the
have to take.
London address only.
ಅಲ್ಲ, ಕೆಳಗಡೆ ಸೆಕೆಂಡ್ ಅಡ್ರೆಸ್ ಇದೆ.
ಅಲ್ಲ, second. Only then.
Process, first process, London.
Only paper publication in Mangalore.
Letter sheet,
ಆಮೇಲೆ ಮಂಗಳೂರು.
ಎಲ್ಲ process ಎಲ್ಲ UK ಗೆ.
UK ಕೊಡಿ. ಲೆಟರ್ ಬರ್ದಿದ್ರ UK ಕೊಂದು.
ಹೌದು, UK ಬರ್ದಿದೆ.
High Commission.
That we have exhausted. Then the last known address for us is Mangalore. We have taken, my lords.
But whenever she comes here,
Petition is one.
foreign cover. Handwriting ಅರ್ಥ ಆಗೋದಿಲ್ಲ. Yes.
Argument ಇರುತ್ತೆ. West. UK.
I do concede this position, my lord, as far as your lordship's question, if I understood properly, London is ಸರ್ವ್ ಆಗಿದ್ದ ಬಗ್ಗೆ ಏನು ಇಲ್ಲ.
ಮಂಗಳೂರು ಅಡ್ರೆಸ್ ತಗೊಂಡಿಲ್ಲ ಅಲ್ಲ.
ಲಂಡನ್ಗೆ ಅದು ಏನು ಹೈಕಮಿಷನ್ ಲಾಟರ್ ನೋಟಿಸ್
Regular process is
If
not
you have
taken to
taken the
Mangalore.
paper publication in London newspaper, it was acceptable.
ಆಗ ಹೇಳ್ತಿದ್ರು ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ, ಮಂಗಳೂರಲ್ಲಿ ಇದ್ದೆ ನಾನು.
No, no,
ಅಲ್ಲಿ ಇರ್ಲೇ ಇಲ್ಲ.
You said last known address. Last known address according to you. was-
ರೆಸಿಡೆನ್ಸಿಯಲ್ ಲೆಟರ್ಸ್ ಮಂಗಳೂರು ನಮ್ಮ ಪ್ರಕಾರ. ಅಲ್ಲಿದ್ದು
Residential address ಮಂಗಳೂರು ಇದ್ರೆ you would have taken first notice to ಮಂಗಳೂರು.
yes.
ಎರಡು ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸರ್ವ್ ಮಾಡುವಾಗ.
That we understand. ಎರಡು ಕೊಟ್ಟು ಎರಡು process ಹೋಗಿದ್ರೆ you can accept your argument.
Please,
ಮಂಗಳೂರು also and there also.
Yes, next.
please, I leave it at that on this point, my lords. I will not take it further, my lords. I understood what the honorable indicating, my lords. May I beg to take my lord to the second submission which I wish to canvass, my lords. As far as the maintainability of the appeal is concerned.
Maintainability of the.
Appeal is concerned. Now, my lord, technically speaking, appeal can be maintained any time by filing an application for condonation of delay, my lords, and the delay is also condoned. So, appeal is can be filed anytime, but kindly appreciate here is a case where after a judicial order is passed, he was entitled to contract a marriage. I rely upon section 15, my lord.
We are not questioning the validity of your
Please,
marriage.
Once this is the position, exact position, my lord. Now kindly appreciate whether by virtue of this powers of appeal, by setting aside the lower court's judgment, what happens to the second marriage, which is already valid under section 15? Can it be automatically annulled? What is the effect? Because now a third party or the second wife's interest has come into picture. I cannot be made a party here. I cannot be permitted to or made to contest this case. So the position is, I will simply put it like this, my lord. This has been examined by the Supreme Court, my lords. What happens to this? I will directly may come to my lords to save the precious time, my lords.
Yes.
To the what happens to such a judgment, my lords, where appeal marriage has already been performed. The Honorable Supreme Court has laid down, my lords, the appeal is not maintainable. I have filed an IA, my lord, on this point only.
Yes, we have seen that
Please.
citation.
ಹೌದು, ಅದರೊಳಗೆ Supreme Court says, my lord, and may I also submit, my lord, here is a question where the second marriage is by way of registered document, which is not disputed. There is a prosecution also. They admit it. May I beg
All
to-
these questions arise only after deciding this appeal.
ಇಲ್ಲ, ಇದ್ರೊಳಗೆ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿ Supreme Court said, my lord, appeal itself is not.
Whether this appeal was in this matter, which you are relying this Krishnaveni Rise case,
ಹೌದು.
whether the petition was allowed uncontested.
No, my lord,
It was.
I'll answer that question. There are two questions, my lords. I will answer that. I am thankful to that question, my lord. I was anticipating that question. Well, I have made my research on that question. This question has been answered by another coordinate bench, my lord. I will submit to the Honorable Court's kind consideration, my lords. May I first, my lord, place the Krishnaveni decision, my lords, 2020. Relevant paras beg to submit, my lords. Para 3, my lords. According to the appellant, period of, that's at ink page 8, my lords.
Yes.
Please. According to the appellant, period of limitation for filing the appeal against the decree of divorce passed on 28/6/2005, expired on 26/9/2005. No appeal was filed either by the appellant or by the said Arvind Chanji within the period of last year. In August, almost a year after expiry of the period of limitation, appellant filed an appeal against the said order on 26/8. Delay in filing the appeal was condoned by an order that so and so operation the decree does not appear to have been stayed. In the meanwhile, in 2006, had remarried Chipra Chanji. Appeal filed with the appellant against the decree of divorce was from the inception infructuous. I beg to stress on this sentence. Honorable Supreme Court points this, my lords, legal principle that from the inception it became infructuous. It was dismissed subsequently. Now, my lord.
There the appeal was dismissed as withdrawn. That is also there.
No, no, the
The
question
appeal
is, my
was,
lord,
however, formally dismissed as withdrawn.
please, formally, please, my lords. No, no, the question is, my lords, whether, my lord, what happens to the marriage then, my lords, which has been performed? There, what happened, my lords, in that case, in this Krishnaveni's case, my lords, after the second marriage, which was set aside, my lords, which was, second marriage was performed after the first marriage was dissolved. The second marriage was held to be, contended to be illegal. Contention was that, my lords. And because it was performed during the, when the appeal was pending, etc., was the contentions. May I beg to take my lords directly to para 22, my lords, where section 5, validity conditions for Hindu marriage, para 22, my lords. I will not read it, neither past. I beg to take my lords to ink page number 11, void marriage. That stands on a different footing. Section 15. 15 is applicable not to void or voidable marriage. It is applicable only to dissolution. Divorced persons when may marry again. When a marriage has been dissolved by a decree of divorce, and either there is no right of appeal against the decree, or if there is such a right of appeal, the time for appealing has expired without an appeal having been presented, or an appeal has been presented but has been dismissed, it shall be lawful for either party to the marriage to marry again. Then, my lord, based on this, the Honorable Supreme Court, my lords, in the next page, para 29, my lords.
28 also.
28, please. Section 15 clarifies that when a marriage has been dissolved by decree of divorce and there is no legal right of appeal against the decree, or if there is a rupture rate, the time of appealing has expired without an appeal having preferred, an appeal has been present, but the same has not been dismissed, it shall be law for either party to the marriage to marry again. Had it been the legislative intent that a marriage during the pendency of appeal should be declared void, section 11 would expressly have provided so. And then a quote Anurag Mittal next para, my lords. There may beg to take my lord to para 29 only. First para quoted, last words, my lords. Last, I am in agreement with the way you taken so and so. Last sentence of that para. Assuming that a marriage contract before it became lawful to do so was unlawful, and the words create a disability, it is not possible to infer a nullity or voidness. Then I beg to take my lord directly to the next para number 30. In Leela Gupta, so and so, quoted extracted portion 10. The interdict of law is that it shall not be lawful for a certain party to do a certain thing, which would mean that if that act is done, it would be unlawful. But whenever a statute prohibits a certain thing being done, thereby making it unlawful, without providing for consequence of the breach, it is not legitimate to say such a thing when done is void, because that would tantamount to saying that a very unlawful act is void. Last line, para 20, my lords, says that such marriages are not void. And therefore, para 33 is the ratio, my lords, at the bottom, para 33. As observed above, appeal was infructuous for all practical.
That was not a petition for divorce. There he had filed, claiming that this is a nullity, marriage is a nullity. That is not the question we are deciding here.
No, that's not the.
No, see the facts of the case, para 9. Respondent number 1, on the other hand, filed a suit in OP number so and so in Family Court Hyderabad for declaration of nullity of his marriage with the appellant.
It was contested, my lords.
My lord, what happened?
It was contested.
No,
She has not filed appeal within time, my lords. This is not the case.
May I submit, my lords? It was like
We are not deciding here the.
No, exactly the same
whether
question.
their
The
marriage
same ratio is applicable.
Valid or null,
No,
we are not deciding that.
my lords may have to decide whether the appeal is rendered infructuous at the inception itself for this reason. Kindly see what happened in this. I'm sorry, I'm not able to place the facts properly. Krishnaveni's case, my lords, facts are that the facts are at the para 3, my lords. What happened is he files a suit for nullity, stating that my marriage with so and so is nullity, and try to obtain a decree. on the ground that his marriage with the second wife is during the pendency of the appeal. Ground is that, my lords. During the pendency of the appeal, marriage has happened. Therefore, this marriage itself is invalid, because section 15 uses the term where appeal has been filed, my lord, he should wait till the appeal is over. He cannot marry and the appeal is already filed. So he tries to project this ground, my lords, on the ground that the marriage is invalid. Marriage is void because marriage is contracted during the pendency of the appeal. And he wants to avoid the liability of maintenance to the second wife.
So there it was a case of maintenance. It was said.
Maintenance in the maintenance to the second wife, my lords.
Also being the pending suit of respondent.
Yes.
For declaration of nullity, para 18 nullity of marriage between the appellant and respondent was allowed when order dated 19/12/2018, whereby respondent number 1 was directed to pay rupees 20,000 per month from the date of the application.
Yeah, exactly, my lord. Exactly. He wants to avoid it by saying that.
That order was challenged there.
Yes, my lords. On the ground, he also filed a suit, my lord, stating that my marriage should be declared as a nullity.
Now we are not deciding that marriage.
This
here now.
Honorable Supreme Court now considered, my lords, what happens to the appeal which is filed when he has already contracted the marriage after the appeal period? What happens? That is the ratio which I am placing before the Honorable Court, which is the ratio of the case, my lords. What happens to the appeal which is filed after the marriage?
Which appeal? Appeal against which order?
Appeal against the first marriage decree of divorce.
Where is that?
That may beg to take, my lord, from the first para with kind permission, my lord. First para itself. Leave granted. This appeal is against the judgment and decree of order dated 9/4/2019 passed by the High Court for the state of Telangana, dispensing the criminal division case number so and so, challenging the order dated -- passed by so and so, 125 CRPC. On the last sentence, on the purported ground that the marriage with the appellant respondent was a nullity. Now the Supreme Court is considering, my lord, what happens to the appeal which is filed later. May I beg to take matter para 2. On or about 11/9/1989, appellant married one Arvind Chenerjee in accordance with Hindu rights and customs. Marriage of the appellant with the so and so dissolved by a decree of divorce on 28/6/2005. Para 3. According to the appellant, period of limitation was over on so and so. No appeal has been filed, etc. Para 4. In August 2006, almost a year after expiry of the period of limitation, appellant filed an appeal against the order. Delay in filing the appeal was condoned. Operation of the decree does not appear to have been stayed. In the meanwhile, in 2006, when the appeal was pending, he remarried. Appeal filed by the appellant against the decree of divorce.
Yes.
Was from the inception infructuous. This is what Supreme Court answers. When appeal is filed after the marriage, the appeal itself is infructuous.
Only one observation.
No,
Any
you're-
law in laid down. what is there?
That's the law laid down with great respect, my lord. That's how it is being considered.
However, they are discussing the issue, points, facts they are discussing here.
And the appeal, the Supreme Court lays down that the appeal is filed when a remarriage happens. That's why they discuss on section 15, my lord.
It was infructuous for all practical purposes.
From the very
Because
inception.
This was for maintenance.
No, that the question was, my lords, whether the marriage is valid or invalid. No, but that's the principle in Leela Gupta and Anurag Mittal discussed in para 29 and 30. Those principles are quoted here. I have not extracted them because I have not produced those decisions because I felt, my lord, this decision summarizes the principle. In Anurag Mittal is the same position. ಹೌದು.
Appeal becomes infructuous in the hearing. She had remarried.
Para 33, according to me, my lords, is the ratio. And para 34 again, my lords. Because they discuss the provisions of law and say what should happen to the para 34. It could never have been the legislative intent. Now kindly see my position. If for any reason, if my lords are two, I'm sorry. If for any reason my lawyers were to entertain the appeal and allow this appeal, what should happen to my marriage? That's para 34, my lords. It could never have been.
Yes.
The legislative intent that a marriage validly contracted after the divorce and after the expiry of the period of limitation to file an appeal from the decree of divorce should be rendered void on the filing of a belated appeal. Now my position is this. My marriage, second marriage would now get cancelled if for any reason this appeal is allowed. Though belated appeal. Is it provided in the legislature? If the marriage with the appellant's ex-husband 2006 was a valid marriage in law, recognized that he had no living spouse, subsequent remarriage appellant could also not be void. We are in full agreement with the view we quote of Leela Gupta that the effect of the prohibition against one of the parties from contracting a second marriage for a certain period is not to nullify the divorce and continue the dissolved marriage as is the same as subsisting. So it's not to nullify the divorce. Divorce doesn't get nullified. Now whether that divorce can now be nullified by the second appeal, which is filed subsequently.
Says we are not in, we are in full agreement.
The position is this, my lord. If by virtue of section 15, I am entitled to marry after the appeal period is over. And the Honorable Supreme Court has gone to the extent of saying, my lords, even if there is a marriage during the pendency of the appeal, even if, that's not the position here. Once I marry after the
Correct, what is their point?
my marriage is lawful. Now, my lord,
Was
if,
called upon to examine whether the marriage is a nullity,
please.
not whether decree of divorce is a nullity.
Now, my lord, it's like this. Now, I was entitled to marry under section 15.
That court said that because the decree of divorce was in operation, they have married so null. Now, we are not called upon to decide that. We are called upon to decide whether this decree is sustainable, whether she was served.
That appeal itself, with great respect, that appeal itself is not maintainable, having been filed after the marriage. That cannot be. That's how the that is the position of law according to me, subject to what my lords lay down. The law is very clear. Otherwise, what happens is it leads.
That should be.
May I also, before my lords make any conclusion, may I also try to impress upon the honorable. This is not the first.
Should be with a due process of law.
Please.
To become, even assuming your, even accepting your reasons, this earlier divorce should be with a due process of law, without serving the notice, taking notice in some other country. It's not like that.
That question, my lords asked that question. I was also researching on that very recent decision of the Honorable Delhi High Court, my lords. This question has been considered again on this point, my lords. May I pass on with kind permission? Seema Devi. May I pass on the Seema Devi, my lords, recent decision on the same point. All the courts, other courts, my lords, it's subject to what my lords decide it matter, but all other courts who have relied upon this principle, my lords, to hold that such an appeal is not maintainable. May I beg to read this with kind permission?
Yes.
Para about the remarriage, my lords. The appeal was against the
judgment
2000. I'm sorry, the extra copy till 2023 SCC online, Delhi 2257. You also come here. Just name of 2257 Delhi.
Only she refused to accept the same employee. In that judgment, it is held that wife refused to accept the notice.
Oh, and the one argument was advanced, my lords, is fraudulent.
18 months she filed application under blind on 13 CPC.
May I beg to take my lord to
Yes.
para 29, I may read my lords 29 onwards. Another submission learned counsel to respond is that after 17 months of the ex parte decree, respondent has remarried. Now he has 2 children from second marriage, one age dash dashes. So specifically put to the appellant whether he admits second marriage of the respondent, to which replies evasive. She states the second marriage of the respondent is not a subject matter of the present appeal and is for the court to decide about the legal status of second marriage. Appeal did not, however, deny or dispute the fact of the respondent's second marriage. On the contrary, response to appeal of based on fact of second marriage. Legal status of the respondent's second marriage and its bearing, section 15. Divorced persons when may marry again. When a marriage has been dissolved by a decree of divorce and either there is no right of appeal against the decree, or if there is such a right, the time for appealing has expired without an appeal having been presented, or an appeal has been presented but has been dismissed, it shall be lawful for either party to the marriage to marry again. In terms of section 15, either party to the marriage is well within his or right to marry when the time for appealing filing an appeal has expired without an appeal having been preferred, or an appeal has been presented but the same has been dismissed. The bar or impediment to contract a second marriage operates during the pendency of the appeal. Only if an appeal is preferred within the period. In other words, provision enables parties to marry again only after the decree of divorce has become final. The provision section 15 of the Act has been subject matter of the recent decision of Supreme Court to Krishnaveni. In that case, the ex-husband of the appellant wife remarried as no appeal was filed within the period of limitation. Appeal was preferred by the appellant wife almost 1 year after the period of expiry of the period of limitation. In this factual backdrop, Supreme Court held that the bar of section 15 was not attracted. It was lawful for the ex-husband to remarry. Appeal was infructuous from the inception. The relevant extract of the judgment reads as under para 28. Section 15 clarifies that when a marriage has been dissolved by decree of divorce and there is no right of appeal against the decree, or if there is such a right of appeal, the time of appeal has expired without an appeal having been preferred. An appeal having been presented but the same has been dismissed. It shall be lawful for either party of the marriage to marry again. Had it been the legislative intent that a marriage during the pendency of an appeal which will be declared void, section 11 will be expressly provided for. As held by this court in Anurag Mittal versus so and so. Object of section 15 is to provide protection to the person who has filed an appeal against the decree of divorce of marriage. Ensure that the appeal is not frustrated. Protection afforded by section 15 is primarily to a person contesting the decree of divorce. As observed by so and so Anurag Mittal, I am in agreement with view taken by Nageshwar Rao, Justice, but it's necessary to state how the question before us has already been settled with the decision Leela Gupta. Even if the words of the proviso were found to be prohibitory in clear, modlu prohibitory to some, amendment it shall not be lawful, etc. This court held that the incapacity to marry imposed by the proviso did not lead to an inference of nullity. Wide para 9 and Leela Gupta. It's all the more difficult to infer nullity when there is no prohibition, when there are no negative words, but on the other hand, positive words like it shall be lawful. That's in the after amendment, my lord. Assuming that a marriage contract before it became lawful to do so was unlawful, and the words created disability, it's not possible to infer a nullity or wideness. Wide para number so and so. What is held in essence is that if a provision of law prescribes an incapacity to marry, yet the person marries while under that incapacity, marriage would not be void in the absence of an express provision that declares nullity. Where incapacity imposed by the statute, there is no difference between an incapacity imposed by negative language such as it shall not be lawful, or an incapacity imposed by positive language like it shall be lawful, in certain conditions in the absence of which it is impliedly unlawful. It would thus appear that the law is already settled by this court that the marriage contracting during a prescribed period will not be void, but it was contracted under an incapacity. Obviously, this would have no bearing on the other conditions of a valid marriage. Decision in Leela Gupta thus covers the present law. In any case, bar under section 15 is not at all attracted in the fact of the case where the appeal from the decree of divorce had been filed almost a year after expiry of the period of limitation for a filing. Section 15 permits a marriage after dissolution of the marriage if there is no right of appeal against the decree, or even if there is such a right of appeal, the time of appealing has expired without an appeal having been presented, or the appeal has been presented but has been dismissed. In this case, no appeal has been presented within the period of limitation.
No fraud
The
has been
bar, if
committed
any,
by the respondent. 35 million. Despite of this summons. In the subsequent, the written response has been to solemnize it. We have already observed that no fraud has been committed by the respondent. Summons for process. Oh, in your para 35 only it is held.
para 32.
In the circumstances, it was lawful for the respondent husband to solemnize another marriage. We have already observed that no fraud has been committed by the respondent. Summons was also served on the appellant.
Para 34 may I read, my lords?
Para 34 or the
It is
35
tried that the dissolution of marriage is complete once a decree is made. A decree of divorce breaks the marital tie, and the parties forfeit the state of the husband and wife in relation to each other. Each one becomes competent to contract another marriage as provided so and so. In law, the effect of ex parte decree of divorce is not different from a contested one. That's true even in any other decree, my lords.
Right.
Even section 15 of that does not make any distinction between a contested and an ex parte decree. Here is an ex parte decree.
Right. Read further.
Therefore, in case of an ex parte decree of divorce also, it shall be lawful for either party to the marriage to marry again. No appeal is filed against such decree within the period of limitation. This is the,
Right, right. Oh, the para
in the
35.
present case, now my lord, this is referring to the present case, there is no fraud, etc., etc. Even in the present case, my lords, there is no impersonation, there is no forgery.
Distinction there.
Please, my lord, I will read. In the
Application
present
number
case,
13, they try to make a distinction there. The
please, I beg to read,
Sir.
I beg to read, my lords. The application under Order 9 Rule 13 CPC was also filed after 17 months so and so the decree as against limitation period of 30 days and the date of the decree as provided in so and so, despite the appellant having been duly served with summons, in the circumstance it was lawful for the respondent husband to solemnize another marriage. We have already observed that no fraud has been committed by the respondent. Summons was also served the respondent. This being the position, the application under so and so, that is on merits Order 9 Rule 13 should be allowed or not. Now, my lord, I am on this point. I am very clear. Let me make.
Moreover, under Order 9 Rule 13, the scope is only whether she was served or not, she or he. They were
Please.
served or not. There she claimed that she was not served. The court held that she was duly served.
No, my lord, I beg
No
to.
fraud was played.
Yes. No, even if my lord, no, the question of fraud, my lord, you as far as the question of fraud is concerned, my lords, there is no allegations of fraud to the court. It is the court which orders for this publication being made. My lord, you may kindly see, fraud is something different. There is no allegations of fraud here. Only allegation is notice has not been taken. There is infraction of Order 5 Rule 20. At best, they can contend. But second marriage is admitted.
Yes.
Second marriage is not denied. Now, the right of the second wife has come into force. Once there is a second marriage, which is lawful under section 15, the right to challenge by way of appeal the first marriage is lost. There cannot be remedy. If such a remedy is made available, it would mean indirectly second marriage is set aside in the absence of second wife. I ask a question to myself, whether the second wife is a party here. No. Should she have any right or not? Certainly yes. Her right is now decided by virtue of this appeal. Para 635, I beg to submit is, of course, of the Honorable Division Bench of the Coordinate Bench, my lords. It was on the facts of that case. As my lord usually says, my lord, no two cases will be on facts exact, my lords. It's only the law. Law is clear. And this is how it is applied. It's not only this Honorable High Court of Delhi, my lords. Along with my petition, I have also produced other decisions also, how other high courts have applied it, even before Krishnaveni's case. Question here is only it was placed ex parte is the. May request the Honorable Court, my lords, to kindly see page number 23. I produced all the decisions, my lord, but one thing I wish to make it very clear to the Honorable Court, my lord. Section 15 is not applicable to annulment of marriage. It is applicable only to dissolution of marriage, my lord. Kindly see page 23 as to how other high courts have understood this and how they applied it, my lord. Page 27.
23/7/2000. Which para you are reading?
There, my lords, will relevant portion I beg to take my lord to the honorable court page, ink page number 32.
Your
That's
citation.
Punjab and Haryana High Court. Page 27, again, division bench.
Which were furnished earlier.
How the page 27, that's third edition, my lord.
32, yes.
Second edition, my lord, not applicable. It's applicable only to, not applicable to dissolution of marriage by annulment, not applicable. I am coming to third edition in that page 27.
Yes.
Page 27, there I directly take my lord to page 32, my lords,
Yes.
para 16.
Yes.
That's just one sentence prior to that. Allahabad High Court decision is discussed in para 15. Last line, my lords. Appeal of the wife was dismissed as infructuous. I will not read that. That's another High Court decision, my lords. Then para 16. Madras, it was held that the remarriage after the period of limitation had expired. The right conferred upon a spouse by virtue of section 15 of the Act cannot be defeated by condoning the delay when no sufficient cause is shown for the said purpose. The position of the present case is similar. The respondent has solemnized her.
That comes with a qualification. You are reading only, which is, that comes with, when no sufficient cause is.
I'm reading everything. When no sufficient cause is shown, that's how they discuss. I cannot change it. That's how the other high courts have understood, my lords.
How
My submission is,
delay was condoned.
my consistent submission is,
You
delay
are
is
not
condoned,
changing
but now on merits, when the appeal is taken up for on merits, my lords, my submission is, appeal is rendered infructuous at the inception itself. It cannot be taken on merits. It's liable to be dismissed as infructuous because of second marriage.
Now this is admitted, cannot be taken here for hearing on merits. Admit agi final hearing.
That's why I raised a preliminary objection regarding maintainability, my
Correct.
regarding maintainability.
Like admit agi final hearing bandide.
My lord, at this stage also, I am bringing to the kind notes, this one look at the position of law, my lords.
No, you argued that it cannot be taken up for final hearing because it has become.
Not on merits. It is rendered infructuous.
Yes.
I am putting the bar before the, how other, this I beg to submit, it's a bar which is now crystallized into a principle of law. 33, my lords.
Yes, 33.
Respondent having solemnized the marriage insofar as the appellant is concerned has become infructuous. Of course, each fact is different.
Yes.
And the recent decision of the Delhi High Court also. Of course, each fact's a little bit difference will be there, but I beg to submit the principle finally is, my lords, what happens to the second marriage? It's for this reason, my lords. Section 15 permitted me the second marriage. I cannot be punished because of the second marriage now. What cannot be punished there, they saw, can they?
How many times you have to, we are
Yeah,
not.
therefore, the appeal
We are
cannot
not
be.
here to consider your second marriage or its value.
Effect is the same. Once the honorable court allows the appeal, effect is the same.
There is law is also that fraud or nullifies everything.
There is no allegation of fraud in it. My lord, with great respect, no, this is not a case of fraud.
Para 13 and 14 of their grounds, they have made that.
No, my lord, service of notice, they themselves, my lord, there is a duty also to a person to say which is the address, show the proof to the honorable court. A person cannot file an appeal simply saying I was not here on that address. They are also duty bound to inform the honorable court about the addresses, my lords, about the address, proof of the address. The documents also they should produce to the honorable court. They can't take shelter and say, I will not be knowing the address. They should show the details when they were residing in that address and how they say now the Mangalore address is there. When they left the address, Mangalore address.
Your fiction, why you raise so
No, the truth is this. The truth is, my lord, they can't suppress the truth before the honorable court. Nobody can suppress the truth.
Please hear us. In your petition itself, you had given true address.
Yes, I've given the true address.
Right.
Yes, which is known to me, I've given the address.
After giving address, you took notice to the local address.
No, my lord. Now they themselves said she is residing the local address. When they discontinued it, now we have ownership. I beg to submit only this much.
2016.
They let them say, we cannot presume that they were not there.
You have.
No, my lord, 2022, they say they are in the same address.
You have produced the documents of 2016. In 2016, they said that they are residing here. They filed the petition for understanding.
No, we are presuming, with great respect, I beg to submit. They should say 2022, when they came there, they should also at least say now, before they let them produce the documents to the honorable court now, because
22 you produced what 2016 at 2016 alli you produced.
now I address ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. We have given the Mangalore address. Now the same Mangalore address they are there.
ಅವ್ರು ಕೊಟ್ಟಿರೋದು. ನಿಮ್ಮದ್ರಲ್ಲಿ you had given both the address.
ಹೌದು.
In.
Now they give only Mangalore address. They don't give that address at all. My lords, your lords may kindly appreciate. Otherwise, they had an opportunity and to go under Order 9 Rule 13, where evidence could be led, I can cross-examine. Now kindly see in the appeal court, they don't produce all the documents. I don't have the right of challenging their address, etc. Nothing I can challenge. Therefore, Order 9 Rule 13 was also an efficacious remedy. They don't do that.
May I submit minutes?
I
May I
think-
submit?
Please, please, please.
Minutes. Order 5, Rule 9 can be perused minutes.
Order 5.
Judgment ಕೊಡಿಸಿರಿ, ಓದಿರಲ್ಲ.
ಯಾವುದು? ಇದಾ?
Madam, the judgment which they have referred, Seema Devi appellant, that is 2023 SCC online Delhi to,
One second, you first want us
Ah,
to read order.
that is referred here, that's why my lords.
Nine.
Yes, my lords. Order 5, Rule 9. Delivery of summons by court. Else, I'll just read, where the defendant resides within the jurisdiction of the court in which the suit is instituted, or has an agent resident within that jurisdiction who is empowered to accept the service of the summons. The summons shall, unless the court otherwise directs, be directed or sent either to the proper signature, not verified digitally signed, my lords, officer to be served by him or on one of his subordinates, or to such courier service as are approved by the court. Now, my lords, let me kindly peruse the address that they are referring to, my lords. This is the address of her mother's house, my lords. Whenever she is here in India, when she goes there, my lords, she stays there. If at all, if that was the case, my lords, whether they have taken process to that particular address, they have not done it. Straight away, they have given process to UK. My lords, when they couldn't serve on our, my lords, they take the paper publication in Mangalore. But it's a fraud played on the court, not they have obtained the decree. Once they obtain a decree by playing a fraud, my lords, fraud vitiates everything, then the marriage itself will become void, my lords.
No, we are not deciding that. We
No, no.
said to him also,
Yes, my lords.
we have to decide whether this judgment and decree is sustainable.
My lords, yes, my lords. If the appeal is filed,
Only
let's,
in,
I'll submit.
our
All the
argument was
judgments,
that this appeal has become infructuous.
all the judgments, what my learned senior counsel has referred, my lords, in all those cases, my lords, the parties have contested. Let's contested decrees, my lords, that they have not filed appeal within time. But this is a case where this is an ex parte judgment decree, my lords. Notice was not served unto her. But if that being the case, if the arguments addressed by learned senior counsel is admitted, my lords, then my lords, there is no scope for appeal and Section 5 is not applicable at all to matrimonial cases. Let me kindly peruse, my lords, all the judgments what they have referred to here. But all those cases, my lords, there is a contested decrees are passed.
It is mentioned.
Yes, they have not filed appeals within time. That's why the court has held in that fashion. But this is the case where there is no service of notice. That's the court. They have played a fraud on the court and they have obtained a decree. Upon that decree, they have married. Fraud vitiates everything. There are a number of judgment lordships are well aware. Fraud vitiates everything. They have obtained a decree by fraud, my lords. But 2016, my lords, when she comes to know that he's living with other lady, but she comes here and she files a petition for PCR under Section 4 for 494, my lords. At that point of time, and she files one more petition for domestic
Now what
maintenance.
Yeah.
At that point of time, they come and produce this decree.
They have already argued.
Yes, my lords.
You are submitting that those petitions were dismissed. What happened thereafter? You check ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತಲ್ಲ ಯಾವ್ದು court website ಗಳಲ್ಲಿ.
We'll check it.
Petitions were dismissed. ಒಂದು 125 and DV Act case dismiss ಆಗಿತ್ತು ಅಂತ ಹೇಳ್ತಾರಲ್ಲ. Whether those are challenged or not challenged.
My lords, I'm not aware of that. The only difficulty, my lords, she may be, my lords, she's not in a position to come down to stay here in India because she's living there in a social security. She has no place to stay here. Maybe because of that, my lords, she might have not contested the cases properly there. There may be orders in that fashion.
Now in this case, no interim alimony was sought.
But
Because it is pending since.
my lords, there is an order of this honorable court, my lords, which I have yesterday, your lordships. There is an interim order passed by this honorable court directing them to pay 40,000, my lords, which they have not paid so far.
Mentioning. That is yesterday, ನಿನ್ನೆ ಹೇಳಿದ್ರಲ್ಲ. Appellant's counsel submits that respondent has not paid interim alimony of 40,000 awarded by this court on 15/6. You can execute ಅಂತ ನಾನು
Yes, ಹೌದು ಮಾಡಿದ್ರು.
already interim alimony is also there.
Yes, my lords. My lords, it is at the instance of the husband, my lords, insistence of the husband, but they were residing there. He also accompanied her and the daughter.
ಅದು ಗೊತ್ತು ಇನ್ನೊಂದು ಅವರು ಬಹಳ ಕೃಷ್ಣವೇಣಿ ಜಡ್ಜ್ಮೆಂಟ್ ಇಲ್ಲ ಆದ್ರಲ್ಲ ಅಲ್ಲಿ they have filed a petition for declaration of nullity of marriage. We are not deciding that. If you want to innocent ಅನ್ನೋದು ನಮಗೆಲ್ಲ ಏನು satisfied ಅಂತ it's a case of the information. ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ where she is residing ಅಲ್ಲ. He himself had given two address. One is ಅಲ್ಲಿ ಕೊಟ್ಮೇಲೆ ಅಲ್ಲಿ ತಗೋಬೇಕಿತ್ತಲ್ಲ ನೋಟಿಸ್ ಅಷ್ಟೇ ಆಗ್ತದೆ. I will take a notice to that address.
In 2016 only, I think so.
2016 she comes and files a
16.
16.
First to me, Miss.
2016, only 42 of 2016 and another one is 116 of 2016. Dismiss ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರು ಅವರು ಏನು ಡೇಟ್ ಆಫ್ ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ಕಾಪಿ ಎಲ್ಲಿದೆ ಒಂದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಒಂದು ಡಿವಿ ಇನ್ನೊಂದು 125 ಇದೆ
ಇನ್ನೊಂದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರು ನನಗೂ ಕಾಪಿ ಏನಿಲ್ಲ
ಆರ್ಡರ್ ಕಾಪಿ
ಇಲ್ಲ any of the now that they are also not
dictation now ಮಾಡು 40
Dictation.
just 19 ಎಷ್ಟು
because ಅಲ್ಲೇ ಆಯಾ ಜಡ್ಜ್ಮೆಂಟ್ಗಳೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ Why have you not paid that 40,000 rupees?
what to say that your lords may kindly see take judicial notice of the his situation also. It's a serious health problem also.
They will engage your services.
No, that's true. That's for my lord. The engage is true, my lords. It's also true that I have been defending them in Mangalore also, and we also take the social facts and their own inability to pay. Also, we take
You
note.
can't take judicial notice of that.
No, we have to. My lords, my lords, we do the lot of service freely also, my lords, and the situation where they his situation is that such, my lords.
Both side. ಈಗೇನು ಅದಕ್ಕೆ ಮತ್ತೆ date fix ಮಾಡಿ. ಆಯ್ತು ನಾಳೆ ಕೋರ್ಟಲ್ಲೇ ಮಾಡ್ತೀವಿ ನಾಳೆ ಬೇಡವಾ ನಾಳೆ ಕೋರ್ಟಲ್ಲಿ
Please.
My lords, she has filed an affidavit also. This is which is there before this honorable court, my lords, wherein she has produced all the documents to show that she is living on a social security. They are speaking about their inability to pay, my lord. I am just submitting her position.
ಆಯ್ತು ಫರ್ ಡಿಕ್ಟೇಷನ್ ಲಿಸ್ಟ್ ಮಾಡು
Please. Great, most great.
ಪ್ಲೀಸ್ ಫಾಸ್ಟ್ ಎಕ್ಸೆಪ್ಟ್ ಆಯ್ತು 442 ಆಯ್ತು ಅದು ಇದ್ದದ್ದು ಇನ್ನೊಂದು ಅದೇ 230 ಒಂದಿತ್ತು
Serial number 30, my lord.
1 second 30ಗಿಂತ ಮೊದಲ 230 ಅವ್ರು ಯಾರೋ ಅವಾಗಿಂದ ಕಾಯ್ತಿದ್ರಲ್ಲ ಹೋದ್ರ ಅವರು
230 ಮಾಟ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದ್ ನಾಳೆನೂ ಆಗತ್ತೆ ನಾಳೆ
Specific date maybe. And 230.
230 ರಲ್ಲಿ ಅವ್ರೇನೋ 230 ಅಂತ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರು ಅದು ಆಗೋದಿಲ್ಲ ನಿಮ್ದು 2021 ನೋಡ್ತೀರಾ ಓಲ್ಡ್ ಕೇಸಸ್ ಇದೆ not be taken up with the paucity of time. List on 27.
Much up.
230 ಬೇಡ ಅದು ನೋಡಿ ಇಲ್ಲಿದ್ರೆ ಬರ್ತಿತ್ತು ಅಲ್ಲಿದ್ರೆ ಅದು ಬರೋದಿಲ್ಲ.
Pastor matter 10.7. 10.7 Unikrishnanyam.
Yes, my lord. Wait.
Careful is done.
10.7 to furnish copies.
Yes, my lord.
ಅಲ್ಲ ಇರ್ಲಿ ಅದು ಇವತ್ತು ಕೊಟ್ರಲ್ಲ ನಾವು we can ಕೇಸ್ ಕೊಟ್ಟಿದಾರಲ್ಲ submitted the PF is paid today. That was the order dated 29/5/2024. Dismissal of the matter is hereby record. Issue notice to
R1
R1.
Yes.
And the date ಕೊಟ್ಟಿದ್ವಿ ಬೇರೆ ಕೇಸ್
29/7.
It's not 29/7. All
Read
right.
to me.
Yes.
Lordships kindly, serial number 30, my lord. I appear for
30?
the respondent,
30.
30, final hearing matter.
Huh.
Matter may be taken up, my lord, on Tuesday. Because tomorrow, day after, and Friday, I've got parted matters.
I mean, the convenience of the court, whatever date, because this matter was argued at length before the previous bench, my lord. And then my lord will see the order sheet. There was no response from the other side at all. They didn't even participate in the proceedings. So I'm a little surprised that he wants to date next week.
No participation in the sense,
7.
that day I was not keeping well, and the
No,
next
that's okay.
day, what happened was I was held up in the other court. Thereafter, this on.
Any date which the court feels fit,
Every time that cannot happen alva.
Correct.
any date which is convenient to the court.
ಎಷ್ಟು 27. Right. Rest of the matters.
Obliged.
Anybody want any specific dates?
32, my lord, serial number.
Huh?
32.
444, 32. Huh?
I appear for the respondent. Only with regard to my lord's permanent alimony, my lords, the matter has to be decided.
Correct. Who represents Sana Vakunt? ಯಾರಿದಾರ ಕಡೆಯವ್ರು ಯಾರ ಇಲ್ಲ
Colleague was. Next
ನಾಳೆ
week,
ರಿಪೀಟ್ ಮಾಡ್ತೀವಿ ಬಿಡಿ
ಅಲ್ಲ Tuesday, ನಾಳೆದಲ್ಲಿ ಸಂಪರ್ಕ Tuesday.
32 ಹಾ ಹಾ ಎನಿ ಡೇಟ್ ಓಕೆ ಹಂಗಂದ್ರೆ ಮುಂದಿನ ವಾರ ಹಾಕೊಳ್ಳಿ 27
33,
Great.
33 ಮೇಡಮ್.
ಹಾ 33
ಜೂನ್ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಏನೋ ಮಾತಾಡಿದ್ರು 33 ಮೇಡಮ್.
ನಾವೆಲ್ಲ ಈ 2017 ಮೆಟ್ಲ ಅವ್ರು ಪ್ರೆಸೆಂಟೆಡ್ ನೋಡೋಣ
ಇಬ್ರು
ಸೆಟ್ಲ್ ಮಾಡ್ತಿದ್ರೆ ಸಂತೋಷ ಆದ್ರೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲಿದ್ದಾರೆ ಇಬ್ರು ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ
ಅವ್ರ ಮೇಂಟೆನೆನ್ಸ್ ಇದೆ, ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡೋದು
ಅರಿಯರ್ಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಸರ್. more than 7 lakhs ಇದೆ ಅಲ್ಲಿ. ಅದನ್ನಾದ್ರೂ ಕ್ಲಿಯರ್ ಮಾಡಪ್ಪ, ಕ್ಲಿಯರ್ ಮಾಡೋಣ ಅಂತಂದ್ರೆ ಅವರು
ಅಲ್ಲ ಏನದು ಡಿಸೊಲ್ಯೂಷನ್ ಬೈ ಮ್ಯೂಚುವಲ್ ಕನ್ಸೆಂಟ್ ಆರ್ ರಿಯೂನಿಯನ್
ಇಲ್ಲ ರಿಯೂನಿಯನ್ ಆಗ್ತಲ್ಲ ಸ್ವಾಮಿ, ಇನ್ನೊಂದು ಮದುವೆ ಮಾಡ್ಕೊಂಡಿದಾರಲ್ಲ.
ಮ್ಯೂಚುವಲ್
you represent the appellant.
I am for respondent.
ಎಷ್ಟು 33
33.
so the petition was dismissed.
Yes, go ahead for your.
ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಹೆಂಗ್ ಎರಡನೇ ಮದುವೆ ಮಾಡ್ಕೊಂತಾರೆ
ಅವ್ರು ಹೇಳ್ತಾರೆ ಮೂರನೇ
ಅಲ್ಲ
ಅಂತ ಹೇಳ್ತಾರೆ.
see first marriage has been divorced. I am for the respondent second wife, second marriage. See without divorce ಮೂರನೇ ಮದುವೆ
ಕರೆಕ್ಟ್ ಈಗ ಏನ್ ಸೆಟಲ್ಮೆಂಟ್
ಇಷ್ಟು ಅಮೌಂಟ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಇವ್ರು 4 lakhs
ಸ್ವಾಮಿ ಅವರೇ ಡೇಟ್ ತಗೊಳ್ತಾ ಇದಾರೆ.
ಕೊಟ್ರೆ ಅದು
ಹೇಳಿದ್ದೀನಿ.
ಸೆಟಲ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಇಲ್ಲಾಂದ್ರೆ ಯು ಹ್ಯಾವ್ ಟು ಕಂಡಕ್ಟ್ ದ ಕೇಸ್.
ಈ ಸರಿ ಆಗ್ಲಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಮ್ಯಾಮ್.
ಎಷ್ಟು ದಿವಸ ಬೇಕು? ಈಗ 2017 7 ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್
ಬಂದಿಲ್ಲ ಸರ್,
ಬಂದಿಲ್ಲ.
ಬಾವುಲಿನ ಮಾತಾಡೋ ಸರ್ ಒಂದು ಡೇಟ್ ಅಲ್ಲಿ
ಅವ್ರ ಹತ್ರ ಮಾತಾಡ್ಬೇಕಲ್ಲ, ನೀವು ಬರೀ ನೀವು ಮಾತಾಡ್ಕೊಂಡ್ರೆ ಮಾತಾಡಿದ್ರೆ ದಿಸ್ ಇಸ್ ಫ್ರಮ್ ವಿಚ್ ಪ್ಲೇಸ್? ಯಾವ ಊರಿಂದ ಬಂದಿರೋ ಕೇಸ್? ಕೋಲಾರ ಡಿಸ್ಟ್ರಿಕ್ಟ್. ಏನು ಬೇರೆ ದೇಶದಲ್ಲ, ಇಲ್ಲೇ ಇದೆ. ಬಂದ್ರೆ ಮಾತಾಡಿ ಕೇಳ್ಬೋದಲ್ಲ. ಬೋತ್ ಪಾರ್ಟೀಸ್ ಆರ್ ಪ್ರೆಸೆಂಟ್. ಯಾರು ಈಗ ಯು ವಾಂಟ್ ಟು ಟೇಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಫಾರ್ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ ಸೆಟಲ್ಮೆಂಟ್? ನಾವು ಅದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡ್ತೀವಿ.
ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಅಂತ ಹೇಳಿದಾರೆ.
ಅವ್ರು ಎಷ್ಟು ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತಾರೆ?
20 ಕೇಳಿದ್ರೆ ಸುಮ್ಮನೆ 15 ಬಂದಿದೆ.
ಮಕ್ಕಳಿದಾರಾ?
ಇವರಿಗಿಲ್ಲ ಸರ್, ಮಕ್ಕಳಿಲ್ಲ.
ಮಕ್ಕಳಿಲ್ಲ. ವಾಟ್ ಹಿ ಇಸ್ ಡೂಯಿಂಗ್? ಇದು ಮಾಡ್ಕೊಳ್ಳೋ ಮದ್ವೆ ಮಾಡ್ಕೊಳ್ಳುವಾಗ ಅವರು ರಾಯಲ್ ಫ್ಯಾಮಿಲಿ ಅವರು ಇರ್ತಾರೆ. ಈಗ ಮೇಂಟೆನೆನ್ಸ್ ಬಂದ ತಕ್ಷಣ ಪಾಪರ್ ಆಗ್ತಾರೆ. ಕರೆಕ್ಟ್. ಏನ್ ಇಬ್ಬಿಬ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ? ಕರೆಕ್ಟ್. ವಿ ಕ್ಯಾನ್ ಒಬ್ಬರಿಗೆ ಕೊಟ್ಟಿರ್ತಾನೆ, ಇಬ್ಬರಿಗೆ ಅಲ್ವಲ್ಲ. ಫೈನಾನ್ಸ್ ಕೊಟ್ರೆ ಇಬ್ಬರನ್ನ ಪರ್ಮಿಟ್ ಮಾಡ್ತೀವಿ. ರೈಟ್. ಇಫ್ ಬೋತ್ ಆಫ್ us you are arguing appearing, one of you should argue.
ಅಲ್ಲ ಅವ್ರನ್ನ ಸೇರ್ಸ್ಕೊಂಡ್ಬಿಡಿ, 3 ಜನ ಆಗ್ತೀರಾ ಸಾಕು ಬಿಡಿ.
ಅಲ್ಲಲ್ಲ
445 ಏನ್ ಕಥೆ ಹೇಳ್ತೀರಾ ಇದೆಲ್ಲ?
ನೋಡಿ ಏನು
ಆಫರ್ ಹೇಳಿದ್ರಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್
ಆಯ್ತು, ಅವ್ರು 15 lakhs ಹೇಳಿದ್ರು, ನಿಮ್ಮವ್ರು ಎಷ್ಟು ಕ್ರೆಡಿಟ್ ಇದ್ದಾರೆ?
4 lakhs ಹೇಳ್ತಾರೆ ಸರ್. 4
ಮತ್ತೆ ಇದು ಆಗೋದಿಲ್ಲ. ಕೇಸ್ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ
ಮಾತಾಡಿ
ಮಿಸ್ಟರ್ ಕೌನ್ಸಿಲ್ ಮಾಡೋದಿಲ್ಲ. ನೀವು ಬೇಕಂದ್ರೆ ಬೇರೆ ಮೇಂಟೆನೆನ್ಸ್ ಏನೋ ಹಾಕೊಳ್ಳಿ, ಇದು ಆಗೋದಿಲ್ಲ. ಅವ್ರು ಮಾಡೋದಿಲ್ಲ ಇದನ್ನ. ಹಾಗೆ ಒಂದು ಅಡ್ಜಸ್ಟ್
10 years ಆಗಿದೆ.
ಅದಕ್ಕೆ ಕೇಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿ ಅವ್ರು ಮೆರಿಟ್ಸ್ ಮೇಲೆ. My
lord,
both parties, counsel are present. It is submitted that respondent is agreeable for mutual consent trials provided the appellant pays her permanent alimony of 15 lakhs, whereas the appellant offers only ₹4 lakhs. In view of this long gap, the court is satisfied that there is no possibility of settlement. Appellant's counsel shall argue the matter list on Nade. Tomorrow.
My lord,
Day after tomorrow.
Serial number 36.
Either you settle the matter.
ಆಯ್ತು sir.
ಸುಮ್ನೆ ಸೆಟಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಳ್ಳೋದಲ್ಲ.
ಇಲ್ಲ ಅವರಿಗೆ ಹೇಳಿದೆ ಸುಮ್ಮನೆ.
That serial number 36.
My lord, my lord, serial number.
Serial number 36.
July.
ಮತ್ತೆ
Second July.
ಯಾವ ಬೇಕು?
ಸ್ವಲ್ಪ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ.
ಅಲ್ಲ
Actually,
ಯಾವ
second July.
ಸೆಕೆಂಡ್ ಜುಲೈ ಅಂದ್ರೆ ಯಾವ ವೀಕಲ್ ಬರುತ್ತೆ? ಜುಲೈ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲೇ ಬರುತ್ತೆ ತಾನೆ?
36 ಮಾಡಿ next week any date ಮಾಡಿ.
ಹಾ?
36.
ಎಲ್ಲವನ್ನು ರಿಪೀಟ್ ಮಾಡ್ತೀವಿ ನಾವು ಆಫ್ಟರ್ 449.
My lord, serial number 25, my lord. Serial number 25, for appellant, my lord. I filed a memo seeking education expenses of children, my lord. And the respondent has to pay, my lord. Serial number 42, my lord.
42.
My lords, an application has to be filed. The memo that has been filed.
We'll see.
My lord, this honorable court has already passed an order on the same issue, my lord. The receipts were produced.
Now the matter is listed for final hearing. We'll
My
hear
lord.
all the aspects together.
Education expenses, my lord. This honorable
Correct,
court
we'll
has
hear
already
that.
directed the
Now the list
respondent.
ಮಾಡಿ ನಾಳೆ tomorrow next
My lords,
tomorrow.
my lords, may
Please,
make
my
one
lord.
submission on this matter. The same issue has been raised before the
Correct,
trial court.
tomorrow we'll
Please,
hear.
my lord.
My lords, those
And
matters
very
are
soon.
awaiting judgment. My lords, its final arguments were completed today. The very same claims have been made in the maintenance petition and the
No,
deed
my lord.
petition with
No, my
different
lord.
amounts, in
Now
fact,
it
my
is
lords.
450.
Please,
The
my
matter
My lord,
is
it may be
listed for final hearing as well as hearing on these applications and memos. We'll
Tomorrow,
hear
my
both of it
Please, my
tomorrow. All
My lords,
Please,
my
my lord.
perjury application may also be put up in that case, my lords. It's not put up, my lords.
Serial number 36.
ಇದೆಲ್ಲ
The connected
listed.
matter, my lord, is not listed today. So
Yes,
this.
there is one more matter.
Yes, my lord. There are two matters
No,
that are
by the- They
connected.
were connected by the order of the court, or you say they are connected?
No, my lord, it was connected by the
How
order of the
connected?
court.
1178. How is that?
1178 and 738.
It's posted today.
It is always posted together, my lord, but today it is not.
Today, it's listed today, in fact.
ಎರಡು ಎಲ್ಲಿ ಇದೆ ಅಲ್ಲ 1178 ಅಂತ ಅಲ್ಲಿದೆ ಅಲ್ಲ ಕೆಳಗಡೆ.
1178 ಇದೆಯಲ್ಲ.
Sorry, my lord, I have.
Serial number 35.
ಬರೀ
Melody in-
mention ಮಾಡ್ಕೊಂಡು ಹೇಳಿದ್ದೆ ಹೇಳ್ತಾರೆ. Yes.
Serial number 35, my lord.
Serial number.
Full fees.
I appear for the respondent. I pray your lordship to pose the matter next week, man.
Creative dresses. ನರಸಿಂಹಸ್ವಾಮಿ ಅವರು ಇಲ್ವಾ?
He has been informed.
ಯಾವಾಗ when do you want it?
Next week, any date, man.
As requested, list in the next week.
Please.
Lord, serial number 36 malad, next week any date malad.
36. ನೀವ್ ಯಾವಾಗ್ಲೂ ಇರೋದೇ ಇಲ್ಲ ಅಂತ
ಇಲ್ಲ,
ನಾನು
ಇಲ್ಲ.
ಹೇಳಿದ್ದು 2017 ಕೊಡೋದಿಲ್ಲ ಅಂತ. ಒಬ್ಬೊಬ್ರು ಇಷ್ಟಿಷ್ಟು ಹೊತ್ತು ಒಂದು ಎಕ್ಸ್ಪರ್ಟ್
ಅಲ್ಲ ಸ್ವಾಮಿ next week ಅಲ್ಲ next week any date ಕೊಡಿ ಸ್ವಾಮಿ.
ರಾಜು ಅವ್ರೆ ನಾವ್ ನೋಡ್ತಾ ಇರ್ತೀವಿ ನೀವ್ ಯಾವಾಗೂ ಇರೋದೇ ಇಲ್ಲ ನಮ್ ಕೋರ್ಟಲ್ಲಿ. ನಾವು ನೋಡಿದ್ವು ಎಷ್ಟ್ ಸರಿ ಬಂದಿಲ್ಲ, ಎಷ್ಟ್ ಸರಿ ಅಬ್ಸೆಂಟ್ ಇದ್ದಾರೆ. ನಿನ್ನೆ ಯಾವಾಗ ಇಷ್ಟೊತ್ತನ ಇದ್ರು ಈಗ ಎದ್ದೋದ್ರು ಅಂತ ಹೇಳಿದ್ರು. ಟುಮಾರೋ ಎಸ್
Serial number 34, man.
ಎಲ್ಲ ಅಷ್ಟೇ ವಿಲ್ ರಿಪೀಟ್ ಆಲ್ ದೋಸ್ ಥಿಂಗ್ಸ್ ವೆರಿ.
ಶಶಿ 2017 put up ಮಾಡಕ್ಕೆ ಮೇಡಮ್ ಇದು 10.7 ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ಅದೇ ಪಿ ಎಫ್ ಪೇಡ್ ಆರ್ಡರ್ ರಿಕಾರ್ಡ್ ಇದು ಈ ಫೈಲ್ ನ ಕೇಸ್ ಆರ್ ಕೊಟ್ಬಿಡಿ ಆರ್ಡರ್ ಆಗಿದೆ ಅವ್ರಿಗೆ, ಯಾಕಂದ್ರೆ ಮುಂಚೆ ಇದಾಗಿದ್ದು.
Dismissal of the matter is hereby recalled.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ
ಹಾ ಅಷ್ಟು
ಲಿಸ್ಟ್ ಮತ್ತೆ ಕಂಟಿನ್ಯೂ ಆಗ್ತದಾ?
ಕಂಟಿನ್ಯೂ ಅಲ್ಲಿ ಸರ್ ರೀಚ್ ಆಗ್ದಿದ್ದು ನಾಳೆ ರಿಪೀಟ್.
ನಾಳೆ ರಿಪೀಟಾ?
840 4840.
ಅದು ಕಂಟಿನ್ಯೂಸ್ ಬರ್ತಾ ಇದೆ, ಅದಕ್ಕೆ ಹೇಳಿದೆ ನಿಮ್ಗೆ 43 ಸೀರಿಯಲ್ ನಂಬರ್. ಇದು ನಾಳೆ ಮತ್ತೆ ರಿಪೀಟಾ?
ನಾಳೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಸರ್.
ಸರಿ ಸರ್.
ಸೆಕೆಂಡ್ ಅಲ್ಲ ಮೇಡಮ್.
ಹಾ
ಅವಳು ಸಂಗೀತಕ್ಕೆ ಬರಕ್ ಹೇಳ್ಬಿಟ್ಟು 841 ಮಾಡಿ ಪರ್ಸನಲ್ ಬರೋದಕ್ಕೆ ಹೇಳಿ ಬೇಗ ಬಂದು ಪಿಕಪ್ ಮಾಡ್ಬೇಕಂತ. ಮೇಡಮ್ ಇದು KSR ಅಂತ ಹಾಕಿರ್ತೀನಿ, ಅವಾಗ ನಿಮ್ಗೆ ಜ್ಞಾಪಕ ಬರುತ್ತೆ. ಇಬ್ರದ್ದು ಇದೆ ಕಣಪ್ಪ. ಯಾವ್ದು R ಅಂತ ಬರ್ದಿರ್ತೀನಿ ನೋಡು. ಇದು 27 32
ಅಭಿಷೇಕ್ ಇದೆಯಾ? ಬಂದಿದ್ದೀರಾ? ಬನ್ನಿ, ಇಲ್ಲಿ ಎಲ್ಲಿದ್ದೀರಾ?
ಹೇಳಿ.
ಸ್ಟೂಡೆಂಟ್ ವಿಶ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಂತ ಬಂದ್ಬಿಟ್ಟು ಚೇಂಬರ್ ಅಲ್ಲಿ